Good morning. Welcome to the Occupational Safety and Health Administration's informal rulemaking hearing for heat injury and illness prevention in outdoor and indoor work settings. My name is Drew Roberts, contractor to OSHA. Before we begin, we'd like to go over some logistics for today's public hearing. As a reminder, all attendees are muted automatically. All WebEx attendees can access closed captioning and translated captioning by clicking the CC icon in the lower left-hand corner of the application. You can individually select your caption language if translation is required. We'll pause shortly as I share the same slide in Spanish. All YouTube viewers will have access to auto translation the day after the hearing. All WebEx attendees delivering testimony will have access to a countdown timer to ensure allotted time is adhered to. We will launch the timer for you, and it should be seen on the right hand of your screen. If you do not see this app launched in your WebEx window at the time given, please follow the instructions on the screen to manually launch this app. If you are speaking today, you will receive a notification on your screen that you're being promoted to the panelist group a few minutes before it is time to provide testimony. Once promoted to the panelist role, you will be able to unmute and turn on your camera. We ask that you do not unmute or turn on your camera until your name has been called and you have been asked to start your testimony. Speakers connected by telephone should unmute their phones when called to testify. If you submitted a presentation in advance, we will share the file and advance the slides. Please cue us verbally by saying next slide when you need us to advance. Dependent on timing, there may be the opportunity to ask questions of other speakers giving testimony. You may press the raise hand button at the bottom of the WebEx application to indicate that you have a question. If there is time, you will be called on by name and promoted to the panelist group to unmute and ask your question. If you have any technical difficulties, please send an email with your name and phone number to public_hearing@abtassoc.com. I will now hand it over to Judge Boucher to provide opening statements and go over administrative matters. Your Honor.
Good morning, everyone. We are now on the record. The hearing will come to order. This is an informal public hearing on the Occupational Safety and Health Administration's proposed rule for heat illness and injury prevention in outdoor and indoor work settings. The notice of proposed rulemaking was published to the Federal Register on August 30, 2024, in volume 89 of the Federal Register, beginning at 70698. I am Lauren Boucher, Administrative Law Judge for the U.S. Department of Labor, and I will be presiding over the hearing today. The purpose of this hearing is to receive from interested parties oral testimony as well as other information pertinent to the proposed rule. After this hearing and the post-hearing comment period have closed, OSHA will review the entire record in determining the content of the final rule. My role as presiding judge will be limited to conducting this hearing to assure that a complete and accurate record is made and that all interested parties receive a fair hearing and have an opportunity to submit their information. The hearing schedule and OSHA's procedures governing this hearing are available on the website for this hearing at www.osha.gov/heat-exposure/rulemaking. These documents were sent to people and organizations who filed a timely notice of intention to appear at this hearing. A few words here about the nature of this hearing. Despite the informal nature of the hearing, it is governed by rules, both OSHA's rules governing hearings at 29 CFR Part 1911 and the hearing procedures issued specific to this rulemaking. These rules are meant to assure that everyone has a fair opportunity to speak and express an opinion about the proposed rule. To that end, they also allow me to hold witnesses to their allotted times, limit undue repetition or excessive argument, and generally keep the hearing on schedule. Any written comments you have submitted to the docket are already part of the record of this rulemaking. In the rare case where witnesses wish to provide any other documents that have not already been entered into the docket, they should provide them by email to OSHA-events_DSG@DOL.gov. That's capital O, capital S, capital H, capital A, capital E, lowercase VENTS _ capital D, capital S, capital G @DOL.gov. before the witness begins their testimony so that they can be entered as exhibits in the record. Because all pre-submitted documents are already part of the record, your oral testimony should concentrate on presenting the highlights of your written comments or clarifying your written submission. Hearing participants may also submit additional evidence or statements for a period of 90 days from the end of the hearing, which will be September 30, 2025. At that point, the record for this rulemaking will close. Today, after each speaker or panel of speakers completes giving oral testimony, OSHA representatives will have an opportunity to ask questions of the speaker or the panel. When OSHA has finished asking questions, there will be an opportunity, as time permits, for persons who filed a timely notice of intention to appear to question the witness or panel. Participants may only direct questions to witnesses with whom they have no organizational affiliation. This is the process I intend to follow. After OSHA has finished asking questions of a witness or panel, I will ask participants who wish to ask questions of the witness to identify themselves by pressing the raise hand button in WebEx or by pressing *3 on their phones for those who have called in. Based on the hearing schedule and the number of participants who wish to ask questions, I will determine the order in which participants will question the particular witness or panel and any time restrictions on that questioning. If there are more questions than we have time for today, it may be possible to ask additional questions after the conclusion of the final witness's testimony.
You hear me?
Further, if witnesses are unavailable to answer a question during today's hearing or would like to expand on the answers provided, they are welcome to use the post-hearing comment period to submit such information. I would also like to remind you that this proceeding is being recorded and transcribed by a court reporter. To ensure that the reporter is able to provide an accurate record of all the testimony, questions, and responses, please try to remember to provide verbal responses to all questions. The court reporter may have a hard time seeing if you only nod or shake your head in response to a question. In addition, please remember to identify yourself before beginning your testimony and before asking or answering a question. And do not worry, I know many participants are not accustomed to doing these things. I will remind you as we go along. I would also ask that you mute your microphones if you are not actively testifying or asking questions, so that we can keep the record clear for the court reporter. The transcript of the hearing will be uploaded to the hearing docket on regulations.gov approximately 2 weeks following the hearing. Unless there are any further announcements or other housekeeping matters, I believe we can proceed with public testimony. The expected speaking order is currently displayed on the screen. Our contractor will introduce each speaker in turn and promote them to be panelists. When you are called to testify, please state your name and affiliation for the record and speak slowly and clearly so our court reporter can record these proceedings accurately. Mr. Roberts.
Your Honor, our first speaker will be David Michaels. David, please state your name and affiliation for the record.
My name is David Michaels. First, I'd like to thank the staff of OSHA, the Office of the Solicitor, and Judge Boucher for holding this hearing. My affiliation, I'm an epidemiologist and professor of environmental and occupational health at the George Washington University Milken Institute School of Public Health. From 2009 until January 2017, I served as Assistant Secretary of Labor for OSHA, the longest serving administrator in OSHA's history. From 1998 to 2001, I was Assistant Secretary of Energy for Environment, Safety, and Health, charged with protecting the workers, community residents, and environment in and around the nation's nuclear weapons facilities. I'm here to report and to ensure the record contains some of what I witnessed and what I learned in the years I ran OSHA. The OSHA Act is very clear. Employers have the legal responsibility to provide workers with a workplace free of recognized serious hazards. With that law, Congress created OSHA to enforce, to make sure that they are not killed or injured or made sick because of their work. OSHA's most powerful tool is the standard. Most employers want to follow the law. They make efforts to comply with OSHA standards. The fact that OSHA has no heat exposure standard has meant that many employers make little or no effort to protect workers from dangerous exposures. They don't have an effective rule book to follow. As a result, many workers have been sickened and some killed by extreme heat. Over the past 2 weeks of hearings, we've heard some of the representatives of employers say that a voluntary standard is all that's needed, that with training and better guidance, employers will ensure workers will be protected from extreme heat. That's fantasy. Yes, many employers will voluntarily do the right thing, but history shows that many will not. The OSHA law was written to protect all workers. So there's an important OSHA experience I'd like to recount here. In April 2010, while I was head of OSHA, the Deepwater Horizon rig exploded and oil began hemorrhaging into the ocean. That summer, more than 40,000 workers wearing chemical-resistant suits hard hats, and impermeable gloves and boots cleaned up the oil in the shadeless heat of the Gulf Coast states of Louisiana, Mississippi, Texas, Alabama, and Florida. The Department of Labor strongly encouraged BP to hire local residents, especially ones who were not working because the oil spill had severely impacted the hospitality and fishing industries. The cleanup teams include acclimatized and non-acclimatized workers, as well as some workers who were overweight or who had pre-existing lung and heart problems, which can increase the risk of heat illness. This is common in many workplaces. Employers must protect all workers, no matter their age or physical condition, from extreme heat. Even before the oil reached the shoreline, OSHA knew the temperatures on the unshaded beaches would often exceed 90 degrees, and the cleanup workers would need to do their jobs wearing PPE, including Tyvek suits, hard hats, impermeable gloves, and steel-tipped boots. To ensure their safety, OSHA requested that BP and its contractors follow the work-rest regime that the military used to protect healthy young soldiers from heat exposure in Iraq and Afghanistan. BP accepted and implemented these guidelines voluntarily, no doubt eager to avoid more deaths beyond the 11 workers killed by the explosion and the terrible public condemnation they would receive if more workers were killed. The guidelines were far more protective and costly than the ones in the proposed OSHA standard. That summer on those beaches, it was very hot. Most workers were given a rest break every hour for which they could rehydrate in the shade of a tent. It was controversial. I took phone calls from high-level elected officials who visited the beaches, saw workers resting and rehydrating in shade. Clearly angry, they asked me, why weren't we making those workers work harder? I had to explain we're trying our best not to kill them. This strategy didn't make the news because it was so successful. Not a single worker was killed by heat. Following that success, OSHA mounted a national campaign promoting water, rest, and shade, asking employers to voluntarily embrace that approach. Many employers did, but as we learned from that experience, many did not. Heat deaths and heat illnesses still continued. This is a clear lesson. Voluntary programs are not adequate. The OSHA law says all workers must be protected, not just ones employed by the sorts of employers who have testified at this hearing, who have assured the agency they already have successful programs in place. Those employers who are already doing the right thing, who are ensuring their workers are adequately protected, will benefit from an OSHA standard, since they will no longer be at a financial disadvantage competing with low-road employers whose workers are endangered by heat exposure. There are a few other points I've heard I'd like to respond to. Over and over again, when I was running OSHA, I heard employers say, please just tell me exactly what I need to do to protect my workers and I'll do it. In contrast, we have all heard numerous employer representatives say that if there must be a standard, they would like a performance standard, not a programmatic one, and that shouldn't be burdensome. But real performance standards, ones that don't have any programmatic requirements, are in fact far more burdensome. They require employers to determine how they need to respond to different situations and to keep extensive records showing they have met and evaluated those requirements. Under a performance standard, every employer will have to do the job of a meteorologist, a physician, and an industrial hygienist to determine what they need to do in each situation. This is difficult for large businesses and impossible for small ones. Several state programs have programmatic standards that are flexible, similar to the one OSHA has proposed. I have yet to see evidence that demonstrates that the California or any other state heat standard is overly burdensome to employers. In these hearings, several business representatives testified that the general duty clause is an effective tool to protect workers from heat. This is simply not true. In cases of heat exposure, with very rare exceptions, it is only invoked when the worker has been killed or made very sick, meaning it is reactive, not preventive. There is no evidence that it influences employer precautionary actions. Similarly, several representatives from the business community have announced their opposition to a, quote, one-size-fits-all standard, asserting that differences between workers, geographic areas, and other factors should allow employers to have different programs. Look, some differences are real and important. Workers who have not been acclimatized are at higher risk, and that is addressed in the proposed standard. but acclimatized workers in the hottest states like Florida are still dying of heat exposure and need water, rest, and shade. The Tampa Bay Times has recently published a powerful expose about the number of workers killed by extreme heat in that state, which was twice as high as the number reported by employers to OSHA. And yes, there are also differences among workers. Some workers are more susceptible to extreme heat. Variation susceptibility is true for all hazards covered by OSHA standards. OSHA would never permit workers who have stronger immune systems to have higher exposure to bloodborne pathogens than workers with weak immunity. By law, as I've said, OSHA standards must protect all workers. During the years I ran OSHA, we received numerous reports of young men who were apparently in excellent health before heat killed them. Some of these workers had not been acclimatized. I've yet to hear or read anything that proves that employers can accurately predict which workers would be unaffected by extreme heat. So permit me to end with a plea. In much of the country, we have just suffered under a blistering, record-setting heat wave. I ask OSHA, the Labor Department, and the White House to remember that this summer is likely to be the coolest summer for the rest of our lives, and that they only consider the most protective, comprehensive standard to ensure the nation's workforce, our greatest resource, receives adequate protection from extreme heat. Thank you for your attention. I look forward to your questions.
Thank you, Mr. Michaels. Does the OSHA panel have questions?
Your Honor, this is Andrew Levinson for OSHA. I believe we were going to hear from Mr. Barab as well, since Dr. Michaels and Mr. Barab filed joint comments.
You're right.
And then we would question both of them together.
Thank you for the reminder. Yep. Okay, so Mr. Roberts, can we promote the next witness?
The next witness is Jordan. Mr. Barab?
Yeah, hi, this is Jordan Barab. And I think just Andy, I think we should include Debbie Berkowitz in the question session as well. I think all three of us together would be great. My name is Jordan Barab. I was Deputy Assistant Secretary of OSHA during the Obama administration, working with Dr. Michaels and Ms. Berkowitz. I also worked in the House of Representatives, the Chemical Safety Board, and spent 16 years running the Health and Safety Program for the American Federation of State, County, and Municipal Employees. I want to thank OSHA for the amazing work they've done on this proposal, the scientific research, the extensive work on economic and technological feasibility, and the skill you've used in writing a standard flexible enough to fit all workers in all locations in all industries. But unfortunately, there are still far too many employers who are not protecting their employees, and there are far too many workers still getting sick and dying from heat-related illness. Probably more than we even know because of severe undercounting. But we don't just need to look at the data, we can just pick up the newspaper. And we've seen over the last several days, 3 workers who have died of heat-related illness, one in Atlanta, a construction worker in Atlanta, an umpire in South Carolina, and a letter carrier in Texas. All these workers died in states where heat is common, where if you listen to some of the industry witnesses, workers come pre-acclimated and don't need a heat standard. One thing that struck me from listening to much of this hearing is how many businesses already seem to be doing a great job protecting their employees, which reminds me of a story. A little more than 30 years ago, I went to the dentist. The bloodborne pathogen standard had just been issued, but was not yet in effect. And I asked my dentist what he thought about it. He said that he was terrified at all the costly changes they would have to make in their workplace. But 6 months later, I returned for my next cleaning, and I told him the place looked pretty much the same as it had 6 months ago. He responded kind of sheepishly that, yeah, it turns out they were pretty much all in compliance. They only had a couple of changes they needed to make. Unfortunately, we've all heard about the standard. All he had heard about the standard came from the American Dental Association, who had condemned the bloodborne pathogen standard as a one-size-fits-all solution that shouldn't apply to dentist offices. Like the dentists 30 years ago, I think too many businesses today are listening to the myths perpetrated by certain industry associations without doing their own research. And like my dentist, most of the business associations we've heard from will realize they're already in compliance with most of the standard, particularly with the initial trigger, the requirements under the initial trigger, and probably most of the requirements under the high heat trigger as well. Now, many witnesses at this hearing have praised Nevada's new heat standard as a model that federal OSHA should follow, because it is arguably more flexible and performance-oriented, allegedly more flexible and performance-oriented. But taking a look at the Nevada standard shows that there are major compliance issues and issues that will negatively impact not only workers, but small employers the most. First, the OSHA standard is flexible. Employers can develop their own program suited to their own workplace and industry as long as they satisfy the basic elements of every heat standard. Many witnesses of this hearing have complained about OSHA's heat triggers and praised the Nevada standards, which does not have a heat trigger. But take a closer look. Instead of a heat trigger, employers in Nevada must assess all of the job classifications for occupational exposure to heat illness. The standard lists 7 factors that employers need to consider: air temperature, humidity, radiant heat, conductive heat, air movement, the severity and duration of workload, and protective clothing and personal protective equipment. It's a nice list, but how does an employer easily measure and apply all of that? Can they get away with just measuring some of those factors, like air temperature, without considering humidity? Do they use the heat index that factors in temperature and humidity? Air movement? How do you define severity and duration of workloads? And at what temperature might employees suffer occupational exposure to heat illness? A dry bulb temperature of 90, a heat index of 85, a wet bulb globe temperature of 80? The standard directs employers to just figure it out for themselves. A very conscientious employer might consult with other state heat standards and determine that anything over a heat index of 80, like many state plans have, may cause heat illness. But another business across the street might decide that his workers are only exposed to the heat hazard when the temperature reaches 90 degrees. Do they consider humidity? Maybe, if they feel like it. The method may provide flexibility, but it's also particularly problematic for small businesses who really want to do the right thing, because in order to determine their own personal heat trigger, they either have to conduct a job hazard analysis that considers some or all of these factors for every type of job in their workplace, or they'll need to hire a consultant to help, expenses that small businesses can rarely afford. And how is Nevada OSHA supposed to enforce something like that? The only criteria that Nevada suggests is that any measure the employer implements must, quote, reasonably mitigate the risk of occupational exposure to heat illness for the affected employees. Now that sounds very performance-y. In fact, I'd love for the police to get rid of speed limits as long as I just, quote, reasonably mitigate the risk of traffic accidents. There are many other problems with Nevada's flexible standard. Rest breaks are only required for employees after they exhibit signs or symptoms of heat illness instead of being used to prevent heat illness. And rest breaks are not paid, which means that many workers on piece rate will be punished for taking a break. The water section is also very flexible. There's no requirement for how much water must be available or how accessible it should be. You have to walk a mile to get water? Fine. You only get 8 ounces of water per shift? No problem. You're still in compliance. The employer is required to designate someone to monitor working conditions, but only if practicable, whatever that means. And workers who are loading or unloading motor vehicles are exempted from coverage or exempted from being monitored. There are no acclimatization requirements, none. Even this weak standard exempts employees with 10 or fewer employees under the assumption, I assume, that employees of small employers are either magically immune from heat illness or just don't deserve to come home alive at the end of the workday. So if a worker dies of heat stroke, the employer can probably show that they've taken some of the 7 measures, but decided that his employees are, quote, industrial athletes who could work safely under a heat index of 95 degrees all day. And there's water and rest a half mile away if someone starts showing signs of heat illness, but their pay will be docked if they take a break. A worker is dead, but is the employer in compliance with the Nevada standard? Probably. There are many, many other serious problems with the Nevada standard, but time doesn't permit. The bottom line is that the standard may look more flexible than OSHA standard, but it doesn't adequately protect workers, and there's no way for Nevada OSHA to enforce safe working conditions that will effectively protect workers. So let me be perfectly clear. First, it is true that this is a one-size-fits-all standard, and that's a good thing, because all humans are basically the same. High heat can kill anyone, young, old, in the South or in the North. Second, there's no such thing as geographical differences that make the standard or the triggers unnecessary in some parts of the country. There are only human beings, all of whom are potentially susceptible to heat illness and death. Despite the myths we've heard from so many witnesses, for the human body, 80 degrees in Dallas or Atlanta is exactly the same as 80 degrees in Minneapolis or Bangor, Maine. Many witnesses have attempted to argue that workers in the South don't need a standard because they're used to being hot, and workers in the North don't need a standard because it's hardly ever hot. And every single industry in the country is unique and should be exempted from the standard, even industries like construction and agriculture, where most workers die from heat illness. And despite evident testimony from one large law firm, humans have not evolved to be more tolerant of high heat. In conclusion, for those who fear a strong standard, my advice is to take the science seriously, not the myths. Take the deaths seriously, not the excuses. Take your workers' lives seriously, not the fear-mongering. Finally, trust the process. Despite threats of mass bankruptcies, unemployment, and the end of Western civilization that we've seen criticizing every new OSHA standard, the evidence has proven over the past 50 years that strong OSHA standards protect workers and make businesses more productive and more efficient. Thank you.
You're muted.
Apologies, that's probably going to happen a lot today. Given the request that we take questions after the testimony of the next witness, could you please promote Ms. Berkowitz?
The next speaker is Debbie Berkowitz. Berkowitz, please state your name and affiliation.
Hi, good morning. I'm Debbie Berkowitz, the former Chief of Staff and Senior Policy Advisor at OSHA, working with Dr. Michaels and Jordan Barab. Over the past 40 years, I've also been the Director of the Safety and Health Program at unions and nonprofits. I'm now a fellow at the Kalmanovitz Initiative for Labor and the Working Poor at Georgetown University. I support the OSHA proposed standard, and I'm grateful for the OSHA staff for trying to move forward to protect workers. Had this OSHA standard been in place over the last few years, many deaths would have been prevented. I want to touch just on a few points during my 5 minutes. First, the evidence is clear that the current OSHA proposed standard with specific temperature triggers and all the specific basic common sense requirements included in the proposal are feasible and effective at saving lives and preventing heat-related illnesses. Over 19 years ago, California implemented a heat illness prevention standard for outdoor workers that requires the full basket of basic common sense protections as in the current OSHA proposal. Note that the Cal OSHA standard includes specific temperature triggers to make sure all employers know when to implement the protective measures. And it does not leave it to the subjective judgment of every employer to decide if they think it may be hazardous. That all agriculture and construction employers in California have had to comply with this standard for almost 2 decades, whether they are in the north of California or the south of the state, is clear evidence that this basic common sense approach taken by OSHA in this proposal is feasible and works. Further, 3 years ago, Oregon OSHA adopted a heat standard covering both outdoor and indoor workers that also contains the same basket of protective provisions as in the OSHA proposal. And this standard also contains specific temperature heat index triggers that are critical to assuring that protection will not just be left up to an individual employer's best guess. The Oregon OSHA standard has been enforced for 3 years now, additional evidence that the indoor and outdoor requirements in the OSHA proposal to protect workers from heat are feasible. Second, I want to address the need for specific temperature heat index triggers in any standard. Let's be clear, without a specific temperature trigger, worker protection will only be triggered when an employer thinks their workers might be in danger. Thus, whether or not an employer provides water, rest, shade, breaks, acclimatization, and training will be based on a subjective decision or when it's already too late for prevention when a worker is in an emergency. This could leave workers with less protection than they have now with no standard. We also heard from employers who testified here that though they didn't want specific temperature triggers in any standard, they use specific temperature triggers themselves in their heat safety program. All the more evidence for the need for temperature triggers as in the current proposal. Third, I want to address the narrative we have heard from some that have testified that depending on where workers live, they may not need to be acclimated. Any review of the data on workers killed on the job due to heat makes clear that the first few days of workers on the job are the most dangerous for heat. The evidence is also clear that this is true for workers in the north and in the south. That is why acclimatization is so important to saving lives in all parts of the country. For example, in 2018, a farm worker arrived in Georgia in mid-June from Mexico and went to work picking tomatoes right after he arrived. Miguel Angel Guzman Chavez, a seasonal worker here on a work visa, tragically died on the second day on the job as temperatures soared to 95 degrees. He came from a very hot climate, yet he was killed by his exposure to heat. OSHA cited his employer for failing to protect him from heat-related illness and death. Then there's Jonathan Salazar from Guatemala, who was on a landscaping crew as a temporary worker in Florida in 2022. And on his second day on the job, he died of heat stroke. The Tampa Bay Times in December 2024 released the results of a comprehensive investigation into workers that had died from heat in Florida. The article found that twice as many workers have died across Florida than have been reported to OSHA or others or the state. Thus, the official statistics on how many workers have been killed by heat on the job are clearly an undercount. But additionally, many of these workers were either already living in Florida or had just arrived from Latin American countries and often died during the first few days on the job. Last point I want to address is that some have testified that OSHA does not need to require that employers provide breaks to workers as a protective measure in high heat, because workers can take breaks when they want to. I want to be clear in this record that in my 40 years of working in occupational safety and health, I have not known any workers in agriculture, construction, restaurants, warehouse, sanitation, and other industries where heat can be a health hazard who are just able to take a break when they want one. There may be a few companies, construction companies, where a union has negotiated this in their contract, but it is rare. That is the exception and not the rule. I want to thank you for this time, and I look forward to answering any questions.
Thank you very much. With those first three witnesses completed, I think now we are going to questions of those witnesses. So were there any questions, Mr. Levinson from OSHA?
Yes, Your Honor. Andrew Levinson from OSHA, and I'm going to ask questions. Any of the three of the witnesses are welcome to answer, or each of you can answer as you deem appropriate. Also, there is a post-hearing comment period, so any thoughts that you have now are welcome, but we're also happy to receive any expanded thoughts in post-hearing comments. As I think all three of you have correctly identified, many of the comments that we've heard over this hearing have focused on the one-size-fits-all or the statement that this is a one-size-fits-all approach and a desire for a more performance-oriented approach. In particular, people have asked for things like flexibility around break time, that 2 hours is too prescriptive and that they need more flexibility, for example, if they're doing a concrete pour or some other thing that can't be disrupted. We'd like to know your thoughts on performance-oriented standards, and is there a way that OSHA could make the regulation more performance-oriented while still providing essential protections to assure that workers are adequately protected from heat? Do any of you have thoughts?
First, I want to talk just in general about the performance-based heat programs, because a lot of employers do have them. I've reviewed some of the submissions, and for example, I looked at the UPS, which boasts about having a successful performance-based heat program over the last 2 years, especially, and it looks like it's great. But if you look at the OSHA severe injury database, I counted 23 heat hospitalizations among UPS workers in the past 2 years alone. That's 23 hospitalizations in a company that's right. If you look at the OSHA inspections following these hospitalizations, you'd no doubt see it would have been prevented if UPS had a program that complied with the requirements of the OSHA's. First of all, it's very important to take a very hard look at performance-based programs. OSHA, this standard already has a great deal of flexibility. Obviously, there are some ways that it could probably be made a little bit more flexible, but I think OSHA has to be careful. It would be worthwhile to look at submissions from specific industries that say these are ways you might be able to adjust it. But if people are not given breaks and the ability to rehydrate in shade, they're at risk, especially if you're, and this only obviously occurs at the 90-degree trigger. So we're talking about extreme heat. So if there's a request for flexibility, I think there has to be some accommodation saying, okay, you can take flexibility around this time, but you have to ensure that certain things also occur to make sure people are safe, and to take a hard look at that before moving forward.
Now, one other thing, any standard, has to be enforceable, and it has to be enforceable. It has to be preventive. It can't be reactive. Only
Hold
being
on
able
one
to.
minute, Mr. Barab. I apologize.
Yeah.
I'm getting some feedback. I don't know. Can I just remind everyone to make sure you're muted if you're not speaking, just see if we can minimize that. Apologies for the interruption. Go ahead.
Thank you, Aaron. You also failed to remind me to introduce myself, so I will introduce myself again. My name is Jordan Barab. Any standard that OSHA issues has to be enforceable and has to be preventive. In other words, you don't want to have to wait until after someone is hurt to enforce the standard. Some of the witnesses we've heard promoting performance-based standards have said things like the outcome should be the goal. And OSHA should accept whatever works, quote unquote. The problem is you don't know what's working until it doesn't work. In other words, if somebody until after someone has gotten hurt or died, you don't know what the outcome is, and again, necessarily until someone again gets hurt or dies, and that makes any performance standard that's defined that way, to wait until the outcome or to wait until you see what works, inherently reactive. In other words, OSHA only able to enforce the fact that the outcome didn't come out so well only after someone is actually sick or unfortunately passes away.
Any other questions, Mr. Levinson?
Yes, thank you, Your Honor.
It's like Ms. Berkowitz would like to add a comment.
This is the problem of doing this from home. Somebody was at the door. But I just wanted to say, and I'm Debbie Berkowitz, about flexibility. I was involved in testifying and hearing the comments for the Maryland heat prevention standard, which follows the same basket of protections that OSHA has proposed. And we also heard from the one issue on flexibility was with concrete pourers in construction companies. And I just want to remind the record here that these mandatory breaks happen at 90 degrees, 95, 100 degrees. And that one of the things that the construction companies figured out is their crews take breaks every 2 hours. And so they figured out that they could figure this out just by their own schedule. I mean, I do think that the standard is already flexible. And, it allows fans instead of having to put in engineering controls inside. I mean, I think there's a lot of flexibility built into this, and it's a very basic common sense standard. So thank you and apologies.
Thank you. My next question touches on something that Mr. Barab raised in his testimony. In performance-oriented approaches, we're curious your thoughts on what it would take for an employer to properly document that they considered all of the factors, such as those raised by Arizona, to do an adequate job hazard assessment or some other sort of analysis on in order to determine what was necessary to protect workers.
Well, yeah, I mean, you're obviously referring to the Nevada standard, which has 7 factors listed. First of all, it's unclear from the standard whether you actually have to consider all 7 of those or just some of the 7 of those. If you have to consider all of those, you're essentially doing a wet bulb globe temperature reading and a number of other factors for every job classification, which is, I think some would say is more burdensome than the federal proposal, although I think the federal proposal should also consider wet bulb globe measurements. And as I said, I mean, so either you have to do all of them, which would really require, especially small employers, to hire a consultant, or maybe just some of them, but it doesn't say which ones of them. And if you only do, for example, dry bulb temperature, that obviously isn't adequate. It may be very performance oriented in that you can do whatever you want, but it does not provide adequate protection for workers, and it doesn't require employers to take into account all of the factors that may endanger workers.
If I can just add, it also imposes, this is David Michaels, imposes significant record keeping requirements on employers. There has to be some proof that they actually took these into account. And given we're talking about changing climates, changing situations, changing jobs, the amount of work that this will require to do it right really is quite extensive.
Thank you. My last question relates to injury and illness record keeping. I think all three of you touched upon the issue of recording and reporting of injury and illness information by employers. And given some of the assertions that a performance-oriented standard should only rely on outcomes, do you have any thoughts on how employers should assess those outcomes and any concerns you might have related to signs and symptoms being reported and or recorded by workers?
Well, I think it would be very useful, not only for employers, I should say particularly for employers and their employees.
Just state your name again, sir. Sorry.
I'm sorry, Jordan Barab. I think it would be useful for employers and for workers and for OSHA, for there to be a log of heat-related illness. Not necessarily every symptom. Obviously, somebody suffers, but certainly, some definition of heat-related illness and a logging of that. That would be useful for employers to determine the success of the program. Obviously, be useful for workers to know what's going on in their workplace, and it would be useful for OSHA to determine, how much of a problem there may be at any given workplace. If employers have, good programs, which we hope they would be once the standard is issued, that shouldn't be much work, because ideally, if they're complying with the entire standard, there shouldn't be many, if any, heat-related illnesses.
This is David Michaels. One of the very clear and unfortunate outcomes of exposure to extreme heat is greatly increased risk of injury, of workplace injury. In the various performance standards that I've looked at, there's very little discussion of increased risk of injury from extreme heat exposure. But if you're going to keep records about what sort of effects heat has had, you've got to also record your workplace injuries and the heat and humidity, or however the measurement is being done, for every injury that's occurring during hot periods. And that also will be quite a challenge. But to know whether a standard performance based program is effective, you've got to look at injuries that should address if that's the direction that it ends up going.
This is Debbie Berkowitz. I also support, the provisions to OSHA needs to clarify employers' record-keeping responsibilities when it comes to heat-related illness. I mean, I think one of the things that the Tampa Bay Times did, and we'll submit that in post-hearing comments, is found all these workers that died of heat. They were taken from by an ambulance from their workplace, and they died in a hospital, and nobody reported it. So nobody even followed it. And that way not only employers will get a better record of heat-related illness in their workplace, so that they know, geez, we've missed the boat here and we need to do better. But I think that the AFL-CIO submitted comments about record-keeping provisions that should be added to the proposal that OSHA should seriously consider.
Thank you. And Your Honor, the next questions for the witnesses come from Stephen Scher.
Yes, good morning. Stephen Scher from OSHA. First, thank you, Dr. Michaels and Mr. Barab and Ms. Berkowitz for being here today and for your testimony. I wanted to follow up with a question about the state heat standards. So first, in your testimony, Mr. Barab, you had mentions of the testimony that we've heard during the hearing that OSHA should model any federal heat standard after the Nevada heat standard. That does not have triggers but requires employers to conduct a job hazard analysis. So I wanted to check with Dr. Michaels and Ms. Berkowitz if you could also discuss whether you think OSHA should adopt a standard similar to Nevada's and why or why not. And then as a second part to that question, if you'd recommend any other specific changes that OSHA should make to the proposed standard based on existing state heat standards.
I'm sorry, Steve, did you say I supported, this is Jordan Barrett, did you say I supported OSHA following the Nevada standard?
Oh, no, I don't think so.
Okay, I'm sorry, I misheard you. Never mind.
Right. No, I was saying that you mentioned that we heard testimony during the hearing
Testimony. Right. Okay. Sorry.
that OSHA should model any federal heat standard after the recently promulgated Nevada heat standard. So just wanted to check with Dr. Michaels and Ms. Berkowitz if they could also discuss whether they think OSHA should adopt a standard similar to Nevada's and why or why not.
Thank you.
Sure.
Yeah, no, I agree with Jordan's comments that I think the Nevada standard is severely lacking in enforceability, and therefore it essentially allows employers who decide not to take the high road to really not do anything significant to protect workers. It allows them to do that. OSHA requires making a plan, and the plan essentially is a job hazard analysis. You can think about what needs to be done, but you really have to have some triggers, some real requirements. I have to say, we've always heard, and this is really for 50 years, employer representatives have said, look, the OSHA proposed standard is technologically and economically infeasible. It's too costly. We really should be left to do whatever we want. But once history has shown that once a standard is issued, and it's improved through the evidentiary process, just like this, it's always made better, I think, in every case. We generally find out that OSHA standards are effective, and they turn out to cost far less than employer groups have estimated. They cost far less than OSHA estimated. And that's because the nation's businesses and the nation's engineers are innovative, they're creative, and they figure out how to meet the standard, how to protect workers more effectively and efficiently than OSHA even had presumed. I addressed the vinyl chloride example in my book, Doubt is Their Product, but there are other examples too. The late and lamented Office of Technology Assessment of Congress looked at this and found that it's all doable. I mean, the complaints that you really just have to let employers figure out what they're going to do and let them do it, that doesn't work. But the flip side is what OSHA requires is generally absolutely doable, it's cost effective, and most importantly, it saves lives, which is the point of the OSHA law.
Hi, this is Debbie Berkowitz. I can just weigh in before Jordan does, since it's his testimony, but OSHA should do nothing if they're thinking of issuing something like Nevada. It offers less protection than I feel the general duty clause right now, because an employer could say in Nevada, oh, well, 2 workers got sick, but it still didn't come up in my job hazard analysis because these are the criteria I used, So, I was involved in the Maryland OSHA process for setting a standard on heat, as well as in Oregon. And never in Oregon at any point during that whole process did anybody in the state, no industry, nobody ever said, oh, let's not have specific triggers and let's not have specifics about water and that it has to be accessible and how much water. These are just basic common sense. And nobody said, let's not include acclimatization. I'm very shocked by the Nevada standard OSHA. I knew nothing about it until it was published, but it is not something that any other state should put into place. And I'm hoping Nevada at some point, will replace this with what federal OSHA comes out with. But I also want to say that in Maryland, and I'm happy to put it in the record, is Maryland was first thinking of a very not a performance or a standard, but a standard with no requirements, just saying you got to think about heat, essentially, which was very much like the Nevada standard. And 37 organizations from AIHA, professional organizations, safety organizations, worker organizations, all came together and said, this standard is really fundamentally flawed, and it's less protection than under the general duty clause. And then Maryland replaced it with a proposal and now a final standard after hearing from industry, with very similar to the current OSHA standard, with specific triggers, specific requirements on how to protect workers. But just like in the OSHA standard, it retains a lot of flexibility.
Yeah, Steve, just one more thing. Any standard, you can't just list like Nevada does. You have to consider, water, you have to consider rest. You actually, a standard that's going to protect workers actually has to make sure that employers are actually doing something that's based on the science. And I would encourage, some of the employers who are basing their testimony off other, testimony and things that they've heard, to actually read beyond just the OSHA regulatory text and look at the voluminous amount of science that the OSHA staff has compiled in the preamble, in the background to this standard, because everything that OSHA has put in the proposal is backed up by strong science. The amount of water workers need, the amount of rest workers need. These are not just things that OSHA has pulled out of its hat. And any standard that doesn't actually, respect that science and base their standard on that science isn't going to protect workers adequately.
Okay, thank you. And my second question, just switching gears a little bit, is about triggers. So we've received many comments and heard many witnesses in the testimony during the hearing say that any triggers in a federal heat standard should account for geographical differences. And so just wondering if you as a panel agree, and why or why not. I know, Mr. Barab, you talked a bit about this in your testimony, but if you have anything else to add, or if Dr. Michaels or Ms. Berkowitz have anything to add, that would be helpful.
David, Michael, I think we all addressed this. The evidence is very clear that it really doesn't make a difference where the worker is working in the country, whether it's in Alaska or in South are high enough, they're at risk for being killed. The functional difference is risk is lower if they're acclimatized.
Mr. Michaels, we seem to have, I don't know if it's just me, but I seem to have lost you for a couple seconds there. I don't know if maybe you want to back up in 5 seconds and state again what you said. Is it just me, or?
No, I also am not able to hear.
Yeah,
I think he's frozen. I'll fill it a little bit until he comes out.
I think we have, this is Jennifer Levin from the solicitor's office. Good, if Dr. Michaels turns off his camera, let's see if we have better transmission or if he freezes.
Okay.
Dr. Michaels.
Okay, I will speak now. I'm sorry I wasn't heard earlier. No, I was saying there is no scientific evidence to say that the 90 degrees heat index is safer in South Texas than it is in Alaska, where we just had record heat. If workers are acclimatized, they're at lower risk, but they are still at risk. And so acclimatization is important, but the triggers that are in place, the 90-degree trigger to actually trigger regular breaks, is fundamentally important no matter where it is. And there is no evidence at all to suggest that it's It's unnecessary, even in hot climates.
Excuse me,
I'm so
Ms.
sorry.
Berkowitz, if you could mute yourself. Ms. Berkowitz, if you could mute yourself. We're getting feedback from your microphone.
I'm muted.
I think she's muted now.
Okay, I've been muted. I'm not sure what you hear because it's silence in here, but I'll mute again.
Okay. Dr. Michaels, were you finished answering or were you moving on?
Yes, I'm finished. Thank you.
Okay.
Okay, thank you very much. Appreciate you addressing those questions.
Thank you.
Your Honor, the next questions from OSHA come from Tiffany Defoe.
Thank you. Go ahead.
Good morning. This is Tiffany Defoe with the Directorate of Standards and Guidance, OSHA. I have a couple questions about rest breaks, and I'm addressing them to Ms. Berkowitz, but definitely welcome commentary from any of the panel members. Thank you. So Ms. Berkowitz, in your written comments that you submitted, you referred to the California outdoor heat standard as one which has been shown to decrease heat-related illness since its implementation. And in that rule, it says that employees shall be allowed and encouraged to take a preventive cool down rest in the shade when they feel the need to do so to protect themselves from overheating. I'd like to ask if there are thoughts you could share on whether you believe the California rules provision to allow rest breaks in a preventive fashion, rather than, for example, as a response to the onset of early signs and symptoms of heat illness, is necessary to prevent significant adverse health consequences of heat stress.
Thank you. This is Debbie Berkowitz. There's evidence that not only is the California outdoor heat standard there's evidence that not only does heat cause heat-related illnesses, but causes other safety-related illnesses when people are working outdoors in heat or even indoors, with falling off ladders and other kind of things. So I think it's very important that any standard prevent heat-related illness and death and not only implement provisions till after somebody gets sick. Because what we've seen and what we see at OSHA and the cases that I've been involved in, when I get calls from agriculture workers and construction workers, is somebody went very quickly from feeling dizzy and nauseous from heat, and then they died. And so that's the problem with heat stroke. I mean, there was, we just had a heat wave, and I had a neighbor that lost their air conditioning that thought, okay, I'll sleep in my house tonight. Woke up with chills, and in 1 second, they were in the emergency room, and for 8 hours and survived. But the nature of heat illness is not like I get an early symptom, early sign, and if I have a break, then everything will be okay. It could be too late even at the early sign. And so that's why these rest breaks are so important. And I think, other standards that came after the Cal OSHA standard, remember that was almost 20 years ago. So their indoor heat standard, the Oregon standard, and the Maryland standard all actually has very specific requirements for mandatory heat breaks with specific times within certain hours, once the temperatures get higher. And I totally support that and totally support the requirement that breaks be part of a standard for prevention. And I think if you go back to the record of the cleanup during Deepwater Horizon on the beach, we follow the Coast Guard's heat prevention program, which whether there were symptoms or not, they had a, they worked for 15 minutes, off for 15 minutes. That was really instrumental in making sure nobody died of heat stress while cleaning up the beaches after Deepwater Horizon. I hope this is helpful.
Thank you. I have one more question. I just wanted to pause and see, just give a pause in case any of the other participants wanted, the panelists had something on that one. Okay, hearing none.
No thanks. David Michaels, no thanks.
Thank you. Tiffany Defoe, Standards and Guidance, OSHA. Ms. Berkowitz, you also referenced your involvement in Oregon's development of their heat rules. And in that one, in the outdoor work rule, there is a provision that allows for the use of cooling vests, either with fans or ice packs, water dampened cotton clothing, or similar effective measures, as the rule puts it, in lieu of shade, when the employer can demonstrate that providing access to shade is not safe, or if it interferes with the ability of employers and employees to complete the necessary work in a particular situation. And I'm wondering, either now or in post-hearing comments is fine if you'd rather take some time with it. If you can give any thoughts that you have about how that provision was intended to be used, what kind of situations it's intended to address, and how it's been working out in practice.
Yes, I can put that in post-hearing comments. That was part of the comments and, trying to be flexible in some of the provisions in the rule.
I had no further questions, but much appreciate all of your testimony.
Thank you. Your Honor, the next questions from OSHA come from Zoe Petropoulos.
Hey, good morning. This is Zoe Petropoulos with the Directorate of Standards and Guidance. I have a few questions for you all about OSHA's risk assessment. My first question is, do you agree with OSHA's conclusion that heat poses a significant risk of material impairment to workers in the United States?
David Michaels, yes. There is no question that's the case.
I'm seeing head nods. I assume we need a verbal.
This is Jordan Barab. I agree 100%. It does. It kills, injures, and kills workers. I think that's the bottom line. I don't think anybody would deny that.
And Debbie Berkowitz, yes. And not only is it a hazard, a serious and deadly hazard to workers, and we agree with your risk assessment, but it's preventable. These deaths are preventable.
Thank you. My next question, for the risk assessment, OSHA relied upon multiple sources of data on non-fatal injuries and illnesses, specifically the BLS Survey of Occupational Injuries and Illnesses, and state-level data on workers' compensation claims and hospitalizations and emergency room visits. In your expert opinions, do these represent the best available data sources for estimating the incidence of non-fatal heat-related injuries and illnesses among U.S. workers?
If I can step in here first, I think they're good sources, but it's very clear that there is a significant undercount of heat-related mortality and non-fatal events as well. So while it's useful to use those numbers, I think it has to be assumed that the actual impact of heat on worker health and on injuries is far greater than is actually being seen. I'm trying to do some work now looking at the ITA case data to get a better sense from there to see if we can essentially come up with more information to supplement it. But overall, the risk assessment just has to take all of these into account and recognize that they're all incomplete. And we know from other studies that BLS has commissioned that the SOI data, which the BLS Survey of Occupational Injury and Illnesses, is somewhere between a 30 and 60% undercount of injuries, and even injuries that we would expect to see picked up much more easily. They're not controversial, say an ergonomic related injury where you could say perhaps that didn't occur at work, but traumatic injury, amputations that occur at work are undercounted in the SOI data. So there's no reason to think that the heat data are also there's reason to think that the heat data is slightly undercounted in the SOI, and we know, of course, how heat increases
Mr. Michaels,
risk
you're
of
breaking up
fatality.
again. I think it might be worth
sorry.
turning your video off again, just to see if we can.
Yes, yeah, I'm sorry about that. Yeah, so just let me repeat, there's also reason to assume that the fatality data from the CFOI, from BLS's Census of Fatal Occupational Injuries, is also an undercount because extreme heat increases the risk of fatal heart attacks and other causes of death, and they rarely get recorded as caused by heat directly, and so they don't make the CFOI. So again, all the evidence that says that while these are good data sources, they're not complete, and they underestimate the effects of heat on injury, illness, and death. Thank you.
This is Jordan Barab. A couple other things. I think Ms. Berkowitz mentioned the story in the Tampa Bay Times that documented over a dozen workers just in Florida over a fairly limited amount of time who had died from heat-related illnesses, but were not recorded as that, or picked up by OSHA, and probably therefore not by BLS either. You also have to consider that a lot of heat illness, you may have some symptoms at work which are not picked up at all. They aren't reported, they aren't recorded, and the worker may become much more sick at home later on, and that's directly, caused by the exposures to high heat levels at work. But again, those will be missed by any kind of record-keeping process.
And this is Debbie Berkowitz. I just want to add a couple of things. First of all, as you're very aware, folks at OSHA, those record-keeping guidelines that you have miss a whole lot of workplace-related serious injuries and illnesses, because in many cases, employers feel like they don't have to report or record anything unless someone's gone to the hospital during the workday, or they have to see a doctor. And a lot of employers, like especially agriculture employers, there's no doctor anywhere if somebody is sick. And so they don't send people who are very sick and then who may die. And I've seen that in many, many other industries where companies have figured out how to game the OSHA record keeping system. So if they don't send workers to a doctor when they're sick, and workers go to their own doctor, and then the employer doesn't have to record it. So it definitely, the statistics you're relying on for this standard are an undercount, and that's why and even those are incredibly high. So you really do need to move forward. But I also think OSHA needs to consider in this proposal sort of a better definition of when employers need to keep a record of heat-related illnesses. That's going to be really important for them in monitoring their program effectiveness. And the last thing I wanted to add is in that 2018 case that I mentioned that OSHA did an inspection in Georgia, that farm worker death wasn't reported or recorded.
Thank you. My next question is whether you agree with OSHA's conclusions about the effectiveness of the proposed rule in reducing heat-related injuries, illnesses, and fatalities.
This is Jordan Barab. I think if you look at the science of what causes heat-related illness and what can be done to prevent heat-related illness, OSHA hits all of those nails on the head. There are certainly, I think we've seen, I think our testimony, you can look at the AFL-CIO testimony, there are certainly improvements that can be made in this. But in terms of not only identifying the factors, water, shade, rest, emergency response training, and acclimatization, those are all hit. And unlike the Nevada standard, actually require employers to do something to actually implement those protections to the extent that they will will prevent most heat-related illness or death. So yeah, I think the the OSHA standard is great. I mean, there's always room for improvement, and as I've said before, there has never been a final OSHA standard that hasn't had changes from the proposal based on public input and hearings such as this. So although they're not perfect, I'm sure it will be better after these hearings. And again, I think it'll go a long way to significantly reducing the incidence of related illness in this country.
And okay, I'll add. This is David Michaels. No, in fact, I totally agree with what Jordan said, and I want to compliment the OSHA staff for the really excellent work they did on the all the risk assessment data, on looking at what sort of solutions can be applied, and their determination about the effectiveness of the proposed standard. I think they did an excellent job. It's always challenging to write a standard and to synthesize a tremendous amount of literature. We're fortunate that until the organization was really virtually destroyed, NIOSH provided a lot of very important information that went into the standard. With luck, we'll have some ability to get some additional assistance from NIOSH, but I'm not sure we will. But I think that generally, when I read the standard and the technical aspects of the standard, I thought they were very well done and, as far as I could tell, accurate and really well presented.
And this is Debbie Berkowitz, and I just want to add that the evidence is really clear that the OSHA proposal will save lives and prevent heat-related illnesses, and that it works. And if you just recently, a year ago, there was a tragic death in Baltimore of a sanitation worker, and actually Eric Kahn's law firm did a whole analysis of how this happened, how this worker died of heat stress, and found that Baltimore had no heat program. They had no, comprehensive plan with temperature triggers and with measures and training to prevent this. And Maryland OSHA had proposed a heat standard and had just implemented it after the worker died. And all of a sudden, Baltimore's implementing the program. And that's exactly what, this law firm said you need to do to prevent injuries and illnesses. So this standard will go a long way. And I want to say that just having this proposal out, employers are going to start following it. That's just what happens in the OSHA standard setting process. And so if OSHA, discards it or weakens it, you're going to see a real setback in employee protection.
Thanks. And I'll just say my last question is if there's any additional input that you would like OSHA to consider on these topics I've asked about, we welcome in post-hearing comments. And that's it for me.
Your Honor, OSHA's last question comes from Eduardo Hernandez.
Hi, good morning. Eduardo Hernandez, Standards and Guidance, OSHA. And I have one question. So we've heard testimony during the hearings that OSHA should continue to rely on the general duty clause instead of issuing a federal heat standard. And you've talked about that a little bit today. And Mr. Barab and Dr. Michaels, in your written comments, you mentioned that the general duty clause is very difficult to use and it requires significant enforcement, legal, and administrative resources. So could you further explain some of the difficulties for the record?
I'll start. Yeah, this is Jordan Barab. Yeah, so the general duty clause, I mean, I've heard it characterized as, so this standard, for OSHA to issue a standard, they have to show that there's a significant risk, that the standard addresses that significant risk, that it's economically, technologically feasible. And one has heard the general duty clause described as having to basically do a mini rulemaking for every single enforcement action under the general duty clause. It's a lot of work. And it's also a lot of work for employers because the general duty clause doesn't exactly say what is required, and it's really kind of up to OSHA to determine based on the 4 factors of the general duty clause, whether there's been a violation or not. But it's, we've heard, as David mentioned, especially from small employers, that it's a lot easier to comply with the standard that more or less sets up a checklist of what you have to do rather than dealing with the vagaries of the general duty clause. And I think it was also mentioned in this hearing, the general duty clause is almost exclusively used only after a worker is killed or hurt. That makes it totally reactive. The whole point of the Occupational Safety and Health Act and OSHA is to ensure that workers are protected from hazards before they get hurt, not after they get hurt. So that again makes the general duty clause not as effective as a specific standard. I also want to point out that there's a funny phenomenon that goes on here, and I've been through God knows how many OSHA hearings as well as congressional hearings, both as a witness and as someone who's organized the hearing. Is that industry? If OSHA starts using the general duty clause a lot, they're for ergonomics, workplace violence, heat. Industry representatives generally hate that. We have testimony over and over again saying if you have that's not what the general duty clause was made for. It was made for exceptional circumstances. If you have a pervasive hazard that is, to workers, OSHA really needs to develop a standard, not keep using the general duty clause. And then as soon as OSHA starts developing a standard, suddenly they turn around and they say, no, we don't need a standard. We just need the general duty clause. So it's very unclear, what anybody thinks in the industry thinks about the general duty clause, whatever happens to be, I think, convenient at the time. But the bottom line is, it's just I don't think there's anybody out there that will say enforcement through the general duty clause is really as effective as having a standard that lays out exactly for employers what they have to do to protect workers.
And this is David Michaels. Just to add, I totally concur with everything Jordan has said. It's also worth noting that the OSHA Enforcement Inspectorate has gotten quite a bit smaller over the very recent period. And if you look at the budget being considered by Congress, it will likely stay at a record small number of inspectors. The general duty clause, use of the general duty clause is extremely resource intensive. It takes inspectors away from doing other inspections, which are really needed to make sure workers are safe. So if OSHA were only to rely on the general duty clause, it would therefore result in fewer inspections elsewhere. And we know that there is lots of evidence that OSHA inspections reduce injury rates into the future. There are 3 studies which use essentially a randomized design that incontrovertibly show that OSHA inspections reduce injuries, and we'll have fewer OSHA inspections. So just relying on the general duty clause not only will mean more workers are exposed to heat, but in addition, it will mean workers at other workplaces will be injured as well.
I know you didn't ask me as well, but can I chime in? This is Debbie Berkowitz. When I started my career in worker safety and health, I was working at the Food and Allied Service Trades Department in the AFL-CIO, then called the Food and Beverage Trades Department, and grain elevators were exploding everywhere and killing workers. And I was working for the American Federation of Grain Millers. And OSHA tried using the general duty clause to cite these employers killing workers, and explosions continued. OSHA finally started the rulemaking and sort of telegraphed that they're going to set specifics of how much dust, and that they have performance-oriented standards, but they had to control ignition sources, with specifics, but some flexibility. That rulemaking went on for almost 5 years. And then since the rule's been issued, there have been almost no grain elevator explosions. And I think, the record shows very clearly that when you've got a pervasive hazard like heat, that you need to have a specific rule if you're going to protect workers. And and I also agree with everything that Dr. Michaels and Jordan Barab said. Thank you.
Thank you. Those are all my questions.
And Your Honor, that concludes the questions from the OSHA panel.
Thank you very much. Did we have questions from the solicitor, Ms. Levin?
Yes, Your Honor, thank you. This is Jennifer Levin for the Office of the Solicitor. I have no questions for the witnesses.
Thank you. And did we have any questions from any other online participants?
Your Honor, we have 3 questions in the queue. First up is Ms. Janae Arbery.
Okay. Go ahead and promote her, please.
Oh, hi there, Shanae Arbery with the AFL. I have a question for Jordan, but the other panelists can answer as well. As you've heard over the past few weeks, a lot of witnesses have stated their preference for a performance-based standard, and like they believe it to mean employers should be given basic goals, allowed to decide how to best meet them. But what would you say is wrong with this approach?
Well, let me just start with saying that's basically where we are right now. The general duty clause requires employers to provide a safe and healthful workplace. That is in effect right now, and we've seen that it hasn't been working. There's still far too many workers, many more again than we know, that are dying and getting sick from heat. So it's clear, and I think as Dr. Michaels explained, having a standard for any issue is much superior than the general duty clause, or as some employers have said, all we need is more training and guidance, which again is what we already have. I mean, just as an aside, if you do a search for workplace heat protections on the internet, and within half a second you can get 35 million hits. There's plenty of information out there. There's plenty of guidance out there. We have the general duty clause. None of this is working. Employers know they have to keep keep their workplaces safe. It's just not working to protect workers. And we've seen throughout the over 50-year history of OSHA, as Ms. Berkowitz testified, only strong standards that specify what employers have to do, but provide some, flexibility for differences in different industries and different workplaces are the things that actually work to protect workers.
Thank you. And Your Honor, I have one more question to pose. Additionally, why aren't training and guidance documents a better solution than a specific standard for the panel? Thank you.
If I can just follow up on that, I mean, there's lots of training available. You can train people and tell them, you need to take regular breaks, but unless they're guaranteed the right to take those breaks, that training is not effective. I mean, it's pretty straightforward. Training is useful, but it's necessary but not sufficient, and that's very clear. And that's why every other OSHA comprehensive standard has training requirements that are a component of programmatic requirements that require engineering controls and other protections.
I want to jump in because I think this is the new thing that industry is saying we don't need standards. We just have to train workers to protect themselves, I guess. I mean, the training requirements in the standard are very important. They're just one part of a program because you're training workers on the early signs of heat-related illnesses so they can recognize it right away and know to get help. But if there's no requirements for at certain temperatures for water, rest, shade, and when do those, and what is the trigger for training workers and acclimatization, then, it's not going to protect workers. And, you've got some industries that try to run against OSHA now saying none of their standards are legal and they should be able to just train workers to avoid dangerous equipment. And that's going back to sort of before OSHA, when we know that 3 times as many workers were killed on the job, and that's with half the workforce.
This is Jordan Barab. So I spent, as I mentioned, 16 years working for a labor union, and a good part of that time I spent training workers out in the field. One thing you understand very quickly when you do that is the differing power relationships in workplaces. You can train workers or employers all you want. I mean, workers will understand how much water they need, how much rest they need, how much acclimatization they need, but they mostly have zero control over any of that. They can't, as Debbie said, can't just take a break anytime they want. They can't just go get water anytime they want. They can't acclimatize themselves because that's not within their control. So they don't have again, all the training in the world is great. People need to understand what the factors are. But if you don't have, as a worker, if you don't have control over whether you can implement any of those, they're fairly worthless. Again, you can train employers too, and it's great. I mean, I think the more training, the better. And I think it's important that the OSHA standard not only requires the training of workers, but also the training of employers. But again, unless there's nothing there requiring employers to implement those, the factors that are stressed in the training, it's fairly worthless. So training, as Debbie said, is very important. It's necessary. It's essential, but it's not sufficient to really solve the problem unless you actually have requirements there that require employers to actually implement the factors in the training.
Shanae Arbery with the AFL-CIO. My final question, since you're all hinting at this, so why are workers particularly at risk from heat hazards more so than the average citizen?
This is Jordan Barab. I think the main reason is going back to what I just said. Workers don't have control over their lives at work in general. I mean, if they're in a union, they have a lot more control than if they're not. But as we know, the vast majority of American workers do not belong in unions and do not work under union contracts. So I can go out from my air-conditioned house to go to the store and walk all the way to my air-conditioned car and then go into an air-conditioned supermarket. And if I'm out, walking the dogs, I can cut that short and come back home to my air-conditioned house. Workers do not have that option. They are in their workplaces 8 or 10 or 12 hours a day. Without a standard like this, they have no control. They can't just, go get in an air-conditioned vehicle or an air-conditioned rest area unless the employer, is enlightened and lets them do that. And we know a lot of employers do that, but there are still far too many who don't. So I think that is the major factor that, whereas everybody is subjected to heat if they go outside, or if unfortunately they don't have air conditioning, there are options that you have if you're not a worker that workers who have little control over working conditions in their workplace just don't have.
And if I can add, this is David Michaels, the other component of work for many of the nation's workers is that work is strenuous. That it's not simply sitting in office, though at a high enough temperature and humidity, that alone can be dangerous. But the hard work that's done by agricultural workers, by construction workers, by workers on the tarmac who are unloading luggage, or who are in cemeteries digging holes, this adds to the risk of extreme heat. When I refer to the work rest matrix that the Army used for healthy young soldiers in Afghanistan and Iraq, where it got very hot, there were categories for the most strenuous work. That's something that employers need to think about and consider. It's obviously somewhat complicated, and strenuousness can't be easily measured in a totally objective way, but it's pretty clear that if you're doing work which even in non-heat works up a sweat, then in heat situations is going to be particularly dangerous. And that's what's different about this than just saying that heat is a risk to anybody who's in the United States. That's a risk to everybody, sort of like a virus that's going on. It's totally different. Work is strenuous, and that strenuousness greatly increases the risk of injury, illness, and death.
Okay, Ms. Arbery, is that all?
Yes, thank you so much, Your Honor.
Okay, thank you. Mr. Roberts, who's next, please?
All right, we have Mr. Mark Friedman.
Okay, thank you. Mr. Friedman, please identify yourself and your affiliation for the record.
Hi, good morning. I'm Mark Friedman with the U.S. Chamber of Commerce. Good morning, Dr. Michaels. Been a while since we've interacted. My question to you is the idea that you seem to concede that flexibility is desirable. You've noted several times that the OSHA standard is flexible. I'd like you to help me understand how you see it as flexible. The way I read the proposal, it doesn't allow for any variations in location or nature of jobs or employers or any of the other things that we would likely consider indicia of flexibility. So help me out. How is the OSHA proposal flexible?
Well, Mr. Friedman, it's always nice to see you. You can't see me because we're having technical difficulties, but you can hear me. No, I mean, the ability to select different engineering controls, for example, the use of fans at various points. There's flexibility. It gives employers the ability to think about how are we going to make sure workers are cool. Is one example. There are certain things that are biological or physical facts. Temperature reading is something that I don't think lends itself to flexibility, because employers need to know at what point do certain controls are they triggered, and that's really what that does. But it gives employers some ability to think about how they're going to address these differently to make sure workers are safe.
If I could add one thing there, Mark, good to see you again as well.
And who are you?
I'm sorry. My name is Jordan Barab. You mentioned also flexibility in terms of location. Now this continues to puzzle me on the location argument. We've heard that over and over again. Witnesses have said, well, it's much more humid in the South than it is in the North. But we all know that the heat index actually takes humidity into account. Workers may be more, workers, whether they're in the North or South, need, climatization. And while it's true that workers in the South and hot states may tend to be more acclimatized than workers in northern states, the fact is that the OSHA standard provides flexibility for that by exempting workers who can show that they've been working in similar jobs and under similar conditions for the last 14 days. So I just don't see any justification for any kind of geographical differences or geographical quote unquote flexibility in the standard. All that is taken into account by the measures and by the requirements and whatever exemptions are in the standard already or in the proposal already.
Okay. I mean, my feeling is I don't think.
Your name again, sir?
My name is still Mark Friedman. I'm still with the U.S. Chamber of Commerce. I guess we're going to have this debate going forward, and you guys have your views on whether this is flexible, and I think we're going to have our views on whether it is or is not. So we'll continue that discussion, I think. One other question I had for Dr. Michaels, and I think this is specific to him. You've talked about your experiences with the Deepwater Horizon disaster, and you were very aware of the problems with heat and heat exposure. I'm curious why you didn't initiate a rulemaking during the time that you were running OSHA.
That is a really good question. Essentially, to be frank, we didn't have the bandwidth. The OSHA standard setting body office is relatively small. We are putting all of our resources into standard for silica exposure. Workers were, that affects more than 1 million workers.
I remember that one.
And we knew that as we every OSHA standard has to be letter perfect with extensive studies, because we know organizations like yours take OSHA to court, and every I has to be dotted, every T has to be crossed in order to ensure that we've answered every single comment and query. And it's hard work and it requires a lot of resources. And the OSHA silica standard was 600 Federal Register pages, which is 1,800 manuscript pages. The standard actually is very short, but all the supporting documents to show that you've considered every one of these issues. And we looked at heat and we said, we didn't have the strength then to do it. And so therefore we said, we need to do something. So we launched this Water, Rest, and Shade campaign, which we thought was useful and effective, but in a limited way. We think it definitely encouraged employers to do the right thing, and some did, but we also evaluated to say it was not as adequate as the standard. Perhaps what we should have done was initiated rulemaking to say at least it's on the regulatory agenda, but we didn't do that, and I regret that. I think the climate things have gotten really very pressing. Every summer is getting warmer, and we really need to address the issue of heat now.
One other thought along those lines, you did make a big push for your I2P2 effort, the Injury and Illness Prevention Program standard, which would have been the all-encompassing workplace health, the workplace safety program. Had that gone through, I have to wonder how it would have addressed heat. And whether, in fact, at that point, you would have been looking at something more like a performance-oriented approach to heat.
Yeah, I think this is an interesting discussion, probably something we should have a beer over. But the decision was made at a higher level than me to focus primarily on silica and not the I2P2. And therefore, we had limited resources. They went into silica. We issued what I think is a very important standard. And I think it's time for OSHA to move forward and issue both a heat standard, and I would like to see an injury and illness prevention program standard as well.
So just to complete the thought, if the I2P2, I'm sorry, that's just still Mark Friedman, I'm still with the chamber. If the I2P2 program had gone through, I have to imagine you would have expected heat to be included. And yet it wouldn't have had any of the specification requirements that the current proposal had. Would you have been satisfied at that point with heat being included under an I2P2 approach?
Well, this is sort of the, I'm sorry, this is David Michaels, and this is one of these necessary but not sufficient. Every employer should have a plan to address injuries and illnesses, and that would include heat as well as silica and standard and other hazards that OSHA has a standard for, and hazards that OSHA doesn't have a standard for. But standards still have a very important role. You wouldn't say we don't need a silica standard because every employer has to include silica in their injury and illness prevention plan. So while it would again move some employers forward to do the right thing, you still need those programmatic components for important hazards, and heat certainly would be one of them. So if this is obviously, I'm not sure, speculation, but just thinking about what might have happened, but if we had an injury and illness prevention program standard, a requirement that every employer do that, which is a requirement, for example, in most other developed countries, I think you would still want to have a heat standard, but it would also tell employers on the way to do that you have to consider heat and think about how you're going to make sure workers are protected. And once you had a heat standard, employers would say, okay, how are we going to meet that heat standard?
And this is Jordan Barrett.
I apologize. I if you need one moment to respond, that's okay. But I do need to start moving us along. We have 3 more witnesses before lunch. And so
I've had my fill, Your Honor. Thank you.
Okay. Thank you, Mr. Friedman. Mr. Barab, do you need to respond or are we good?
Very shortly, this is Jordan Barab. You have to look also at California, which has an I2P2 standard, but also has felt the need, and I think we've seen the usefulness in issuing a number of other standards there covering heat, workplace violence, infectious diseases, and a number of other hazards.
Thank you. Okay, Mr. Roberts, who is our last online participant with questions?
So we have Mr. Parsons, Travis Parsons.
Okay.
Mr. Parsons.
Mr. Parsons, please identify yourself and your affiliation.
Travis Parsons with the Labor's Health and Safety Fund of North America. Can you hear me?
Yes, go ahead.
Yeah, because my connection was a little sketchy earlier, so it's gotten a little bit better, maybe the weather. But anyways, kind of along the same lines of the previous discussion, and this is for David Michaels and anybody else on the panel, because you all work together in the same administration. In your tenure of setting standards at OSHA, have you ever heard this whole argument about one size fits all approach for other OSHA standards, and that it's going to put people out of business? And could you expand on that one size fits all idea?
David Michaels here. Thanks, Mr. Parsons. Yes, we always hear that. That's comes right out of the playbook of people who don't want to see OSHA standards, because you could cut and dice OSHA standards for every different industry, for every different condition. OSHA sometimes looks at some industries and says, well, we need a special standard, for example, in construction, because construction has silica exposure very different than manufacturing, and the processes are different. But heat really requires the same approaches. We're talking about how to protect individuals from these environmental conditions that will affect them. And we're not talking about the way the work is done. We're talking about how the worker is protected. And so in this case, really one size does fit all.
Thank you.
Anything else from our other panelists?
Oh, this is Debbie Berkowitz. I just want to agree with Dr. Michaels and that, and we've seen it in other states like California, which is a huge state, in Oregon, where you have one standard and all employers are able to adopt it to their specifics. As opposed to a standard just on grain dust, which just affects certain employers that have a grain dust in them. But, in the end, the standard only affects you if heat is an issue in your workplace.
Thank you very much.
Mr. Parsons, anything else?
Nope, that's it. Thank you.
Thank you. Okay, I think that was it for questions. Yes, Mr. Roberts?
There is one more person with a raised hand in the queue.
Okay.
Mr. Mickey Siegel de Hernandez.
Hi, this is Mickey Siegel de Hernandez. I have a question that's related to.
Could you please, I apologize, could you please keep your voice up because it's a little bit hard to hear you, and just identify any affiliation you have?
Sure. This is Mickey Siegel de Hernandez, and I'm from the Communications Workers of America. My question for any of the panelists is regarding Section F of the proposed standard, the requirements at or above the high heat trigger, specifically regarding the observation for signs and symptoms for employees who are alone at a work site. And OSHA gives some options about the employer maintaining a means of effective two-way communications and contact being made with employees at least every 2 hours. My question is, can you comment on the feasibility of this? And do you have any examples from the work that you have done as part of OSHA, or what you have seen for remote and lone workers?
And Mickey, hi, this is Jordan Barab. I don't have any specific knowledge of that. I do have some knowledge with, in general, with workers alone. Again, I've worked with, workers, AFSCME members, for example, who worked out on their own in housing developments or other places where they were working alone in rather dangerous environments, all the way back into the 1980s before there were cell phones. And it was really difficult back then to communicate with these workers and our members. Cell phones have made a major change in that, and that you can, get in touch with workers at any time. There are all kinds of different, electronic communication devices that can be used even where cell phones don't necessarily reach. So I think technologically, it certainly is feasible to do that.
Your Honor, this is Jennifer Levin from the Solicitor's Office. Just wanted to remind the witnesses that they can supplement their comments with post-hearing comments if they think of any responses to this question or other questions, just in the interest of time.
Thank you. Okay, Ms. Hernandez, anything else?
No, that was my question. And thank you, Jordan, for your answer.
Thank you. All right, I believe that's all with questions for these panelists. So thank you very much, Dr. Michaels, Mr. Barab, Ms. Berkowitz. We appreciate your time. And let's go ahead and move to our next witness.
Your Honor, our next witness is Ellen Widas. It does not appear Ms. Widas is in the attendee list, so I would just request if she is logged in under an alternative name, if she could raise her hand. And if not, then I assume we're okay to move to the next witness, Miss Michelle Garner-Jana from What Works Institute.
Yes. Ms. Garner-Jana, do we have you?
Yes, she's coming now.
Are you able to hear me?
Yes.
Okay. Hi, thank you.
Please go ahead and state your name and affiliation.
Hi, yes, my name is Michelle Garner-Jana, and I'm the Chief Experience Officer and co-founder of the What Works Institute. So good morning, members of the panel and fellow participants. I'm honored to be here today and appreciate the opportunity to share a few comments on the proposed federal heat standard. First, I'd like to express my sincere appreciation to OSHA for putting together this proposed standard. It represents a truly meaningful step in protecting workers across the country from the very real risks of heat stress and heat-related illness. I know a tremendous amount of thought and effort has gone into this work, and I want to acknowledge and thank the agency for its commitment to worker health and safety. This standard has the potential to be transformational, especially for industries and regions that are increasingly impacted by extreme heat. A consistent national approach will help ensure that all workers, regardless of where they are or the jobs that they do, are safeguarded in environments that can sometimes be unpredictable and unforgiving. On behalf of the What Works Institute and the member companies we work with, I submitted written comments that reflect a variety of industry perspectives. The goal of these comments is to offer ideas that we believe can help make the standard more workable for employers without losing sight of the core priority, which is keeping workers safe. In the time I have today, I'd like to share a few of the high-level key themes from those comments. First, embracing technology for monitoring. The ability to use remote monitoring tools, particularly for hazard identification and response, can be a game changer. These technologies can offer real-time data and provide another layer of protection, especially in more isolated or dynamic settings. 2, practical approaches to observation and rest breaks. We've suggested a bit more flexibility in how high heat observation and rest break requirements are applied. For instance, in small team settings, allowing employees to watch out for one another rather than requiring strict buddy systems can reflect how teams already function safely and effectively. Similarly, many employees already take rest breaks when needed, supported by training and good communication. Acknowledging these practices could help ease implementation without sacrificing safety. Third, acclimatization considerations. This is an area where a one-size-fits-all approach can be difficult to apply. Workload, worksite conditions, and employment types like temporary or rotating workers, for example, can all influence how acclimatization happens. We've recommended building in some flexibility here to help make the requirements more practical across different industries. Fourth, drawing on lessons from California and other jurisdictions. California's experience has taught us a lot. We believe that there are helpful elements that could inform the federal approach, such as how water quantity is defined or how indoor cool down areas are described. Clear definition and consistent language can really help with compliance and understanding. And fifth, a few clarifications we hope can be considered. We've also asked for a few clarifications, such as allowing safety committees to gather worker input, recognizing alternative monitoring methods besides WBGT, and defining what counts as emergency response activities under the rule. These clarifications can help reduce confusion and support better implementation. In closing, I just want to reiterate my thanks to OSHA and to everyone who has been part of this process. The proposed standard is a critical and positive step forward. We hope these comments are received in the spirit they're intended, as thoughtful suggestions to help ensure the final rule is as effective and achievable as possible for the broad range of workplaces it will impact. Thank you again for your time and for the opportunity to share these perspectives.
Thank you. Mr. Levinson, any questions from OSHA?
Yes, Your Honor. Andrew Levinson for OSHA. Thank you very much for your testimony, ma'am, and for your NPRM comments. So as you've identified, OSHA has heard from a lot of folks the desire for more flexibility and a performance-oriented approach. Do you have thoughts on how the agency could address either rest breaks or heat triggers or other sorts of issues to offer more flexibility while still having something that is adequately protective?
Yeah, great question. This is Michelle Garner-Jana with What Works Institute. Yeah, so in the feedback that we've received from various organizations across industries, the request has really been around allowing for an approach that looks at the specific work that's being performed along with the environmental and personal conditions. So using technology to help to understand the task-specific conditions that are occurring, as well as things like wearables, for example, to understand how they're impacting the individuals. So flexibility is certainly appreciated, but while still allowing for organizations to understand the critical conditions that are occurring for given tasks. So even within an organization, at times, it may require a detailed analysis to come up with the correct protective requirements.
Thank you. Further expanding upon the use of technology and wearables, either now or in post-hearing comments, do any of your members have experience with wearables, and how do they use them to assure that workers are adequately protected? And in particular, what I'm looking at is the tension between using wearables that people might to indicate what's physiologically going on with that individual worker compared to heat triggers that might be going on in the environment, and how you could use that to inform decision making in a workplace.
Right. And I only have a handful of examples on using wearables for the physiological aspects, but some that we've received good feedback around are related to understanding dehydration before it actually becomes an issue. So, wearables that allow for the detection of things like sweat monitoring, for example, that provide a cue. Usually it's an audio cue of when employees should stop and take a water break, for example. So we've had some good feedback on some of the physiological aspects. And then from the environment, I don't have good information on how environmental wearables are correlating with the physiological. But I think that's certainly a good question and something that I can try to research within our member organizations more.
Yeah, thank you. My last question, I guess, refines the point that I'm trying to make. For example, so I guess let me ask a kind of multi-part question. We're interested in your members' experience with cooling PPE or other sorts of technology to reduce workers' risk. And so what I'm getting at with the wearables compared to the environmental exposure is, for example, if somebody was wearing cooling PPE, their wearable might suggest that the worker is not at risk because the cooling PPE is effective, while the environmental measurements might say this person is above the heat trigger, right? And so there's this tension. The wearables arguably would say this is what's biologically affecting the worker. So that's what I'm looking for, is any experience your members have with cooling PPE, and or if using wearables and other measures such as cooling PPE allows them to work differently than would be suggested by an environmental trigger.
That's a great question. And unfortunately, I don't have statistical data or any even anecdotal data about the correlation between those two types. But
sounds like that might be a good candidate for post-hearing comments.
Absolutely. Yeah, I'm happy to go back to our members and determine if that's an issue or if it's if it's something that has actually worked congruently. So, great question.
Thank you very much. And Your Honor, that concludes OSHA's questions for the witness.
Thank you. Ms. Levin, any questions from the solicitor's office?
And for Levin from the solicitor's office, I have no questions for this witness, but thank you very much for your time and testimony.
Thank you.
Thank you. Mr. Roberts, do we have any other online questions?
Your Honor, there are no online questions.
Then Ms. Garner-Jana, I just want to say thank you very much for your time. We appreciate you being here and sharing your testimony.
Thank you.
And Mr. Roberts, I believe we can move on to our next witness.
Yes, Your Honor, the next speaker will be Ruth Wilkinson from the Institution of Occupational Safety and Health. Ms. Wilkinson, please state your name and affiliation.
Hi, I'm Ruth Wilkinson from the Institution of Occupational Safety and Health. Good morning, Your Honour, and distinguished members of the subcommittee. Thank you for the opportunity to speak at this important public hearing on OSHA's proposed rule for heat injury and illness prevention in outdoor and indoor work settings. So, as mentioned, I am Ruth Wilkinson. My role is the Head of Policy and Public Affairs at the Institution of Occupational Safety and Health, which I will refer to it as OSHA. We are the chartered body for occupational safety and health professionals. We have approximately 50,000 members in 130 countries, which includes the US, and we have a vision of a safe and healthy world of work. Next slide, please. As an international non-profit organisation, we ethically influence important decisions that affect the safety, health and well-being of people at work worldwide. We responsibly collaborate with governments, advise policymakers, commission research, set standards, engage with global, regional and local organisations, and run high-profile campaigns to promote awareness of occupational safety and health issues. Next slide, please. So on this slide, you can just see some of the global collaborations that we have in place and different memorandums of understanding. We've also got special consultative status with the United Nations Economic and Social Council. Next slide, please. So OSHA is also a liaison member of ISO TC 283, which looks at health and safety management in the international standard setting remit. And currently, this group is looking at an ISO standard 45007, which is titled Occupational Health and Safety Management, Occupational Health and Safety Risks Arising from Climate Change and Climate Action, providing guidelines for organisations. And this document is due for publication this year, and it will provide guidelines for organisations and professionals to plan for and address occupational health and safety risks arising from climate change and climate action, which will include occupational health and safety risks which arise as a result of climate change adaptation efforts, changing ways of working, of work processes and infrastructure upgrades. Obviously, not forgetting that there are also other standards internationally available, such as ISO 45001, looking at good occupational health and safety management systems, but also the good principles of health and safety generally, which includes principles of prevention and the hierarchy of control, which can also be applied to this topic. Next slide, please. And I'll go to the next slide. I'm just going to skip on from that one, please. Lovely, thank you. At OSHA, we're deeply concerned about the growing risks posed by excessive heat in both outdoor and indoor workplaces. The organisation I represent has been actively involved in research and campaigning to address the risks of solar radiation and occupational cancers, particularly in outdoor workers. And we've provided a number of resources for employers, such as toolkits, posters, training materials that can help organisations implement sun safety policies, but can also introduce educational resources that emphasises the change in attitudes and behaviours around sun protection that is also needed, especially in sectors like construction, agriculture and landscaping. So there's a few illustrations on the slide here, but all this information is available on our OSHA website. So I intend to provide this testimony today to highlight the urgent need for an enforceable standard to highlight the vital role of occupational safety and health professionals that we can also play a part, as well as employers. So we need to support the development of a comprehensive, equitable protections that reflect the realities of the labour force today. And if this rule is progressed in the right direction, it could represent a critical step towards protecting all workers, with my emphasis being on all workers. So this piece of work obviously started with the Biden administration and it's continuing at the moment with the Trump administration. So the bipartisan momentum in this space of occupational safety and health, particularly around heat illness and injury, is obviously unprecedented, and it reflects a shared understanding that excessive heat is a growing and urgent threat to workers' health and safety, and especially in the face of climate change. Workers across industries from agriculture, construction to warehousing and delivery are increasingly exposed to dangerous temperatures and often without adequate protections. I think the data is speaking for itself and the statistics here. So I'm here today to support the development of a strong, enforceable standard that prioritises the welfare of all workers and helps levelling the playing field, and particularly for vulnerable workers and for all American workers. And just as OSHA's asbestos standard became a landmark in occupational safety and health, saving thousands of lives by preventing long latency diseases, and often appears decades after exposures, the proposed heat stress rule has the potential to be a defining public health achievement of this era, especially as climate change intensifies heat risks. So by learning from the success of the asbestos regulation, OSHA can craft a heat standard that is both life-saving and equitable. So distinguished members, heat is now the leading cause of weather-related deaths in the US, with thousands more suffering illness. I believe some of the previous hearings have not had a strong emphasis on vulnerable working populations. I'd like to address this gap, if I may. So young workers tend to go off the radar because of their physiological vulnerability and their lack of experience. Migrant workers can also be highly impacted and vulnerable to the health impacts of prolonged exposure to extreme heat. When it comes to professional sectors, workers involved in labour-intensive physical activity, such as working in agriculture, forestry, public spaces, road repair, fisheries, construction, mining, quarrying, and so on, should be provided with enhanced protections. And special attention should be given to these workers being employed in states where prevalence of heat stress is critical, such as Texas, Mississippi, and Florida. Indoor workers continue to be at risk of heat stress that may increase during heat waves, especially those who work in poorly cooled buildings, in cabin-operated machinery without cooling, and in settings with high industrial heat production, and those who carry out heavy physical work, as well as those who might be using personal protective equipment in hot conditions. So it's important that we look at both those indoor and outdoor workers. Another aspect that we would like to draw the committee's attention to is the urgent need for the US occupational health system to evolve the reactive crisis management to proactive heat resilience. Many American workplaces still lack on-site occupational health service, especially in small and rural areas. Especially in small businesses and rural areas. The numbers of occupational physicians are insufficient to meet the needs of millions of workers, especially in rural and high-risk industries. This limits early detection and prevention of heat-related illness. So we're really coming at this from a prevention-led approach. The proposed rule underestimates the critical role of occupational safety and health professionals and the role that they can play in helping organisations manage climate-related occupational safety and health risks. These professionals, if I go next slide, please. And next slide, please. And next slide, please. Sorry, next slide, please. There we go, thank you. So these professionals, the occupational safety and health professionals, bring essential expertise to support adaptation strategies, infrastructure upgrades, and the integration of climate considerations into risk assessments and emergency planning. They also enhance organisational preparedness by guiding health surveillance, heat action plans, and improving transparency around climate-related risks. A preventative approach to heat-related extremes calls for capacity building in occupational health and safety, occupational health programs, and occupational health surveillance. Good practice in pre-exposure screening and pre-employment assessments have the potential to identify people with permanent and long-standing medical conditions that might mean that they're not suited for physically demanding work in extreme heat conditions. As part of this process, occupational health monitoring and self-assessment becomes critical, but without the foundation of a federal standard, thousands of workers could be left vulnerable. So we agree that the proposal shouldn't constitute a growing burden placed on American employers and workers. On the contrary, regulators must acknowledge the toll of inaction. Each year, extreme heat leads to preventable injuries, fatalities, and billions of time lost in productivity, especially in outdoor and labour-intensive industries. It is for this reason that we welcome this OSHA initiative to mandate written heat illness and prevention plans. We see this as a critical step forward to safeguarding workers from the growing risk of heat exposure. However, we are particularly concerned about companies that may fall outside of the direct scope of this proposed rule. We cannot afford to place the burden of protection solely on employers, especially small businesses, which often operate with limited capacity, informal processes, lean management structures, and they don't always have competent occupational safety and health professionals either. That said, exclusion of them from the standard is also not the answer. Instead, the proposed rule should support small businesses in adapting to their unique circumstances. A practical recommendation is to incorporate flexibility through a pragmatic approach, one that allows small employers to tailor their heat illness prevention programs to the specific resources, workforce, and operational realities that they face. So this rule of this nature can only succeed if it actively promotes education and awareness among both employers and workers about the dangers of heat stress. And it must include specialised training for those working in extreme heat conditions and support the development and dissemination of sector-specific guidance. I've got 3 points I'd like to highlight about how this rule can be effective. So 1, technical assistance to employers for emergency planning and implementation. 2, to provide clear identification of heat-related illness and high-risk worker groups. And 3, accessible information on prevention strategies and protective measures. So we therefore recommend the establishment of a national training programme for employers and workers, supported by the technical expertise of occupational safety and health professionals. We see that these programs should guide employers in preparing, reviewing, and continuously improving their policies, procedures, and practices for those who are working in high heat conditions. So at OSHA, we look forward to continuing our contribution to this vital dialogue, and thank you once again for the opportunity and our 15 minutes to testify today. I now welcome any questions that you may have, and that the slides can come off the screen, so thank you ever so much.
Thank you, Ms. Wilkinson. Mr. Levinson, any questions from OSHA?
Yes, Your Honor. OSHA's first question comes from Stephen Scher.
Yes, hello, Stephen Shayer from OSHA Directorate of Standards and Guidance. First, thank you, Ms. Wilkinson, for your testimony. We appreciate you being here today. I had a question about your written comments. In the written comments you submitted to the agency, you recommended that acclimatization procedures be implemented within the course of a 10-day period. And one option that OSHA had proposed for acclimatization for new workers was a gradual exposure option, where exposure to the heat increases by 20% per day. So just wondering, either now or in your post-hearing comments, if you could explain how acclimatization over a 10-day period would be preferable to what was proposed.
Yes, thank you ever so much for that question. I think the importance here is that this standard is based on the evidence and the research provided. So on that basis, I would like to take the opportunity to respond to this one outside of the hearing, the post-hearing comments, to make sure that it's a full answer and that we can guide and confirm our thinking on this one. So thank you, Stephen. Thank you.
Sure, that would be great. Thank you, Ms. Wilkinson. That concludes my question, Andy.
All right. Your Honor, the next question from OSHA comes from Eduardo Hernandez.
Hi, Ms. Wilkinson. Good morning. Eduardo Hernandez, Standards and Guidance, OSHA. So one, if you have any examples of your campaign materials around heat that you would be willing to submit in post-hearing comments, we'd definitely appreciate that. And I have one question on the heat injury and illness prevention plan. And again, it focuses on your written comment. So you expressed concerns for the exemption for small employers from the written plan, and reiterated that those workers would be unprotected by the proposed standard. So, but you also kind of mentioned that OSHA should allow for a, quote, maneuver margin by providing flexibility with a programmatic approach for those small businesses to be able to tailor their plans to their circumstances, end quote. So what elements of the HIP could be more programmatic in nature for small businesses if OSHA were to require a written HIP?
Oh, thank you, Eduardo. So I suppose coming to your first point about examples of campaign material, we'll be more than happy to share those. A lot of the material came under our No Time to Lose campaign, but we've got a wealth of evidence and research that's looked into solar radiation where workers are working out in the sun, but also some of the tools that have been there. So I will submit those. And I suppose coming to your second question around the prevention plan and those small, medium enterprises, we do see that this section of businesses, they are sort of that harder to reach, and how do you support, given that for all the reasons that I've just mentioned, really. And it's, I suppose that's the key bit that we'd like to hit. As you can see, that I think the bulk of individuals, and I think it's sort of 80% we said in our written submission, hitting that SME market. And again, I will come back, Eduardo, with some examples here, but I think where that proportionate response and that flexibility and the amount of guidance and training that you can support these organisations to implement the good practice, you know, sort of following on from all the conversations that people have said. And I know that the ILO, the International Labour Organization, have done some research on this as well, and even said where in small, medium enterprises you can use sort of the wet bulb globe option. So I will look to compile all those together and we'll submit in the post-hearing feedback if that's okay as well. Thank you.
Yes, thank you so much. That's it for me.
And Your Honor, OSHA's next question comes from Tiffany Defoe.
Hi, for the record, this is Tiffany Defoe with the Directorate of Standards and Guidance, OSHA. So firstly, in your written comments, you made you made recommendations, as we mentioned previously, about acclimatization, and then just immediately following your recommendation for a gradual adjustment, there, you stated that a similar approach could be considered based on NIOSH and CDC evidence to accommodate the proposed 15-minute rest ratio as temperature levels increase. And I'm just asking, either now or in post-hearing comments, if you could expand a little bit on what you are recommending that we consider doing, because I apologize, but I'm just not, I don't think that I'm fully understanding what you're intending to recommend.
No,
so any
thank
further
you.
detail would be great.
Oh, no, thank you, Tiffany. So I'll write that up in the post-hearing comments just to confirm on that and to also bring in the evidence that that's based on. So thank you.
And then I just wanted to, we already have asked you to provide further information about the flexibilities that may be appropriate for small and medium businesses. And I'd like to ask if you would include in that commentary specifically your thoughts about the appropriateness and how it might, and if appropriate, how it might feasibly be done to add flexibility to what we have proposed for the rest break requirements in the proposed standard.
Lovely. I will do. I'll add that to that submission piece as well. Thank you.
Thank you very much. That's all I have.
Thank you, Your Honor. The next question from OSHA comes from Patty Downs.
Hi, Patty Downs with the Directorate of Standards and Guidance at OSHA. Ms. Wilkerson, I'm interested in learning, are there any controls that OSHA should consider that were not mentioned in the proposal?
Yeah, good question. Thank you, Patty. And I think that having gone through, I mean, we come from that prevention first based approach to the hierarchy of control, and having looked at the standard, although we have highlighted areas where we think it can be improved, such as all the questions that I've just sort of had posed to me, I think in the main it does follow the control measures that one would expect to see in there. Obviously, the challenge is in the delivery, the enforcement, the implementation, as we've just mentioned, with the majority of businesses being small, medium, and enterprises. So how we support that. So what we really advocate for is that prevention first approach comes through in the first main, and then obviously following that hierarchy of control that you do implement that. So, and the key bit is around that education and training and those collective control measures. So that there's the climate change, so the adaptation methods that you can put into the times of working, the times in the day, the breaks, the rest periods, are then those cooling hours. So I think that's all covered, and it's how that then comes out and that gets communicated and educated to all the key players, from workers to the employers, and also toolkits that can help support this to be implemented. And again, in our research, I know when we've looked into sun safety, I know one of our research areas looked at how technological tools could support some of that education and behavioural change. So again, in our written submission, I'll look to pull some of that out as well.
That would be great. Thank you so much. That's all for me, Andy.
Your Honor, that concludes OSHA's questions.
Thank you. Ms. Levin, anything from the solicitor's office?
Yes, at this time, I'd like to request that the PowerPoint presentation by the Institution for Occupational Safety and Health be admitted into the record as Exhibit 12.
It will be admitted.
Thank you. No further questions from me. Thank you very much to the witness for her time and testimony.
Thank you ever so much.
Your Honor, you're on mute.
It's hard to remember. Do we have any other questions from online participants?
We have no questions from the online participants.
Okay. Then Ms. Wilkinson, I just want to say thank you very much for your testimony. We appreciate your time today.
Well, thank you, Your Honour. Thank you, everybody else, panelists and committee.
Is there anything else before we adjourn for the lunch break?
Your Honor, there's been a request if we could maybe try and call Miss Ellen Wides again. We don't see her, but maybe if she is here, if that's okay with you.
Sure. Yes. Ms. Wides, if you're there, please make yourself known.
Your Honor, since it appears Ms. Wideness is not making herself known, just for the record, that if she has any post-hearing comments, we are certainly welcome to receive them, as she has filed a timely notice of intent to appear.
Thank you. Anything else?
Nothing from me, Your Honor.
Okay. And it sounds like we are finished with our morning session, so we are adjourned. We can go off the record. We'll be on lunch break until 1 o'clock, and we will reconvene and resume the proceedings at that time. Thank you, everybody.
This is Drew Roberts from OSHA as OSHA's contractor. It is 1 p.m. Eastern Time, and we are rejoining OSHA's informal rulemaking hearing for heat, injury, and illness prevention in outdoor and indoor work settings. Before we begin, we'd like to go over some logistics for today's public hearing. As a reminder, all attendees are muted automatically. All WebEx attendees can access closed captioning and translate the captioning by clicking the CC icon in the lower left-hand corner of the application. You can individually select your caption language if translation is required. I will now share the same slide in Spanish. All YouTube viewers will have access to auto translation the day after the hearing. All WebEx attendees delivering testimony will have access to a countdown timer to ensure allotted time is adhered to. We will launch the timer for you, and it should be seen on the right-hand side of your screen. If you do not see this app when launched in your WebEx window, please follow the instructions on the screen to manually launch this app. If you are speaking today, you will receive a notification on your screen that you are being promoted to the panelist group a few minutes before it is time to give your testimony. Once promoted to the panelist role, you'll be able to unmute and turn on your camera. We ask that you do not unmute or turn on your camera until your name has been called and you've been asked to start your testimony. Speakers connected by telephone should unmute their phones when called to testify. If you submitted a presentation in advance, we will share the file and advance the slides. Please cue us verbally by saying next slide when you need us to advance. Dependent on timing, there may be the opportunity to ask questions of other speakers giving testimony. You may press the raise hand button at the bottom of the WebEx application to indicate that you have a question. If there is time, you'll be called on by name and promoted to the panelist group to unmute and ask your question. If you have any technical difficulties, please send an email with your name and phone number to public_hearing@abtassoc.com. Your Honor, do you want to say anything or shall I continue?
Nope. I think if we're ready to proceed with our remaining witness testimony, we can go ahead.
We'll continue with the testimony. The expecting speaking order is displayed on the screen. I will introduce each speaker in turn. The first speaker will be Ashley Gregor. Who I do not see in the list. So, Ms. Gregor, if you could raise your hand if you're under a different name.
I'm here.
Oh, you're already. Oh, look at that. You're already there. Please state your name and affiliation with the record.
Thank you. Good afternoon, and thank you for the opportunity to speak with you today. My name is Ashley Gregor, and I am an Assistant Attorney General in the Environmental Protection Bureau of the New York State Office of the Attorney General. Along with 15 other state attorneys general, New York submitted comments on OSHA's proposed rule, urging the agency to finalize its heat standard as soon as possible. In addition, New York has twice petitioned OSHA to issue emergency temporary standards to protect workers from extreme heat. And we've also called on Congress to pass legislation that would require OSHA to promulgate a heat standard. And New York may not be the first place that comes to mind when we think about extreme heat, but in our rapidly changing climate, no state is immune from dangerously high temperatures. In recent summers, New York has experienced sustained heat waves and oppressive humidity that imperil the health and safety of millions of our workers, from construction workers in Manhattan to farm workers upstate. Just earlier this week, much of New York State was under an extreme heat warning. On Tuesday, the heat index reached at least 111 degrees in New York City and 107 in Albany. But every year, across the United States, outdoor and indoor workers are exposed to dangerous levels of heat and humidity. And tragically, some of these workers never come home. Just last year, Wendy Johnson, a 20-year veteran of the U.S. Postal Service, died after delivering mail from a postal truck with no air conditioning during 95-degree heat. Ronald Silver, a 36-year-old solid waste worker in Baltimore, died from hyperthermia after working outdoors when the heat index was 108 degrees Fahrenheit. Unfortunately, these are not isolated events. Rather, they are the predictable and the preventable consequences of inaction. And while nothing can be done to bring these workers back, OSHA can take action to finalize the proposed rule to prevent these types of needless heat-related deaths from happening in the future. Today, I would like to underscore 3 key points from our multi-state comment letter in support of the proposed rule. First, we need a baseline national standard, and OSHA cannot wait for all 50 states to act on their own. Currently, a handful of states have adopted heat standards, and representatives from some of those states will testify later this afternoon. But others, including some of the most heat-vulnerable states, like Florida and Texas, have gone so far as to preempt local ordinances that would protect workers from extreme heat. That means that a worker in Miami or Houston has fewer protections than a worker doing the same job in the same temperatures in Los Angeles or San Diego. Extreme heat doesn't stop at state lines, and neither should basic workplace protections. New York is not an OSHA state plan state, so we depend on federal OSHA, not our State Department of Labor, to set and enforce safety standards for private sector workers. But in the absence of federal action on workplace heat, the New York State Legislature has been forced to try to fill the regulatory gap where federal OSHA should be leading. New York lawmakers have introduced the Temp Act, a bill that would require private employers to implement basic safeguards like water, rest, and shade during high heat conditions. But with competing legislative priorities, the bill has yet to pass. While the Temp Act is certainly commendable, our state legislature should not have to solve a problem that federal OSHA is uniquely equipped to handle. With its health and safety expertise and enforcement infrastructure already operating in New York, OSHA is best positioned to implement a heat standard to protect our workers, and OSHA should not abdicate its responsibility to do so. Second, reliance on existing enforcement mechanisms is not enough. Currently, OSHA relies on the General Duty Clause of the Occupational Safety and Health Act to enforce heat hazards, which requires a case-by-case showing that a recognized hazard existed. This approach is inefficient, it's legally vulnerable, and reactive rather than preventative. Plus, it disadvantages employers because without a defined standard, employers have no clear guidance on when and how to act. We need a clear, enforceable standard that allows OSHA to move proactively before a worker collapses from heat stress, not after. Third, OSHA must include strong record-keeping requirements in the final rule. Record-keeping is not a punitive or an administrative exercise. Rather, it's a knowledge-building tool that supports continuous improvement in employer practices to prevent future harm. That's why our multi-state coalition has urged OSHA to require comprehensive record-keeping as part of the final rule, including logs of all heat-related incidents, not just those that resulted in hospitalization, documentation of worksite temperatures, acclimatization procedures for new or returning workers, including for H-2A visa workers, and critically, a written heat injury and illness prevention plan that is regularly reviewed and improved as appropriate. In sum, OSHA has the obligation and the moral imperative to ensure that every worker in every state is protected from extreme heat. So let's not suffer through another summer of needless and preventable heat-related worker deaths. Thank you again for the opportunity to testify today, and I'll be happy to answer your questions.
Thank you. Mr. Levinson, any questions from OSHA?
Yes, Your Honor, thank you. And thank you, Ms. Greger, for your testimony today. OSHA throughout this hearing has heard from a number of groups that have called the current proposed regulation a one-size-fits-all standard and argued that we should have a more performance-oriented approach to give employers more flexibility in how they deal with temperature and rest breaks and other aspects of the rule. We're curious to hear your thoughts on whether or not OSHA should allow more flexibility, and if so, how, and what sorts of basic requirements should still be in order to assure workers are adequately protected.
Thank you for your question.
And I should offer, in addition to hearing what you have to say now, we also have a post-hearing written comment period. We're happy to hear either now or in post-hearing comments.
Thank you, Mr. Levinson, for your question. This is Ashley Greger speaking again. And I would like to submit post-hearing comments on that particular question. I do have a few initial thoughts about that, though. First of all, I do think that the proposed rule is inherently flexible. It does have basic protections. It has heat thresholds, and at certain thresholds, employers are required to provide basic protections like water, rest, and shade. But they do have flexibility about how to implement those protections, specifically through drafting their own heat injury and illness protection plan, which can include site-specific ways for the employees to stay safe during extreme heat conditions. And I would also say that human bodies are inherently the same. They react to heat in the same way. So I'd like to counter some of the testimony that we heard earlier. I'm thinking specifically of some testimony I heard last Friday that claimed that farm workers that are part of the H-2A temporary visa program are only here for a short period of time. So these employees are probably already acclimated to the heat. And that statement in particular, I think, is both scientifically flawed and it's dangerous. Acclimatization is not simply about where someone's from. It's about the specific environmental conditions that the worker is currently exposed to and how their body adapts to those conditions over time. So even if an H-2A temporary farm worker in New York has previously lived in a hot climate, they may not have performed intense physical labor outdoors in similar humidity in direct sunlight or at the same pace. So if someone comes from Central America and arrives in New York and begins picking apples for 8 to 10 hours a day, going up and down a ladder, possibly in full sun or in personal protective equipment, they will be physiologically unacclimated to those new stressors. So human bodies, they react to heat in the same way. Moreover, I think that making assumptions about workers' heat tolerances based on their country of origin, their race, or their ethnicity is not only unsupported by occupational health research, but it also risks reinforcing really discriminatory and exploitative labor practices. Heat illness is a physiological process, it's not a cultural trait. So all workers, regardless of where they're from, deserve evidence-based protections and basic protections such as water, rest, and shade. And I think that the proposed rule adequately provides for that.
Thank you. My next question is related, but a little bit more specific. A number of stakeholders have asked OSHA in particular to take the approach employed by Nevada, where they did not include many criteria, but instead relied upon a job hazard analysis by employers as the way of determining how and when to protect workers. Again, either now or in post-hearing comments, we would very much like to hear your thoughts on that particular approach by a state and what New York thinks about that.
Yes, so I would like the opportunity to comment in post-hearing comments on the Nevada rule. That rule was only finalized in April 2025, so we didn't get the chance to comment on that in our January comments. But I will say, just based on my read of the Nevada standard, I think that it's lacking in many respects. For example, it doesn't have a temperature threshold, so it allows employers to subjectively choose a threshold that would apply to their employees. The rest breaks are available only after a worker starts experiencing signs and symptoms of heat-related illness, which is wholly inadequate. We need a preventative standard. And moreover, the rest breaks aren't paid, so that disadvantages piece rate workers such as farm workers. And critically, there's no acclimatization required in the Nevada standard. So I think because of these provisions in the Nevada standard, it's lacking in enforceability. I don't see how they're going to enforce a rule like this. So generally, I do think that the Nevada standard is lacking, but I will provide more detailed comments in the post-hearing comment period.
Thank you. That concludes my questions. Our next question from OSHA comes from Tiffany Defoe.
Hi, this is Tiffany Defoe with the Directorate of Standards and Guidance, OSHA. I wanted to add, you've already addressed some of the questions that I had for you, but I do want to ask, earlier in the hearing, we've received a variety of comments that mandatory rest breaks at or above the high heat trigger in the proposed standard are not feasible for all workplaces, and recommending that OSHA should either remove those proposed requirements in any final rule or should add flexibility to the proposed timing schedule for mandatory scheduled rest breaks. And I'd like to ask either now or in post-hearing comments if your group would be willing to provide any thoughts you have on those two recommendations. for addressing some of the concerns that have been raised about flexibility in rest breaks.
Yes, again, I would be happy to address that in post-hearing comments. Many of our states do have mandatory rest breaks, and OSHA's proposed rule provides for mandatory rest breaks when the heat index is 90 degrees Fahrenheit. So that's talking about extreme heat conditions. And in preparing for our multi-state comments and preparing for this testimony, we spoke to a lot of workers who work in extreme heat and in these extreme heat conditions, and they generally do take rest breaks. So it seems that many workplaces, they do have the flexibility built in to be able to take rest breaks, especially during high heat conditions, to stay safe. But again, I will provide more commentary in post-hearing comments.
Thank you. I realize that you're already planning to provide some comments about the importance of, or I'm sorry, you stated the importance of giving rest breaks before the signs and symptoms of heat illness arise. But if you do comment on that in your post-hearing comments, any further discussion on why that is, why it's important to preempt even early signs, if you believe that's true.
Yes, we can provide more comments on that. And I do believe that's true to prevent heat-related illnesses before it happens. Many of the symptoms of heat-related illness are nonspecific. It may be things like dizziness or feeling weak. So it's important to be preventative before those kind of things come on, because workers may not know that they're experiencing a heat-related illness when they start to feel those nonspecific symptoms.
Thank you. That's all I have.
Your Honor, the last question from OSHA comes from, actually, it's not from an OSHA person. I think it's our solicitor, rather, will be asking the question. So I guess that concludes OSHA's questions. Let me turn it over to our solicitor.
Thank you, Andy. This is Linda Wiles from the Solicitor's Office. Thank you, Ms. McGregor, for being here today and for your testimony. I heard that in your testimony, you touched upon OSHA's current enforcement policy to protect workers against occupational heat under the General Duty Clause of the OSHA Act. And you noted that there are some challenges or shortcomings with this enforcement. During this hearing, we've heard alternatively from other witnesses that OSHA should continue to rely on the General Duty Clause instead of issuing a federal heat standard. I just would like to ask if you could elaborate either now or in post-hearing comments why you feel that the General Duty Clause is inadequate.
Sure, I can address that now. And this is also discussed on pages 31 to 32 of our written comments. So the General Duty Clause requires employers to provide a workplace that's free from recognized hazards that are causing or are likely to cause death or serious physical harm to employees. But the clause itself is ineffective as a primary mechanism to protect workers from extreme heat for a few different reasons. First, the clause is generally reactive. It's enforced after an injury, illness, or fatality has occurred, rather than requiring employers to implement proactive safety measures to prevent hazardous conditions. So this post hoc enforcement leaves workers vulnerable to entirely preventable outcomes. Second, the General Duty Clause is legally burdensome. To issue a citation under the clause, OSHA must demonstrate 4 individual elements, and these requirements make enforcement time-consuming and legally vulnerable. For instance, I'm sure you're familiar of the case Secretary of Labor v. A.H. Sturgill Roofing, Inc. That's on page 31 of our comments. And there, OSHA issued a citation to Sturgill under the General Duty Clause for exposing its employees to excessive heat after a 60-year-old man died on his first day on the job replacing a roof when the heat index was 85 degrees Fahrenheit. And the administrative law judge in that case affirmed the citation, but the Occupational Safety and Health Review Commission reversed, finding that despite this workplace death, OSHA failed to establish the existence of a hazard. So this demonstrates the inherent vulnerability of citations issued under the General Duty Clause. Third, the General Duty Clause lacks clarity for employers. Without a specific standard, employers have no clear benchmark for compliance. For example, some employers may not know when the heat index is high enough to warrant interventions or how long of a rest break is necessary, whereas a formal rule provides predictability and consistency, which the general duty clause simply cannot do. In fact, there's a footnote in the Sturgill roofing case that I mentioned where the Occupational Safety and Health Review Commission found that OSHA's reliance on the general duty clause often leaves employers confused as to what is required of them. So a standard, unlike the general duty clause, would clearly lay out what employers are required to do to protect their employees, and employees, on the other hand, know their rights. And finally, and relatedly, the general duty clause fails to send a strong regulatory signal. Specific OSHA standards can help to create compliance cultures. For example, they can lead to an employer investing in safety systems, or they can empower workers to recognize violations. So while the general duty clause is a useful backstop in some cases, it was never meant to stand in for a detailed, enforceable standard that's tailored to an occupational hazard like extreme heat.
Thank you so much, Ms. McGregor. That's all for me.
Mr. Roberts, do we have any questions from other online participants?
Your Honor, we have Mr. Jordan Barab in the queue. Barab, please state your name and affiliation.
Did you say Jordan Barab?
Yes.
Okay, that would be me. Okay, this is Jordan Barab. Ashley, thanks for your testimony. Got a few questions here. In your comments, you stated that OSHA's National Emphasis Program was not really a replacement for a comprehensive and preventive rule that's legally binding on employers. Can you elaborate on that?
Sure, thank you for the question, Jordan. And again, this is Ashley Greger speaking. Yes, in our comments, we mentioned that OSHA's National Emphasis Program, it's a meaningful interim measure for sure, but it's not a substitute for a comprehensive, enforceable federal heat standard. For one, the National Emphasis Program is not legally binding. So the program allows OSHA to prioritize inspections and enforcement related to heat, but it doesn't create any new obligations for employers. For example, under the National Emphasis Program, employers aren't required to provide water, rest, or shade or develop a written heat injury and illness protection plan. Additionally, enforcement under the National Emphasis Program relies on the General Duty Clause, which, as I discussed earlier, is insufficient to enforce workplace heat standards. And finally, the National Emphasis Program is an administrative program that OSHA could change or terminate at any time. So it's not nearly as durable as having a federal standard created through notice and comment rulemaking like this. So I think that reliance on the National Emphasis Program can leave worker protections vulnerable to shifting agency priorities or funding or changes in political leadership. So again, I think the National Emphasis Program is an important interim step, but it's inherently limited. So that's why we're calling on OSHA to finalize the proposed heat standard.
Okay, thank you. I know you all have been in contact with farm worker advocates in New York and farm workers. Can you tell me from those conversations, from your experience with those conversations, are farm workers always free to take a break anytime they feel they need it, or go grab some water somewhere?
Thanks, Jordan. And again, this is Ashley Greger speaking. Yes, my office did speak with some farm workers, both in preparation for the comments and in preparation for the testimony here today. We spoke with farm workers who work in tomato greenhouses, who work on fields and in dairy farms, both in central and western New York State. And in tomato greenhouses, the workers said that they spend their entire day under plastic coverings with very limited ventilation. So even though they're not exposed to direct sunlight, they still endure very high temperatures. And because of the fast-paced nature of their work and the fact that they're paid at the piece rate, rather than receiving an hourly wage, they don't have opportunities to take rest breaks. Similarly, farm workers who we spoke to who work in fields planting and harvesting fruits and vegetables under direct sunlight are generally provided no access to shade, and they have very limited opportunities to take rest breaks or take water breaks. Most of those workers, again, are paid based on how much they harvest, or they have to keep up with a moving tractor, leaving them no choice but to keep working. And then, sorry, go ahead.
Go ahead. Are you done?
And just finally, I'll mention the workers that we spoke to who work on dairy farms. The cows are actually housed in barns that have fans and sprinklers and drinking water to keep them cool. But the workers themselves, they don't have access to clean drinking water unless they bring it themselves. In the milking parlors in particular, they lack ventilation, so the heat generated by the cows, compounded by the tin or the metal roofs, can cause temperatures to rise to really unsafe levels. So these are just a few of the anecdotes that we collected that demonstrate the dangerous heat conditions for farm workers in New York State, and again, speak to the need for a really strong and enforceable federal standard.
Okay, one more. So, we're going through a major heat wave right now, and everybody suffers from the heat, walking the dogs, going to the store, gardening. Why are workers more vulnerable than everyone else to heat than the average citizen?
Well, everyone is vulnerable to heat, but workers are particularly more vulnerable due to the combined effects of ambient temperature and metabolic stress. So when you're working, for example, if you're a farm worker in a field, your body just builds up and retains more heat than someone just walking their dog on the sidewalk in New York City. But that does also remind me of the urban heat island effect. So workers in New York City who are working on construction sites are often exposed to greater temperatures than workers in more shaded or green areas. So that's another thing to take into consideration.
Okay, thank you. That's all I have.
Mr. Roberts, anybody else?
You have Miss Anastasia Crispin. Miss Crispin, please state your name for the record.
Yeah, I'm here. Can you hear me?
Yes.
Yes, thank you. This is Anastasia Crispin from the National Employment Law Project. Thank you, Ms. Greger, for your testimony. And we've heard repeatedly some assertions that different regions, workers experience heat in different ways, with the implication being in some places they're very used to it, in some places heat just doesn't really happen. And as you noted, New York is not a place people typically think of when they think of heat. And I really appreciated the anecdotal evidence you're just sharing. I'm just curious whether you could share now or later in your written follow-up if there's any other data or any other information about the scope of the problem in New York.
Thanks, Ms. Crispin, for your question. And again, this is Ashley Greger speaking. I can certainly provide more detailed information in written comments following the hearing, but I will say that there are 2 New York-specific reports that were published last year that have really excellent data. First, in September 2024, the New York City Office of the Comptroller issued a report called Safeguarding Outdoor Workers in a Changing Climate. And this is cited on page 24 of our comments. And the Comptroller's report estimates that 1.4 million New Yorkers, which is about a third of the city's workforce, spend significant time outdoors, including 170,000 workers with near constant outdoor exposure. Many of those workers are immigrants, they're people of color and low-wage earners working in jobs like construction, delivery, building maintenance, and street vending. So these workers often lack basic protection like access to restrooms, water, or shade, and they face heightened risks of heat-related illness and injury, especially during heat waves like we saw earlier this week and air quality emergencies. The Comptroller's Office report, it recommends concrete policy changes, including the promulgation of enforceable heat standards to address these inequities and protect New York City's workforce that is increasingly exposed to extreme heat. And the second report that I'll mention now was published in May 2024, and it's from the New York State Insurance Fund, and that's our state's largest workers' compensation insurer. And their report's called Insurance as a Catalyst for Climate Action, which is cited on pages 29 to 30 of our comments. And that report found that on days when the heat index in New York is above 80 degrees Fahrenheit, the likelihood of a workplace injury in New York increased by 45%, and the severity of those injuries rose by 20%. And these findings are not hypothetical. They're based on 95,000 workers' compensation claims from 2017 to 2021. And the report, again, underscores the need for a federal heat standard to reduce preventable harm. So I will also provide some more data in written comments following the hearing period.
Thank you. This is Anastasia Christman again. Thank you for that. And that's my only question. Thank you.
Thank you.
Thank you.
There are no further questions in the attendee queue.
Okay, then Ms. Gregor, thank you very much for your comments. We appreciate your time today.
Thank you.
And Mr. Roberts, could you please promote the next witness?
Next witness is Mr. Bob Harrison from the California Department of Public Health. Mr. Harrison, please state your name and affiliation for the record.
Good morning or afternoon, depending on where you may be. My name is Dr. Robert Harrison. I'm a physician from the University of California, San Francisco, and with the occupational health branch in the California Department of Public Health. And I'm here to express my strong support for OSHA's proposed heat injury and illness prevention rule. California successfully implemented the first outdoor heat regulation in the country in 2006. And then just last year, our state passed an indoor heat standard in July of 2024. I was on the standards board in California in 2006 when we passed the standard. And if anyone has any questions directed at our process or the success of our standard over the last almost 20 years, I'd be happy to answer questions or put it in the post-hearing comments. But the bottom line is that it's been, in my view, a very successful rule and has prevented many cases of heat illness and injury, fatalities. Back in 2006, we passed this because we had many heat-related deaths. We had an emergency standard. The water, rest, and shade triad actually comes from California, and a massive education and outreach campaign that we launched, and that was adopted by federal OSHA in their education and outreach tools, and now by several other states around the country. Many people are probably familiar with the most extreme health impacts of heat, but this really underestimates the real human toll. And we also know that heat wave drive increases in heart attacks, strokes, and severe complications from other chronic diseases such as diabetes. I've also been an occupational medicine physician for the last 40 years and have treated many cases of heat illness. And I've seen really firsthand how dangerous heat can be on the job, and these conditions that could have been prevented with basic protection like shade, water, and rest. In California, although our standard has been extremely successful and I would say quite practical and relatively easy to implement by employers across the state, we continue to have sporadic deaths. A landscaper new to the job who died from working in the heat, and a 51-year-old letter carrier who lost consciousness and later died from heat stroke. There are a few specific comments I wanted to make about underreporting and record keeping in the proposed standard. Our tracking of heat-related illnesses, injuries, and fatalities shows that there's a significant underreporting in existing administrative and surveillance data sets. And this happens for many reasons, including lack of awareness of heat illness, barriers to getting care, inadequate reporting mechanisms. And in addition, employers may fail to correlate cardiac problems, injuries, and other symptoms to heat illness. For example, we see many fatalities that are deemed cardiac, but where the medical examiner and coroner didn't recognize that heat also may have played a contributing factor. We also know that heat increases the risk of injuries, but our databases about injuries don't collect information about heat as a factor. There's also variability in how states collect and calculate rates of heat-related illness using workers' compensation data. Finally, we also agree with OSHA that incidence estimates that are calculated by using the entire US working population in the denominator really underestimates the true risk of heat-related illness, because these estimates include workers who are not exposed to heat. To address some of these problems with undercounting and reporting and get a true picture of heat-related illness, we recommend the following. First, a heat incidence log would help both employers and workers recognize and keep track of all heat-related illness, not just the most severe ones. In California, we've had for many years the bloodborne pathogen and workplace violence and healthcare standards that requires an incidence log that includes both OSHA recordable and non-recordable incidents. Second, we found that education about heat illness is one of the essential steps in protecting workers, because heat illness can progress very rapidly from very mild to very severe. OSHA should define the full spectrum of heat illness in the standard, ranging from heat cramps to heat stroke. And then finally, because many cases of heat illness go unreported, this applies even to the more severe cases that need emergency care. The final standard should specify that all heat-related cases be reported within 8 hours as part of OSHA's existing severe injury reporting regulation. In closing, I strongly support the proposed rule and urge OSHA to adopt and implement it as swiftly as possible. Thank you for prioritizing worker safety in the face of this growing climate threat.
Thank you. Any questions from OSHA, Mr. Levinson? You're on mute.
Sorry. Yes, Andrew Levinson for OSHA. Thank you, Your Honor. And Dr. Harrison, thank you very much for your testimony. One of the issues that's come up quite often in this hearing is employers who have asked for flexibility in heat triggers because of the perception that heat is different regionally. And we'd like very much your thoughts on the medical literature and or workers' experience of heat in different regions, and does the heat does a heat measure that accounts for both temperature and humidity adequately adjust, or is there some other need for regional flexibility?
Yeah, great question. Thank you, Mr. Levinson. I don't know of any evidence scientifically that a worker responds differently to a dry bulb temperature, or as OSHA proposes, using the heat index, which is a combined measure of heat and humidity, by region of the country, or by race and ethnicity. I'm just simply not aware of any scientific data that would support regional variability in the physiologic response to heat. I think that's sort of the bottom line there. I'm just not aware that the heat index in Louisiana and the effect physiologically on an outdoor worker is going to be different than that same heat index in Wyoming or New York or Florida.
Thank you. And I should have said at the beginning, we appreciate your comments now, but the agency also has the opportunity for a written post-hearing comment period. Anything that you'd like to say now is certainly welcome, but also anything you can add in post-hearing comments is also very much welcome. Particularly on the point of a body of literature or absence, as you said, of it would allow the agency to make such adjustments. The next topic relates to acclimatization. Many employers have talked about the challenges of acclimatization, and we would appreciate it very much if you could offer your thoughts on the degree to which it's important and how it can be accommodated in workplace settings.
Acclimatization is physiologically very important, and I agree with OSHA's analysis that they did of acclimatization. In fact, that's something we looked at almost 20 years ago in California, and I was sitting on the 7-person board as the only scientist at that time, actually, with subject matter expertise. And I recommended that we build into California standard the acclimatization issue. I would suggest that OSHA considered some of the practical applications for acclimatization, and so that it would give employers and employees the tools to understand best how to adjust return to work and the unacclimatized and acclimatized worker, so that it's feasible and practical for both workers and employers. But there's no question scientifically, from the point of view of the physiology, that acclimatization is crucial. I think what OSHA proposed is probably scientifically grounded in terms of the acclimatization schedule that you've proposed. And we also, I guess, would ask early on when we developed our standard, we did a survey, and I could provide this data in post-hearing comments. We found that one of the most critical factors in causing the heat-related fatalities we were seeing in the mid-2000s was the lack of acclimatization So your concept of building in a climatization, I think, is scientifically very sound.
Thank you. And my last question relates to indoor sedentary workers. OSHA has proposed exempting indoor sedentary workers from our heat standard, and a number of commenters have opposed that exemption. And we're curious, do you and/or California have any thoughts on the topic, and/or do you have any evidence or data related to heat illness among indoor sedentary workers?
Why do you ask the most difficult questions? I don't think we dealt with indoor sedentary workers. I'll double check in our standard. Let me give that to you in post-hearing comments, because I could certainly understand if a worker is in a hot indoor setting and is not exerting himself or herself, what risk does that pose at that point? So let me punt that down the road to post-hearing comments.
Thank you very much. And I always appreciate the opportunity to test you a little bit. The next comment or the next questions from OSHA, Your Honor, come from Zoe Petropoulos.
Hi, this is Zoe Petropoulos with the Directorate of Standards and Guidance. You answered some of my questions about underreporting, but I would still like to ask some questions along that topic, and particularly from your experience as a practicing physician, and if you could weigh in on some of these questions. In your experience, are you aware of cases of heat-related injuries and illnesses that are treated in hospitals, emergency rooms, urgent care settings, any other healthcare facility, that were occupational in nature but not documented as work-related in any way?
We have, thanks for the question. We have a number of data sets, and we can certainly provide those to you in the post-hearing comment period, where we've looked at heat in emergency room during hospitalizations. Your question, though, gets to the other side of that coin, right? Are there injuries or illnesses that are heat-related that were never documented in these data sets that we have? We have not done that study. We have not gone out and gone to emergency room records and looked for heat-related illnesses that were not reported in emergency room data set or hospitalizations, but were truly heat-related illness. And I'm trying to think whether there's anyone who's done that data mining or research. Our group will certainly look and provide that to you, because I think that would be important for you to consider.
Thank you. And yeah, I'll just clarify that, and we talked about this in the risk assessment of the proposed rule, and this is getting to a question, that there are probably cases that aren't coded as heat related but may have been, and that there may be cases that were work related but not coded. And so either now in post-hearing comments, if you could speak to kind of your experience and any data or literature you know of, in addition to what OSHA has cited, we would welcome feedback on that.
Certainly.
Another question from your experience as a practicing physician, are you aware of workers not reporting heat-related injuries and illnesses that they experienced to their employer?
That is pretty universal, not only for heat-related illness, but across the board. You know, for example, in a paper we published several years ago that we are updating on heat-related illness in California, that'll probably be submitted soon and published in about a year, is my guess. We see a differential in heat illness rates by occupation and by industry. And that is probably the result of differential reporting among those occupational groups. For example, firefighters and emergency responders have some of the highest rates of heat-related illness. And agriculture workers have average rates of heat-related illness. And I think that's probably entirely due to access to care and reporting between those two groups. There's some differences in risk, obviously, and exposure differential. But if we know anything about the risk to heat among farm workers, we know that it's very high. I mean, we have workers out in we have about 3 million farm workers in California. And the average temperature in the summer in many of our counties is over 100 degrees. And yet we see that the rates of reported heat-related illness are much lower than I'd expect.
Thanks. And my last question is, if you're aware of any papers, reports, or data on these topics of heat-related injury and illness incidence data or underreporting that OSHA did not cite, if you are aware, if you could share that with us in your post-hearing comments. And we would also welcome any additional input you have on our risk assessment. And I will also add that we talk about underreporting in the benefits analysis of the proposed rule on page 70962. And if you have any comments on that section, we also welcome those in post-hearing comments.
Yes, absolutely. We have a team of epidemiologists here at our health department. I'll have them take a look at that and make sure we provide those to you.
Thank you so much. And that's it for me, Andy.
Your Honor, the next questions from OSHA come from Tiffany Defoe.
Hi, excuse me. This is Tiffany Defoe with the Directorate of Standards and Guidance, OSHA. And Mr. Harrison, or Dr. Harrison, I have a series of questions for you on the topic of rest breaks. First, I wanted to ask about the provision in California's rules for as-needed rest breaks, which require that employees shall be allowed and encouraged to take a preventative cool-down rest break in the shade when they feel the needs to do so to protect themselves from overheating. And I'd like to ask if you have insight you can share into why that provision was written in this way, when they feel the need to do so to protect themselves from overheating, rather than, for example, when they first feel symptoms of overheating or heat illness coming on. Is that something that you could speak to?
Sure. Yeah, I sat there for many hours, probably similar to your position, thinking about the development of this standard because I voted as a member of the 7-person board in 2007. And this was the subject of many hours of conversation. It was written that way to encourage employees triggered by symptoms, and perhaps it could have been more clear in our standard, but our intent and my intent as an occupational medicine physician was if somebody had any early sign or symptom that they had the ability to take a rest break. And I think we originally wrote it as up to 5 minutes. That's gradually been expanded and amended over the last several years. They were called preventive recovery period because of some interpretation of wage and hour law on the provision of rest breaks. California is one of the states that I believe has, and I'm not an attorney here, but has required 15-minute rest breaks every 2 hours under our wage and hour laws. So that was already existing in California. The concept that I supported back when we passed this, Ms. Defoe, is that the idea that when somebody has an early symptom that an employee, a worker, is able to take that break, I think has been the absolute key to preventing work-related heat illness. And whether that's in the form of a mandatory rest break, so that everyone's aware that if they have a sign or symptom of heat illness, they stop, they take a break, is absolutely critical to employers providing protection against heat illness. It sets in place this idea in the workplace that taking breaks and a cool down period is absolutely critical to preventing heat illness. So personally, I didn't think 5 minutes physiologically was enough for a lot of the hard jobs we have in California. But what I've realized over the last 20 years is that this idea of rest breaks sets a benchmark for safety in the workplace. And however that's designed in, whether it's mandatory 15 minutes every 2 hours or it's some other mechanism, it's critical.
Thank you for that. I also wanted to follow up with the question about the sort of in practice use of the as needed rest breaks. To the best of your knowledge, have employees by and large been making use of the preventative cool down breaks provided for in the rule, the ones that are sort of at their request, that is? And if you are aware of any significant challenges with implementing those provisions, could you provide information now or to the record to help us understand why and where those challenges are arising? Any recommendations for how a federal standard could help address them?
Yeah, I'd be happy to put that in post-hearing comments because I think it is a really important issue. I thought about it quite a lot. I am not aware, and I'll see if I can come up with information that will be helpful for the record, that there's been any significant challenges or problems in workers taking rest breaks. There was a lot of concern when we talked about this, that there would be employees who would take advantage and take breaks when they didn't need to, because they would say, well, it's too hot, I need to take a break. And they're really going to do something else. I have not heard a single complaint about that over the last almost 20 years. And I'll see if I can get some data to provide to you about that there really has not been much of a hurdle or issue. There's a lot of worry and concern when we pass this, but I don't think it's happened.
Dr. Harrison, if you, so certainly that feedback is very welcome if you have information on that.
Yeah.
But I think I perhaps was not clear in what I meant with my question. I meant, are you aware of significant challenges in employees being made aware of or able to use as needed rest breaks?
Oh, I see. I'm sorry. I didn't understand your question. Let me get back to you. After we passed our heat illness standard, we implemented a very large compliance program, and this may be directed to our OSHA folks as well. We've had thousands and thousands of sweeps, unannounced inspections with wage and hour violations, as well as OSHA compliance enforcement inspections on this standard. And we collected some data early on. And let us take a look at this and provide that for you, because it could provide some useful insights about how often this happened, what you're asking me. Did workers have problems taking it, using this 5-minute break period, getting to a shade tent, finding water? Because we have a database of citations that we were collecting, and that might help.
Thank you very much. And any insight that comes out of that for what, if the situation has perhaps improved over time, if you find that, any information that would help us understand why improvements have happened in any particular areas would be helpful as well. Now you mentioned the mandatory breaks under the high heat trigger. And it sounds like those were, if I understood your testimony correctly, those requirements in the heat standards were aligning with previously existing rest break requirements. Did I catch that right?
Correct.
Okay. Thank you. Because I was going to ask you a question about whether employers by and large have been complying with those mandatory rest break provisions, and if you're aware of any challenges that have been arising for employers, in terms of extreme hardship or significant feasibility issues. And if they were if they're already in compliance with these other provisions, that may not have been something that you saw developing.
No. Most workers in California already get 15-minute rest breaks every 2 hours. And so I'm not aware that's been a significant issue. That it's come up in. I am aware that this has been raised in your current comment, and it was brought up 20 years ago, that there might be certain circumstances where workers are out doing a certain job, and it's not going to be really easy or feasible for them to take a 15-minute rest break.
Thank you. Well, yes, I mean, as you mentioned, we have received a lot of comments expressing concern about situations in workplaces where, you know, it may not be feasible or may even cause safety hazards in some circumstances. So based on California's experience, any recommendations that you have for how a federal standard could avoid any such consequences while still protecting workers would be much appreciated.
Thank you.
And thank you. That's all I have.
All right, and Your Honor, the final question from OSHA comes from Rachel Karse.
Hi, this is Rachel Karse from OSHA Directorate of Standards and Guidance. Mr. Harrison, OSHA has received comments recommending the removal of the scope exemption for emergency response and the inclusion of emergency services workers in the standard. On the other hand, we've also received comments supporting that exemption and proposing an expansion of the exemption to include activities such as power restoration work. Could you share any thoughts on the issue?
Yeah, I think we put this in the initial comment period, not for this hearing, because we supported the concept that all workers at risk be provided with the equivalent of the proposed heat rule for general industry or for the non-emergency response. I had some concern when I looked at the fine print of the emergency response regulations that they were not equivalent. And I think I put those in there in my comments to you. So I guess my take-home message would be that the physiological effect of heat, regardless of whether or not you're an emergency responder or construction worker or restaurant worker or farm worker, is the same. And I would recommend that OSHA take a look at those emergency regs and just make sure that everyone's getting the equivalent protection, no matter where they wind up in a regulation.
Okay, thank you. That's my only question.
Your Honor, that concludes OSHA's questions.
Thank you. Ms. Wiles, anything from the Solicitor's Office?
Thank you, Your Honor. Linda Wiles from the Solicitor's Office. I don't have any questions, but I would like to thank you, Dr. Harrison, for your time and testimony.
Welcome. Thank you.
Mr. Roberts, do we have any other online participants with questions?
Currently have two, Your Honor. First one is Jordan Barab. Mr. Barab?
Yes, thank you. Jordan Barab, thank you, Bob, for that testimony. It was very interesting. I want to follow up a little bit on Mr. Levinson's question, who highlighted the huge geographic diversity in California. You got the highest mountains, the lowest deserts. You got a huge agricultural sector in the Central Valley, lots of construction, just about everything that the country as a whole has. And California's actually issued, I guess, two one-size-fits-all standards, one for indoor and one for outdoor. And you talked a little bit about, the impact on the human body. But let me ask you this: from your knowledge, have these one-size-fits-all standards been difficult for all kinds of different industries and companies to comply with?
Not in my experience over the last almost 20 years. As I say, there was a lot of the same discussion that I heard for many days, sitting in my esteemed colleague's position here. And it's turned out, I think, to be a very successful implementation. I have not been aware. I mean, quite simply put, I used to drive out to Yosemite for my vacations, and I'd come through the fields and I would see nothing. Now I drive and I see tents and igloos and water and folks doing the same work that they've always done. I haven't not been aware of any impediment to agricultural or construction productivity. Our economy has expanded quite successfully over the last 20 years. And I simply put, have not been aware of any significant challenges. It's proved to be a very successful common sense rule. And as you point out, we have a very wide, we have every climate in California that the rest of the country has.
Okay, one more question. The Nevada standard that some witnesses seem so enamored of, exempts workers, basically warehouse and trucking workers who are loading and unloading materials from trucks into warehouses. And I know California's standard covers that. Has there been a problem with enforcing that or complying with that?
No, not to my knowledge. Again, employers in our state have really quite successfully implemented this standard, in my view. And I would also point out that some of these employers are they have operations in all 50 states. In fact, they're global corporations, they're global companies. And so the responsible large employers who are already implementing this in California, I think would probably be able to implement this quite successfully in the other 49 states if they have the same programs in place.
Okay, thank you. That's all I have.
Thank you. Who's next, Mr. Roberts?
Ayesha Shrestha. Ms. Shrestha?
Hello, can everyone hear me?
Yes.
Yes,
Great.
thank you.
Great. Thank you, Dr. Harrison, for your testimony today a lot, and we really value your expertise on this. This is Ayesha Shrestha from the AFL-CIO. I wanted to ask, we've heard a lot in this hearing about acute heat exposures. So I was wondering about what the medical implications of chronic repeated heat exposure is on the body, since many workers who are impacted by heat, it's not just a one-off thing for them. And does OSHA need to account for this in its risk evaluation?
Thank you for the question. When I went to when I was in medical school 40 years ago now, I learned that acute heat illness, if somebody, if an individual was acutely dehydrated and let's say had some mild to moderate forms of heat illness, they would completely recover and there was no lasting effect on the body. The scientific data has changed over the last 4 decades and shows that repeated heat exposure, even if somebody is recovered or had mild heat illness that never had treatment, increases the risk of chronic kidney disease and long-term cardiac complications. I do think that should be recognized in the evaluation of the scientific data because we now know that there are long-term risks of repeated lower level heat exposure. I'd point in particular the data from Latin and Central America on chronic kidney disease, particularly in the sugarcane workers in Guatemala. And I simply can't remember whether OSHA has sufficiently reviewed that literature or incorporated into their risk analysis, but there's certainly a very robust body of literature now on repeated low-level heat-related illness and chronic disease.
Thank you for that answer. And to build off of that, are people who experience heat strokes, not just lower levels of chronic repeated heat exposures, are people who experience heat stroke once more sensitive to experiencing heat illness in the future?
Probably the answer to that is yes, that a worker who has heat illness and let's say had that happen to him or her multiple occasions, they're probably more susceptible to the effects, which I think makes it even, which I think provides scientific evidence and a basis for the concept of early reporting, tracking, education, setting a threshold of temperature low enough. I agree with the 80 degrees trigger, for example, and because I think it provides a margin of safety there because of exactly what you just pointed out.
Thank you so much. Sorry, you've already answered that question. Thank you so much for this. That's all from me.
Thank you.
Thank you. Mr. Roberts, anyone else?
No one else in the queue, Your Honor.
Okay, then Dr. Harrison, thank you very much for your time. We appreciate you sharing your testimony with us today.
Thank you.
And Mr. Roberts, I believe we can move to the next witness.
Yep, the next speaker will be Maggie Leland from the Washington State Department of Labor and Industries. Ms. Leland, please state your name and affiliation.
Ms. Leland, if you're there, you're on mute and we can't hear you.
I can see Ms. Leland is off mute.
If we think she's having technical
Yeah,
difficulties.
should we move this?
Yeah, should we go to the next witness and then come back to her?
We'll come back. Yeah. So the next witness is Kate McCoy from the Occupational Health Subcommittee, Council of State and Territorial Epidemiologists. Ms. McCoy, please state your name and affiliation.
Can you hear me?
Yes.
Great. Thank you so much. Just pulling up my notes. So good afternoon. My name is Kate McCoy. Along with Dr. Ken Rosenman, I serve as co-chair of the Occupational Health Subcommittee of the Council of State and Territorial Epidemiologists. Our members are based in states and use a variety of data sources to track occupational illnesses and injuries. Our work helps our states identify and address emerging and persistent threats to our workers. Most of our programs are funded and made possible by NIOSH. As public epidemiologists, we understand better than most how much our current data systems fall short when it comes to capturing the true health effects of heat on workers. We know that the data systems we use, such as workers' compensation data, hospital and emergency department data, death certificate data, and even Bureau of Labor Statistics, SOI and CFOI data, consistently and substantially fail to fully identify work-related illness and death, including work-related heat illness and death. In the context of this hearing, this means two things. One, our systems currently underestimate the threat that unaddressed heat exposure poses to our workers, our economies, and our state's abilities to maintain functional operations in extreme heat conditions. And two, as a result, we are also vastly underestimating the benefits that an OSHA heat standard would undoubtedly provide to those same workers, economies, and state systems. Even with the holes in our current data systems, the need for an OSHA standard to protect workers from heat is abundantly clear. In Louisiana, which is recently slated to lose its OSHA office despite extreme temperatures and other threats to worker health, all of the state's occupational health fatality assessments to date have focused on heat-related deaths. One such death was a 24-year-old archaeologist who died only a few hours into her first day on a dig site. The temperature reached 98 degrees and a heat index of 107 at that point. In another Louisiana case, a 27-year-old sugarcane worker also died on his first day on the job. He had received heat training and had access to water, but was not acclimatized and had no access to shade. Dr. Anna Riley, who runs Louisiana's Occupational Health Surveillance Program, notes that such deaths are not always marked as heat-related or work-related on death certificates. When she learns of such discrepancies, she uses OSHA investigation reports and her team's findings to petition coroners to correct the death certificate to accurately reflect these as heat-related deaths. This is the slow and painstaking work of trying to piece together as many pieces of the heat risk threat puzzle as possible. In Michigan, Dr. Rosenman shared another fatality case picked up by their occupational surveillance program. A 39-year-old H-2A migrant agricultural worker from southern Mexico was assigned to an asparagus farm in Michigan. He'd passed the H-2A pre-placement physical exam with no chronic conditions noted. 4 days into his work on the Michigan asparagus farm, he was admitted to the hospital in renal failure, of which he later died after being sent back to Mexico. His condition and the circumstances were consistent with the kidney disease that has been recognized among young male agricultural workers in regions of Mesoamerica. He and his family were not awarded workers' compensation despite Michigan H-2A workers being eligible for such benefits. Workers' compensation claim data is one of the main ways that occupational health epidemiologists track work-related morbidity and mortality. But because the asparagus worker did not receive workers' compensation, his case was one of many not included in the nearly 400 Michigan hospital and ED visits from 2020 through 2023, for which workers' compensation was the payer. His case came to the attention of Michigan's occupational surveillance system only through a review of poison center data, as he was originally believed to have been pesticide poisoned, not through heat-related illness. In my state of Wisconsin, where the ice gets so thick in winter that people drive their trucks out on it to spend the day ice fishing, our workers' compensation indemnity data shows the same basic heat-related illness risk groups as found in warmer states. That includes, among others, warehouse workers. We recently worked with a 21-year-old college student who also had a job at a warehouse for a global corporation. He sought out an internship with us after suffering from heat illness at his warehouse job and seeing firsthand how his health needs were brushed aside. As an intern for us and a member of an immigrant community, he worked passionately to design and disseminate heat safety materials for warehouse workers in their own language to fill a gap that should have been addressed by the employer. These are only a few examples. Every single state occupational surveillance program could offer similar examples of how unaddressed heat poses a significant yet underreported threat to their workers. Some of the data from my colleagues in other states appears in the proposed rule document. As stated above, such analyses represent our profession's commitment to advancing the science, even as we're aware of the extent of underreporting. Even our imperfect data makes clear that too many workers are suffering and dying from heat exposure, and that this has long been the case. And as I was preparing for these remarks, it struck me that NIOSH first recommended a heat standard before most of us in this field were even born. We are at a pivotal moment now. The decimating federal funding cuts to NIOSH and other agencies threaten to remove our ability to track all serious instances of work-related morbidity and mortality, including heat-related illness. At the same time as our systems are going down, heat risk to workers are going up. That means our ability to understand and address this risk is likely to worsen unless action is taken. Whether they are counted or not, worker deaths and heat illness episodes will still reverberate deeply in their affected communities across the country. We urge passage of the heat standard without delay. Thank you. Oh, and I can start my video. I might need to turn it off if there are questions because I don't have great connection here.
Thank you, Ms. McCoy. Any questions from OSHA, Mr. Levinson?
Yes, Your Honor. OSHA's questions will come from Zoe Petropoulos.
I'm on mute. I'm sorry. This is Zoe Petropoulos from the Directorate of Standards and Guidance. Thank you so much for your testimony. I do have some questions for you pertaining to things you spoke about in your testimony, but also specific questions related to OSHA's risk assessment. And because these questions are specific and about specific arguments that OSHA makes in the risk assessment, I'll just let you know that the risk assessment begins on page 70732 of the preamble. And so for any of these questions, if you'd like to go back and read any parts of that section before answering and then responding in post-hearing comments, you're welcome to do that. So my first question, in the preamble of the proposed rule, OSHA, in the risk assessment of the proposed rule, OSHA relied on, among other sources, CSTE's Occupational Health Indicator number 24. And for the record, this is occupational heat-related emergency department visits. However, OSHA noted in a limitations section, which begins on page 70740, that determining when emergency department visits and inpatient hospitalizations are both work-related and heat-related is challenging to do with existing datasets and coding structures. Therefore, OSHA noted that indicators like CSTEs likely do not capture all relevant cases. Do you agree with this assessment?
Yes, and so that indicator is based on looking at emergency department visits for persons age 16 years or older with a primary or contributing diagnosis of heat-related illness and with a primary payer coded as workers' compensation or a work-related E-code listed in the ED record. And so this goes a little bit back to one of the questions that you had for Dr. Harrison. I can speak to why we know we don't know the extent. We don't have a good number on the extent of underreporting because, as Dr. Harrison mentioned, that would take a different kind of work to go to emergency departments and do a rigorous study where you're verifying cases as they come in, which is not feasible. But we know that systematically there is underreporting of work-relatedness. these systems, the underreporting is not nefarious. The underreporting is because these systems are relying on busy medical personnel to fill in several different fields and additional fields beyond what is kind of minimally necessary for them. We know, for instance, even in instances where work relatedness is required, which it generally is not required in emergency department visits, but for instance, in trauma centers, at least in my state, those trauma centers, some of their funding relies on the collection of specific indicators, including indicators related to work-related traumatic injuries. When we looked at that data, these are the cases where we should have excellent data on work-relatedness. But what we see in a lot of that data is the same occupation and industry comes out over and over again. And when you look at it, it's because that was what was sort of the top of the drop-down list for one of these major trauma centers. So what that speaks to is these are very busy medical personnel who are just clicking through till they get to the next screen oftentimes. And so when we do get work-relatedness, we presume that's more the exception than the rule to get that information in something like an emergency department visit record or a hospital record. And we do see those. We do see instances where that data comes up, but we're humble enough and aware enough to know that those are not always included, that our data needs are not top of mind to medical providers in those circumstances.
Thank you. My next question is kind of similar, but stepping back. And so you touched on this a bit, but I'm still curious your thoughts. So OSHA relied on multiple sources, not just the CSTE indicators in the risk assessment, specifically BLS SOI and also state level workers' compensation claims. In your expert opinion, do these data, in addition to the emergency department data you just mentioned, do these data represent the best data sources that are currently available for estimating the incidence of non-fatal heat-related injuries and illnesses among U.S. workers, even in spite of the limitations that you've mentioned and other witnesses have mentioned?
Yes, I think in combination, all of these together help us piece together, the full extent of the morbidity mortality that we are facing. The issue is that they all have different liabilities. As I was speaking to about emergency department data, SOI data is self-reported. That's that BLS data that is survey based. DFOI is based on whether or not those deaths were captured in data systems, news reports, etc. So, really putting together as many different data sets as you can is going to provide a better picture. But there isn't a single gold standard that isn't currently being accounted for that is out there. I would say putting together as much as you can. And I would say the anecdotal evidence really needs to be taken seriously under these cases, under these conditions, because we simply know there are so many ways and so many reasons why underreporting happens. So I spoke to what happens in the medical system. And I think Dr. Harrison spoke a little bit earlier about some of the other reasons why there's underreporting. But whether it's workers not coming forward, whether it's people not being delivered medical care, whether it's employers not reporting when they should, all of these different things make it so that the true funnel of what we imagine to be the underlying burden of occupational injuries and illnesses gets whittled down to a much smaller official number. And so that's why in those situations where we know that our data systems are faulty, we really do need to privilege these voices that come from workers, from worker organizations, from communities, from families that say, here was an instance where this happened and it might not be reflected in official statistics. That example I gave of our intern who we had last year, young college student, he was a young public health student who was working at that warehouse. He wasn't treated medically. He for his instance of heat-related illness. He was just sort of told to sit down on the job and then get back to the line. So get back to work. And so he's not going to show up in any of those data systems. That's an example where he maybe should have been seen medically, but it's underreporting. So I listened to those instances of anecdotal evidence of qualitative data in ways that help to flesh out the picture.
Thank you. My next question for you is about comparing these data between states. So in its risk assessment, OSHA relied in part upon state level data of workers' compensation claims, I think including data from your office in Wisconsin. And OSHA did not directly compare incidence rates derived from these data between different states. And we noted that this is because there are differences in incidence that would not necessarily reflect differences in the risk to the workers in these states. There are differences in eligibility criteria between states and varying rates of usage of workers' compensation insurance by workers. We cited a paper by David Bonato et al. 2010 showing this varying usage of workers' compensation insurance. And I'm curious if you agree with OSHA's decision to not compare rates between states and the reasons that I've outlined and the reasons we outlined in the risk assessment.
Unfortunately, yes. It's one of our major frustrations as a field that we don't have the kind of standard, shared, uniform data systems that we would like. And it makes it very difficult to do those kinds of comparisons that we'd like to have. Just by way of illustration, the analysis that we did in Wisconsin is based on workers' compensation indemnity claim data. So all we can speak to with our comp data is lost time, not medical only claims. And that's because in Wisconsin, we at the state level do have access to indemnity data. We do not have access to the medical claims data. That's not true in every state. So that's just speaking to the data, not the underlying eligibility questions, which, as you mentioned, can also vary.
Thank you. And I'll just conclude by saying, given your background and your testimony and your expertise, we welcome any additional input you want to share with us on our limitations and underreporting section of the risk assessment. This begins on page 70740. In your post-hearing comments, I also mentioned this to Dr. Harrison that we talk about these topics in the benefits section on page 70962. And if you want to share any comments or if we are missing any papers, reports, or data on these topics that you're aware of that we did not cite, we would also welcome those in your post-hearing comments.
Thank you very much.
Thank you.
Your Honor, that concludes OSHA's questions for this witness.
Thank you. Ms. Wiles, anything from the solicitor's office?
Thank you, Your Honor. Linda Wiles from the Solicitor's Office. I do not have any questions. Thank you so much for your time and your testimony today, Ms. McCoy.
Thank you.
Mr. Roberts, any additional questions from online participants?
We have Miss Ayesha Shrestha. Ms. Shrestha, please state your name and affiliation.
Hello, my name is Ayesha Shrestha from the AFL-CIO. Thank you for your testimony today. You touched on this a bit in the OSHA from the questions from OSHA, but I wanted to ask if you could expand on this. From a data variability perspective, why does heat illness need to be addressed for workers in a uniform standard?
From a data perspective? Yeah, well, I think we were coming right up against that question at the end of the last questioner's interaction. So comparability, right? I mean, to be able to have comparisons across states as well as over time, we really need that standard type of reporting, standard interpretation of guidance, and standard enforcement, so that any place in the country we know that the same types of incidents are hopefully being reported. Otherwise, it's very difficult to make decisions based on the reading of the data. if I can, I just go beyond the data part about why it's also important just generally for worker protections. I know a number of speakers have talked to the fact that really there are heat risks across the country. And so we need shared protections across the country. But also, this may have been mentioned previously as well, but a lot of workers who face heat risks do travel across state lines for their work. And so having that uniformity of protections across state lines can be helpful for them within the same season.
Thank you so much. That's all from me.
Thank you.
Mr. Roberts, anyone else?
There's no one else in the queue, Your Honor.
Okay. Thank you, Ms. McCoy, for your testimony today. We appreciate your time.
Thank you.
Your Honor, if you are happy to, I believe we have Ms. Leyland from the Washington State Department of Labor and Industries ready.
Sounds good.
Ms. Leyland, please state your name and affiliation.
Hello.
We can hear you. Go ahead.
Hello. Hello. My name is Maggie Leland. I'm with the Washington State Department of Labor and Industries. We are an OSHA-approved state plan, and we also run a state workers' compensation program where all employers in Washington obtain their workers' compensation insurance either through LNI or through or become self-insured with oversight from LNI. This makes us a unique entity to be providing testimony to OSHA in favor of this rule. We are also one of the few states who have an outdoor heat specific rule in place. We have had this rule in place since 2008. We updated the rule in 2021 with emergency rules, 2022 with emergency rules, and a permanent update in 2023. We are here today testifying in support of OSHA's rule. We believe heat is an occupational safety hazard and rules are necessary and appropriate to reduce a significant risk of material impairment to health. Heat has long been recognized as an occupational hazard, similar to other physical hazards like electricity and noise, despite the hazards such as noise and electricity existing in non-occupational settings. It is important to note that occupational regulations are based on the premise that employers have a duty to provide a safe and healthful workplace, as they have control over the workplace and the way work is performed. Physical activity is associated with the increased metabolic load and the body heat of workers, and metabolic heat is a risk factor for heat-related illness. Employers have control over the physical activity associated with work, the pace of work, the ability to take breaks, the need for personal protective equipment, and other risk factors such as working in direct sunlight, access to water. As such, we believe that it is important that OSHA address this occupational hazard. Washington State and other states are an example that outdoor heat rules are necessary, appropriate, and feasible. Washington adopted its first rule in 2008 specific to outdoor heat. This was triggered by a farm worker death in 2005, excuse me. At that time, our rule set a trigger for most work performed at 89 degrees. We then got a petition to update the rules in 2020 following Washington's heat dome to look at having our rules include more preventive measures. Our rule at the time had specific requirements related to water, and it also included specific requirements related to responding to workers who were showing signs and symptoms of heat-related illness. But our rule lacked concrete requirements to prevent heat-related illness. We looked at our workers' compensation data at the time, and we realized that we were having, from 2006 to 2017, we had 918 heat-related illness claims. 654 of those claims were accepted, and of those, 45% were below the 89-degree threshold. As such, we realized that we needed to have a lower threshold in order to be preventing heat-related illness. In addition, we wanted more preventative requirements. Our previous rule had directed employers to include heat-related illness in their accident prevention program, which is Washington's Injury and Illness Prevention Program. Employers in Washington have a responsibility to have an accident prevention program that is tailored to the hazards of their workplace. And under our previous rule, they were to address heat exposure in their accident prevention program. As a result, this is similar to critique that OSHA has heard around requiring the following the general duty clause and having a more performance-based rule, that this did not provide clarity to employers and to workers as to how to actually, what preventative measures were necessary. As such, when Washington updated our rule, we included requirements, specific requirements for heat, or for shade, for rest breaks, and for both preventative rest breaks and mandatory rest breaks, and specific requirements around acclimatization and training and working under high heat hazards. Our rule, our longstanding rule since 2008 and the updates show that this is feasible for employers to be having prescriptive requirements to prevent workplace heat-related illness, as well as long-term implications from heat, which includes kidney disease and issues based on research that is done in Washington, which we have provided in our comments, as well as research in other states that show that there's an increased risk of traumatic injuries from workers when they are working in high heat. So this includes risks from traumatic injuries from, for example, falls or other types of injuries in the workplace. Washington supports the rule having an initial trigger of 80 degrees. Again, we lowered our trigger to 80 degrees because our previous trigger of 89 was not protective enough to prevent heat-related injury and illness. We recognize that, again, there are those who feel that a more prescriptive or a more performance-based rule would be helpful, providing flexibility for employers, but without clarity on what heat and what temperature employees need to be protected from, that more prescriptive performance-based rules are not going to be protective enough of employees. We also, in Washington, believe that humidity is an important consideration that OSHA needs to have in looking at their rule. So we appreciate that their rule includes consideration of humidity. In Washington, our rule uses an ambient temperature. However, that is because we were able to work with experts, including Dr. Bernard, who at the time was the chair of the ACJH's Physical Hazard Committee, to look at our rule and our unique situations in Washington, and he was able to help us look at our dew point observations, which is a measure of humidity, and calculate that out to determine that our rule, that using an ambient temperature in Washington would allow for consideration of humidity in Washington's environment. Given the diversity in temperature and humidity across the country, we believe that it's important that OSHA's rule does consider humidity.
Is your testimony complete, Ms. Leland?
I'm sorry. So we also, we also believe that it is important that the rule include recognition of acclimatization. That is an important risk for workers, and we believe that it is appropriate that the rule include acclimatization. We also support the rule with respect to rest breaks. Given the variability in the type of work, environmental and personal factors across occupations and workers, ensuring workers understand that they have the right to take preventative cool-down rest periods when needed, and that those rest periods be paid unless during a meal period, will prevent workers from overheating or be overheated. We believe that it is important that the rule include emergency response and planning, such as relieving workers who are experiencing signs and symptoms of heat-related illness, offering first aid, and contacting emergency medical services. We support rest periods at high heat temperatures.
Ms.
We
Leland,
support
just so you
training
know, your allotted time is up. If you just want to finish up, then we'll
Okay.
move to questions.
Yes, thank you. I'm ready to move to questions.
Okay, thank you. Mr. Levinson, any questions from OSHA?
Yes, Your Honor. Andrew Levinson for OSHA. Ms. Leland, thank you very much for your testimony. My questions center around Washington's experience with the concept of close observation requirements in your standard for newly assigned and returning workers. Can you discuss a little bit your experience or the state's experience with employers' compliance with that requirement?
Yes, that requirement was added into our rule, our permanent rule in 2023. And we require close observations for 14 consecutive days for new employees who are not acclimatized to the heat and new employees returning from work. And that also includes times when for all workers, when there's heat waves, when the heat is at or above the action level, which is 80 degrees and at least 10 degrees higher than the 5-day average highs. And we have not experienced any concerns from employers with the ability to comply with this since we have had it in place. We are happy to update. We'll take a look at our data and update you on if we've had any specific complaints regarding this or citations, but I'm not aware of any concerns from employers with the ability to implement this requirement.
Thank you. And I should have said at the beginning, in addition to the opportunity to respond now, OSHA also has a post-hearing comment period, and we're also happy to take any thoughts or observations or data that you have in the post-hearing comment period. In particular, what would be helpful is if the state of Washington has any experience with enforcement around the logistical administrative requirements of or challenges for the close observation requirement. So have you enforced it in fact? And if so, kind of how do your enforcement personnel know when an employer did or did not meet the close observation requirements? That information would be particularly helpful to us.
Great. We will take a look and we will update information for you in our post-hearing comments. We do have a directive to our inspectors as to how they are to go about enforcing our heat rule. And we can also share that with you that has information for them on how they're to be assessing an employer's compliance with the requirements, including with the requirements for close observation.
Thank you. My next question relates to heat waves, and we're curious, are there specific tools or processes that Washington State uses with employers to identify heat waves, and how to anticipate when that's occurring or triggering specific acclimatization requirements in your standard?
So we are happy to update this, supplement this data as well in our post-hearing comments. We do, in Washington, we have a robust Department of Health that sends out notifications at times when there's anticipation of heat waves. And so not necessarily a heat wave is defined under our rule, but when there's high heat advisories and heat warnings and advisories, they send out notifications, and our communications staff here at LNI, we also send out and use social media to send out notifications, but it is not an automatic system in place that we have to provide employers that information. But we do try to.
Thank you. And as you're providing additional comments for the record, any thoughts that you might have on the suitability of National Weather Service alerts and/or why Washington does issue advisories from the state health department or from other state agencies would also be helpful.
We will look at that.
Thank you. The next question from OSHA comes from Zoe Petropoulos.
Hi, Zoe Petropoulos with Directorate of Standards and Guidance. My question was about your written comment and something that you all wrote about training. So you mentioned a recommendation in your comment for, quote, specific workplace supervisory training requirements, such as the use of engineering or administrative controls, end quote. Could you tell us more, either now or in post-hearing comments, about what these requirements might look like and why you think OSHA should include this requirement?
So if there, we will update that so that in comment, but this in part gets at if an employer's way of addressing heat includes some engineering controls, for example, then the supervisors need to be trained to understand what those are, so they can be ensuring that they're that they understand it and ensuring that they're the supervisors can be implementing them and that the workers understand them. So an administrative control could be that the use of access to air-conditioned spaces or scheduling certain work, more physical work during cooler hours of the day. Those are examples of where it's important that a supervisor be trained and understand that an employer is using those to mitigate heat exposure.
Thank you. And that was my only question.
Your Honor, the next questions from OSHA come from Tiffany Defoe.
Hi, this is Tiffany Defoe with the Directorate of Standards and Guidance, OSHA. Thank you for the information that you provided to us about the history and status of your state's rules. Very interesting, as well as helpful, but interesting too. I wanted to ask, to the best of your knowledge, have employers in your state, by and large, been complying with the rest break provisions in your rules? And if so, would you share your thoughts and any available evidence that you may have on whether the rest break provisions in particular have helped to reduce heat-related illness among heat-exposed workers? And to be clear, discussing this now is fine, also in post-hearing comments, or either. Thank you.
We will provide response to this question on our response. I will note Washington State, under our wage and hour law, does have a requirement for 10-minute rest breaks every 4 hours. And so employers in Washington have understood the need to follow rest break laws. But regarding compliance specific to heat, I will get with our compliance data and respond back in our post-hearing comments.
Thank you very much. And I also wanted to ask, to the best of your knowledge, in the history of the implementation of the rule and its various phases, have there been significant disruptions or hardships you're aware of to Washington state businesses as a result of coming into compliance with rest break requirements? And if you are aware of any significant disruptions or hardships that have occurred, if there's information you could provide to the record that could help us better understand where and why those challenges arose, and any recommendations based on Washington's experience that you might have, or how a federal standard could help mitigate those kinds of issues while still protecting workers from heat-related illness.
We can take a look at that information and provide that in our follow-up comments. I'm not aware of any specific issues in particular where employers have identified challenges with rest breaks. Our rule did include a provision that we would be reviewing the requirements for rest breaks in following the adoption of the rule. We would be looking at it within 3 years. So we would review data regarding work rest periods and look at heat-related illness claims, inspections, information from other state and national regulations, and we would be looking at peer-reviewed publications and other nationally recognized standards. So we've committed to doing a review and looking at that as well in our to our stakeholders.
Thank you. Thank you very much. That's all I have.
Your Honor, the last questions for this witness come from Rachel Karst.
Hi, this is Rachel Karst from OSHA DSG. Just following up on Tiffany's question, it sounded like you did some analysis of the effectiveness of earlier versions of the rule. If there's anything that you learned or any details or results from that you can share that you haven't shared already, we would appreciate that type of information. I have, in addition to that, some questions about your final cost benefit analysis for the 2023 final rule. So I'm going to really just read these into the record because they're very specific about the cost estimates, and we don't expect that you have that information with you today, but if you do, we'll take it. So the first question was that there was an estimate that it would cost employers approximately $20 to $75 for translation services. If possible, can you provide the source of that estimate? The second question is, how did Washington State estimate the percentage of workers that are working alone and or in remote locations that would be exposed to outdoor conditions? And the third question is, in the final cost benefit analysis, it is assumed that unreported incidents have 10% of the cost of cases reported and accepted to the workers' comp system. Can you explain a little bit more the basis of this assumption? And that is our questions that we wanted to read into the record.
Thank you. We will look at those and provide information for you in our post-hearing comments.
Thank you.
Your Honor, that concludes the questions from OSHA.
Thank you. Anything from the Solicitor's Office?
Thank you, Your Honor. Linda Wiles from the Solicitor's Office. I do not have any additional questions. Thank you so much for your time and testimony today, Ms. Leland.
Mr. Roberts, any other participants with questions?
We have Mr. Dan Glucksmann with a question. Mr. Glucksmann, please state your name and affiliation.
Hi. Thank you, Your Honor. I'm Dan Glucksmann, the International Safety Equipment Association. And my question for Ms. Leland is, well, I noticed that Washington State's recent outdoor heat stress rules for ag workers and others their definition of water included electrolyte replenishment beverages, parentheses, i.e. sports drinks, that do not contain high amounts of sugar, caffeine, or both, such as energy drinks. I guess my question is, have you found that this provides needed clarity for employers and employees? You know, that adding that definition.
Yes, that definition was added in our rule in 2008 when we first adopted it, as to that electrolyte beverages would be meeting the definition of water, and it was updated in this our last rule to include looking at ensuring that they were not energy drinks or high sugar. And this does provide clarity to employers as to what they can provide and our expectations. So it's critical that employers not be questioning whether something is acceptable, a beverage, if they're going to be trying to meet a requirement in the rule to provide a certain amount of drinking water. We felt that it was important. We had got questions from employers during the rule development phase as to whether it would be acceptable. There are many times where certain physical jobs and some construction jobs, for example, had already been providing electrolyte beverages on the job site. So we have found this to be helpful clarity for both our inspectors and for the regulated community.
Okay, great. Thank you very much. And thank you, Your Honor.
Here. Mr. Roberts, anybody else?
There is no one else in the queue, Your Honor.
Okay. Ms. Leland, thank you very much for your testimony. We appreciate your time.
Thank you.
The next speakers are Sarah Bucic, Milagros Ilia, and Daniel Smith from the Alliance of Nurses for Healthy Environments.
Thank you so much. Good afternoon. My name is Sarah Bucic. I'm a registered nurse, and I represent the Alliance of Nurses for Healthy Environments, and I really appreciate the opportunity to speak today. Our organization is the only global nursing organization focused solely on the intersection of health and the environment. And we have close to 10,000 individual nurses dedicated to promoting healthy people and healthy environments. And we're committed to advancing regulations that protect workers from preventable harms. Heat is now the leading cause of weather-related deaths in the US. And according to recent studies, heat-related illnesses and injuries such as exertional heat stroke are becoming more frequent due to rising temperatures and the increasing physical demands of labor-intensive industries like agriculture and construction. Exertional heat stroke in particular remains a significant cause of morbidity and mortality among workers performing physically demanding tasks in extreme heat, leading to long-term health consequences, including multi-organ failure and cardiovascular dysfunction. Research on exertional heat illness indicates that workers exposed to high ambient temperatures and humidity are at an increased risk of heat-related illnesses. The body's thermoregulatory system becomes overwhelmed when conditions hinder effective heat dissipation, especially in outdoor environments. And this issue is exacerbated by the physical demands of jobs in high-risk industries, such as construction, firefighting, and agriculture, where workers are exposed to prolonged heat stress, often with insufficient rest breaks or cooling measures. Indoor workers are also at risk of heat-related illness, including those working in warehouses, indoor construction sites, vehicles, manufacturing, food services, and maintenance of older public buildings. Further complicating the problem, workers with pre-existing health conditions such as cardiovascular disease, diabetes, and kidney disorders are particularly vulnerable to heat stress. And studies show that heat exposure can exacerbate these conditions, leading to severe heat-related illnesses and long-term health effects, including chronic kidney disease, which has been linked to chronic dehydration and repeated heat exposure. Medications also, such as diuretics and beta blockers, also impair the body's ability to regulate heat, placing many workers at even higher risk. While we strongly support the proposed heat injury and illness prevention standard, we believe OSHA must address several critical areas, and one of them being the implementation of medical screening. The current OSHA proposal does not include a provision for medical screenings to identify workers who may be more vulnerable to heat stress. And heat-related illnesses disproportionately affect workers with underlying health conditions such as cardiovascular disease, diabetes, and kidney disorders. In addition, certain medications, as I noted, such as diuretics and anticholinergics, impair the body's ability to regulate heat, further increasing the risk of heat-related complications. And research demonstrates that pre-existing conditions significantly increase the likelihood of exertional heat stroke and other heat-related illnesses, potentially resulting in severe outcomes. We recommend that OSHA encourage employers to offer medical screenings to identify heat-related vulnerabilities. Such screenings modeled after OSHA's respiratory protection standard would enable employers to tailor accommodations and protections to individual health needs without placing undue burden on the workforce. And by proactively addressing workers' health risks, employers can reduce the incidence of heat-related illnesses and improve workplace safety. Employers also are exempt from the standard due to their indoor operations rarely exceeding the initial heat index threshold of 80 degrees Fahrenheit, or because they provide an air-conditioned environment, should also be required to maintain their HVAC systems and to provide documentation of regular maintenance. Exemptions based on access to air conditioning should also include time limits for temperature deviations exceeding 80 degrees. This is particularly critical for indoor workers, including those classified as sedentary under the proposed standard, who often work in older buildings with inadequately maintained HVAC systems. I appreciate your time today, and I'm happy to take any questions.
Because you're a panel, I think we'll, if the other witnesses want to testify first, then we'll take questions for all three of you. So whoever next.
Thank you. Yes. Hi, I'm happy to take over for my colleague. My name is Milagros Elia. I am the program manager for climate and clean energy advocacy at the Alliance of Nurses for Healthy Environments. I'd like to start by saying that the summer of 2025 has commenced with experiencing, yet again, record-breaking heat wave. Heat-related deaths have increased with warmer temperatures associated with increased risks of hospitalization for things like heart disease, respiratory complications, kidney damage, preterm births, and mental health impacts. Nurses are on the front lines treating patients with exposure to extreme heat with elevated health risks for outdoor workers, children, and other older adults. And those who experience barriers in accessing cooling or healthcare, such as those living in low-resourced communities. Just as we find with many health inequities here in the United States, our communities of color are bearing a disproportionate burden of the impact of extreme heat. Those employed in the agricultural, fishing, forestry, and hunting sectors account for about 20% of heat-related deaths and about 10% of heat-related illnesses reported to the Occupational Safety and Health Administration. Around 17% of the Latino population work as natural resource laborers, meaning those that I just quantified as agriculture, forestry, fishing, and hunting, compared to 10% of whites. High temperatures and heat waves will thus disproportionately impact Latino laborers, with Latino laborers being 3 times more likely to die from heat on the job than non-Latinos. Workers in agriculture, construction, utility, and manufacturing, who are also disproportionately Latino, are more vulnerable to heat waves and higher temperatures, leading to loss of productivity, increased health care costs, and general economic strain. Latinos are 43% more likely to live in areas that are projected to have reduced working hours due to extreme temperatures. Latinos also have less access in these communities to sick days and health insurance, which leaves them less able to manage health conditions that are exacerbated by heat. It is for this reason that we advocate for a requirement of written heat illness and regarding injury prevention plans for all employers. The current OSHA proposal requires written heat illness and injury prevention plans, but exempts employers with fewer than 10 workers. This exemption leaves many vulnerable workers unprotected, particularly in industries such as those I mentioned, agriculture and construction, where smaller employers often operate. Research reveals that workers in these sectors face significant risks of heat-related illness due to outdoor work, high physical exertion, and limited access to cooling areas. Without written heat injury and illness prevention plans, smaller employers may not implement adequate safeguards, exposing workers to dangerous heat levels. Moreover, research on migrant and temporary workers show they often have less access to safety measures and training, which increases their risk. We recommend that OSHA mandates written heat injury and illness prevention plans for all employers, regardless of size, to ensure consistent and equitable workplace protections. Offering compliance assistance for smaller businesses can help ease the implementation burden, but all workers deserve the same protection from heat-related risks. Each day without a strong federal standard is a missed opportunity to save lives. We must ensure that prevention measures are enacted and enforced across all industries with active engagement from workers and labor unions. The scientific evidence is clear. Earlier intervention, stronger illness prevention strategies, and comprehensive workplace protections will save lives and reduce health risks of extreme heat. The Alliance of Nurses for Healthy Environments supports OSHA in creating these safer workplaces and urges the implementation of evidence-based heat safety standards. We thank your office for the work done so far and strongly encourage finalizing and implementing this standard. Protecting America's workforce is both a public health imperative and a moral responsibility. Thank you.
Hi, everyone. I will wrap it up quickly. I am Dr. Daniel Smith, and I serve as the board chair for the Alliance. I'm also a nurse practitioner with a PhD in environmental and occupational health nursing, and I practice clinically providing care for workers, those such as farm workers, construction workers, and restaurant workers who are regularly exposed to extreme heat. Over the years, I've treated patients with heat exhaustion, syncope, rhabdomyolysis, and irreversible kidney damage from heat stroke. One patient that comes to mind is a 32-year-old roofer who collapsed after hours of work when the heat index soared over 95 degrees Fahrenheit. Despite ICU care, this man now lives with permanent renal impairment, which strains both his family and our healthcare system through the cost and time burden of dialysis. In another case, a young farm worker tried to keep working through dizziness because breaks weren't paid and ended up hospitalized for severe dehydration and muscle breakdown. Thankfully, he recovered, but is still at risk for long-term cardiac and renal impairments. In my research, I have published peer-reviewed studies that have documented over 50% of surveyed agricultural workers in Southeast Georgia reporting symptoms of heat strain, with most having limited knowledge of first aid for heat-related illness. Our findings, based on community-engaged methods, highlight how lack of training, power imbalances, and structural barriers increase workers' risk for extreme heat. With this, I strongly encourage OSHA to adopt a rule that would trigger protections at 80 degrees Fahrenheit with enhanced safeguards above 90, require access to water rest shade, implement hourly paid rest breaks and acclimatization protocols, and train both workers and supervisors on recognizing heat-related illness. Thank you so much for prioritizing worker health and safety. We will now take any questions.
Thank you. Questions from OSHA, Mr. Levinson.
Yes, Your Honor. Zoe Petropoulos will be asking the first questions for OSHA.
Hi, and this is Zoe Petropoulos with the Directorate of Standards and Guidance. I'm not sure if you all were able to hear my questions for Dr. Harrison, but I have some similar ones for you all. In your experiences as healthcare professionals, are you aware of workers not reporting heat-related injuries and illnesses that they experienced to their employer?
I will take this. In my clinical practice, this happens all the time. Workers are afraid of retaliation. They're afraid of losing work if they report having heat-related illness. And so it continues to go as something that workers are experiencing daily at work, but not reporting to both their employers nor healthcare providers, leading to the underreporting of heat-related illness in our data.
Thank you. And another topic that we touched on in previous witnesses that I'm curious your thoughts on. Are you aware of issues with the coding of heat-related injuries and illnesses among workers in administrative and surveillance databases, either not being coded as work-related or not being coded as heat-related? Are you aware of any instances of that?
Yes, that happens all the time. I would say most people are going to present to the ER, and most clinicians are going to code something as the cardiac event that caused the ultimate death or the ultimate reason for seeking care. And then also a lot of, we don't routinely collect occupational data at the clinical level, and so that is often going under reported as well.
Thank you. And those were my only questions, but if you want to share any more evidence or examples or stories in post-hearing comments on these topics, we would welcome that.
Your Honor, the next questions come from Tiffany Defoe.
Hi, this is Tiffany Defoe with the Directorate of Standards and Guidance, OSHA. First off, I just wanted to say thanks for your very clear and comprehensive comments. That's much appreciated. And in the comments that you provided about rest breaks, some of the recommendations you made for the provisions of the proposed standard, you recommended ensuring frequent rest breaks at the initial trigger of 80 degrees Fahrenheit, where the proposed standard provided for as needed rest breaks. And you stated that relying on voluntary breaks places undue responsibility on workers to recognize their risks and advocate for breaks. And you went through a variety of reasons why it can be difficult in your experience for workers to advocate for those breaks. Now, recognizing both your recommendation that the mandatory breaks be extended to 80 degrees and OSHA's intention in the proposal that employees should be able to use as needed rest breaks regardless of whether they're working in conditions that also require mandatory breaks. I'd like to ask if you would give your thoughts now or in post-hearing comments on what kind of strategies could be included in a final rule, or what kinds of information could be provided in guidance developed to explain and support the rules requirements that could help to address the issues that you've identified with workers being able to use voluntary as needed breaks.
Thank you for that question. We're happy to provide additional information and post-hearing comments.
Thanks so much. And I also want to note that throughout this hearing, we've received a variety of comments and concern that the mandatory scheduled breaks proposed in the proposed rule may not be feasible or safe in all work processes and all jobs. And the recommendations that we've gotten related to those concerns are generally either that OSHA should remove the mandatory scheduled rest breaks from any final standard, or should add some form of flexibility to those requirements for mandatory scheduled breaks in terms of how they're scheduled and implemented. And so I'd like to ask if your organization could provide your thoughts on these recommendations, either now or in post-hearing.
Yeah, so I can take this. We've done some work in Nicaragua that has worked with a sugarcane mill in order to schedule rest breaks every hour. And it's been quite interesting kind of learning from them that we gave them the mandate that these rest breaks need to happen, and then we gave the flexibility of how you want to implement them every hour is up to you. And I think finding that balance is something that I would like to see in the final regulation, of not just getting rid of the mandatory rest breaks, but recognizing that they're there and that the implementation of them can be industry specific, because you're correct. Depending on the industry at hand, how a rest break is implemented, and particularly in water, rest, shade, right? Whenever you're doing a thorough rest break, it's going to look very different in the restaurant industry than in the agricultural industry.
Thank you for that. If it's possible, when you are providing your post-hearing comments, to provide some of the documentation of the work that you did, and also any further detail that you can supply about, you summarized it right now as we recommend, I think I understood you to be saying we recommend hourly rest breaks, but how you actually implement this recommendation is up to you. If you could expand upon that answer and just to make sure that I'm understanding correctly what you're recommending should be, how that would look in an OSHA federal standard.
For sure, we can do that in the post-hearing comments.
Great, thank you. That's all I have.
Your Honor, the last questions from OSHA come from Rachel Karse.
Hi, this is Rachel Karse from OSHA DSG. I'm going to ask about your recommendation that workplaces are exempt, the workplaces that are exempt because the indoor temperature rarely exceeds 80 degrees should be required to maintain their systems regularly and are subject to time limits of temperatures that exceed the threshold. So we were interested in what your organization would consider a reasonable time limit above the threshold for these types of facilities.
Thanks so much for that question. We will absolutely respond to that in the post-hearing comments.
And along that same subject, are you aware of any employers with policies in place that have a time limit that employees may continue to work if the AC breaks down? And finally, yeah, if you have any data or information that would support the effectiveness of expanding this requirement, we would appreciate that. Thank you.
Absolutely. We'll address those in our comments.
Your Honor, that concludes OSHA's questions.
Thank you. Ms. Wiles, anything from the solicitor's office?
Yes, Your Honor. Linda Wiles from the Solicitor's Office. I heard in your testimony today, I think it was Ms. Sarah Busick, and I apologize if I'm mispronouncing your last name. You had mentioned support for medical screening to aid in providing employees necessary protections, particularly where they may be vulnerable. I wondered if you had suggestions for balancing the need for such information with employee privacy rights.
Absolutely. That obviously, yeah, privacy is of utmost concern, and we can definitely address that in our comments. That's something that is has been discussed. So absolutely.
That's all for me. Thank you, Your Honor. And thank you for your testimony today.
Thank you.
Thank you. Mr. Roberts, do we have any online participants with questions?
No online participants with questions, Your Honor.
Okay, then thank you to all of you, Ms. Busick, Ms. Elia, and Mr. Smith. We appreciate your testimony and your time today. And Mr. Roberts, we can go to our next witness, please.
Okay, our next witness is Mia Horniak from the Physicians of Social Responsibility. So Horniak, please state your name and affiliation.
Hello, my name is Maya Horniak, and I'm testifying on behalf of Physicians for Social Responsibility. Physicians for Social Responsibility, or PSR, is a nonprofit that represents over 22,000 physicians and other health professionals across the country that work to protect human life from the gravest threats to health and survival. PSR submitted written comments during the public comment period for the proposal in question, alongside 86 other health organizations, some of which are also testifying today. Those comments still stand, but to reinforce our desire to see this proposal both strengthened and finalized, I'd like to share the perspective and experiences of our health professional members who are regularly treating patients for heat injuries and illness, especially as climate change continues to raise temperatures across the United States and to cause more frequent extreme heat emergencies. Much of the treatment of heat injuries and illness is done by first responders and healthcare providers in the emergency department. Heat exhaustion and heat stroke are urgent concerns that can sometimes go undetected if workers have not received proper education and training on how to both avoid heat stress and what symptoms to look for in themselves or in their coworkers. A healthy workplace culture where all employees are treated with dignity and feel that they can speak up without fear of retaliation is also necessary in this circumstance. The longer heat exhaustion goes undetected, the more emergent the situation becomes. Ideally, as soon as the symptoms are recognized is when our healthcare workers get involved. Our providers have seen cases of children who spent a summer day outside without drinking enough water, gardeners who was shaded for their few hours of work but still became symptomatic, and construction workers that have been in the sun and heat over a long shift. Every person, whether covered under this proposal or not, deserves to be protected from extreme heat. And of course, these life-threatening cases are on the rise, and so are heat-related deaths, which are currently massively undercounted due to a lack of circumstantial information upon treatment, patient comorbidities, and a flawed reporting system. Our members note that the distribution of heat-related cases are not felt equally. Hospitals in low-income areas are more likely to see these cases due to urban heat island effects and less access to cool spaces, including shade. This contributes to already staggering health inequities that plague the most vulnerable people among us. It's also not lost on health professionals that much of the time and cost burden of workers being exposed to extreme heat is placed on them rather than an individual's employer. According to the Center for American Progress, the economic cost of heat-related healthcare totals $1 billion every summer, and this trend is expected to continue. Many emergency departments are busier than ever, so adding patients suffering from heat injury or illness to this busyness makes for exhausted doctors and nurses, potentially unsafe staffing ratios, and longer waits for patients with emergent issues, including those who have been exposed to heat. Healthcare costs are at an all-time high in the United States as well. So it's worth noting that people seeking treatment for heat-related health concerns are also responsible for both obtaining their own health insurance and then paying whatever may not be covered by their plan out of pocket. This model is unsustainable for all parties involved. Again, PSR urges OSHA to finalize this life-saving proposal for the 36 million Americans working in both indoor and outdoor settings that it would have an impact on. This would be a step in the right direction to protect our communities from climate change-induced natural disasters like extreme heat events. I just want to thank you for your time and attentiveness today and for accommodating everyone who would like to testify over the course of several weeks. I'm happy to take questions at this time, and if there's any questions about the medical aspects mentioned, I can take those back to the health professionals who lended their experiences to this testimony and provide follow-up written responses, since I myself am not a medical professional. Thank you.
Your Honor, OSHA wanted to have all of the people speaking on behalf of chapters of Physicians for Social Responsibility testify, and then we can ask questions of the entire group, if that's acceptable.
That sounds good to me. So, Mr. Roberts, bring up Mr. Gould, it looks like is next.
Yes. Mr. Gould, you should be here. Please state your name and affiliation.
You hear me?
Now we can hear you, yes.
Okay, for some reason I can't get my video on, but I'll just speak this way. Thank you for affording me the time to speak. My name is Dr. Robert Gould. After working as a pathologist at San Jose Kaiser for over 30 years, since 2012, I've been an adjunct assistant professor at UCSF School of Medicine, working with our program on reproductive health and the environment. I've also been a member of the Santa Clara County Medical Association for 30 years, where we have worked to develop many policies for California Medical Association protective of public, environmental, and occupational health. Since 1989, I've also been president of San Francisco Bay Physicians for Social Responsibility, on behalf of whom I'm testifying today, representing many hundreds of health professionals throughout our region. We speak for the health of our patients and communities who are increasingly harmed by rapidly advancing global warming, including the expected increasing occurrence and severity of dangerous heat waves of the sort that at this moment are being experienced by millions throughout our nation. According to a 2024 review article published in the New England Journal of Medicine, Within the United States, recent decades have witnessed an increase in the frequency, duration, and intensity of heat waves, with the annual number of heat waves now being twice that experienced in the 1980s, and with the heat wave season lasting more than 3 times as long as observed in the 1960s. These findings are compatible with global trends reported by the World Health Organization in 2024, which reported that, quote, the number of people exposed to extreme heat is growing exponentially due to climate change in all world regions. According to a research letter published in the Journal of the American Medical Association last year, from 1999 to 2023 in the U.S., over 21,000 deaths were recorded as heat-related, underlying, or contributing to the cause of death, with the number of heat-related deaths increasing from 1,069 in 1999 to 2,325 in 2023, representing a 117% increase in the number of heat-related deaths. Such heat-related deaths have classically been associated with the acute manifestations of heat stress, while the more serious presentation of heat stroke associated with lack of sweating, rapid pulse, vomiting, seizures, and progressive loss of consciousness. In addition to these documented threats to worker health, we also need to be attentive to preventing morbidity and mortality among our indoor and outdoor workforce due to heat-associated exacerbation of their pre-existing conditions, such as cardiovascular disease, respiratory diseases such as asthma and COPD, kidney disease, diabetes, and various mental disorders. In addition, we need to proactively address the specific vulnerabilities of pregnant women to prevent heat-associated adverse birth outcomes exemplified by preterm birth, low birth weight, stillbirth, and congenital heart defects. In recognition of the current and predicted increases in occupational exposure to extreme heat and the documented increasing incidence of heat-related illnesses and deaths, we strongly support OSHA's promulgation of a strong heat injury and illness prevention in outdoor and indoor work settings rule. It is imperative that we establish a fundamental baseline to protect workers in all occupations who are subject to extreme heat conditions, consistent with OSHA's mission to assure America's workers have safe and healthful working conditions free from unlawful retaliation. We need a strong federal standard, particularly given the paucity of state-based standards protecting our workers. As of 2023, only 3 states, California, Oregon, and Washington, required heat breaks for outdoor workers. 2 other states had only partial protections, with Minnesota having a rule setting standards for indoor workers, and with Colorado's heat regulations only covering farm workers. And we need to be able to effectively counter the ability of states to override local ordinances that better protect heat-exposed workers, as evinced by the 2023 Texas law enacted in the middle of a blistering heat wave that nullified ordinances passed by Austin and Dallas that mandated 10-minute rest and water breaks for construction workers every 4 hours. OSHA's current proposed rule takes a more enlightened approach towards protecting our workers than some of these examples, and critically would help protect all workers in the U.S. As such, we reiterate our firm support for the proposed rule. In light of the increasing threat that extreme heat poses to the health of the U.S. workforce, we also recommend OSHA make modifications that would better protect the health of our workers. For example, we at San Francisco Bay PSR recommend lowering the high heat trigger to greater or above 80 degrees from the currently proposed greater or equal to 90 degrees in recognition that heat-related illness can manifest at this lower temperature. Finally, we would encourage OSHA to require all employers to develop and enact in written form, quote, heat, illness, and injury prevention plans, unquote, and suggest that OSHA should provide assistance to small businesses that may lack the resources to draft their own job site-specific plans. Thank you for the opportunity to testify today on this issue so fundamental to public health and so basic to protecting the most vulnerable among us who continue to serve all of us in increasing challenging conditions. Thank you.
Thank you. Mr. Roberts, let's move on to, it looks like Ms. Ringenberg.
Yes, the next speaker will be Lynn Ringenberg, Florida Chapter Physicians of Social Responsibility. Ms. Ringenberg, please state your name and affiliation.
Ms. Ringenberg, if you're there, you are on mute and we are not hearing you.
I am here.
Okay.
Can you hear me now?
Yep.
But I can't see me now. Can you see me?
I can, yeah.
Oh, you can? Okay. Well, there I am. Well, good afternoon, everybody from hot, humid Tampa, Florida. And I am Dr. Lynn Ringenberg. I'm a professor emeritus at the University of South Florida, Morsani College of Medicine. I'm also a retired colonel, United States Army, and past president of Physicians for Social Responsibility in Washington, and also the local chapter here in Florida. And I'm speaking on behalf of myself and also PSR Florida board and members. And Your Honor and OSHA staff, I thank you so much for inviting me to this hearing today. And I mean, you guys have an awesome responsibility, and it's not every day in life that you get an opportunity to save lives. And I thank you for what you're doing through this rule. And we could go ahead and put that first slide up just to give you a little thought on Florida's temperatures here that NOAA has put together. Now, it's hard to see some of those little numbers, but that slide goes back to 1895. I wasn't quite here then, but I am getting older, and I landed here as a kid in the late 40s and early 50s as a kid. So, and I have practiced pediatric medicine in Florida for close to 50 years now, 25 of those years in an academic position at the University of South Florida. I've had a parallel career, as I mentioned, in the military, in the Army, for 26 years. And I can tell you that caring for soldiers and caring for the health and well-being of infants and children has been the honor and privilege of my life. When I commanded field hospitals and combat support hospitals, we had a motto that said safety first, training always. And, we didn't have high tech back then. I'm talking the 90s, so early 90s. And so we just talked to the soldiers about, they all had buddies when they went out in the field. They all learned to look at their urine and know that it should be light. And if it isn't, they're not hydrated enough. And we tasked our leaders with making sure that our soldiers stayed safe. And it worked. We never had a heat-related injury that I know of at that time. And I know a recent report in 2023 shows that they've had over 700 heat-related injuries in the military. So the world is getting hotter, and we're much more sophisticated about these things now. But as I was practicing my parallel career of pediatrics at the same time, it started to really alarm me that I was seeing so many children with worsening health conditions. They didn't come in anymore just for a well child or well baby.
Just one moment,
Yes.
Dr. Ringenberg. Yes. Was it just me that lost connectivity there? Or if so, we can just carry on as long as the court reporter got all the testimony.
Is that to me?
No.
Does somebody have a dog in the background?
Yeah, I'll remind everybody to please mute yourself if you are not actively testifying or asking questions. But Miss Allen, if you think you got everything, then we'll just go forward.
And if you missed something, I'm happy to fill it in.
Yeah,
however I might.
Or let us know where it dropped off.
Okay. And just to also, my partner that was going to talk today, while I think about it, Dr. Todd Sack, I'm not sure he's going to be on because he is in Africa, Tanzania, I believe, working in a hospital. And so he may not join me from there today.
Your Honor, this is Andy Levinson from OSHA. Dr. Ringenberg did not drop out on my end. I think it may just have been for you.
It might just be me. Okay, yeah. All right, let's go ahead and carry on, Dr. Ringenberg. I apologize for the interruption.
No problem. Great, thanks. I think where I sort of was that, I was seeing more and more kids with more illnesses like, chronic asthma, chronic allergies, soft neurologic signs, developmental delays, some severe, some mild, soft signs, some behavioral issues, hearing loss, visual issues. So I was just seeing a lot of more kids that never really came in for a truly healthy kid physical. They always had chronic conditions. And that led me to looking into environmental causes, the air, the water, the heat, and that led me to Physicians for Social Responsibility, which I co-founded in Florida in 2008. And again, as Maya said, you know, this is an opportunity to save so many lives. And from both saving them from dying, but saving them from injury and severe chronic conditions that will be with them for the rest of their lives. But the one thing I want to focus on a little bit more today that I haven't heard much about, and that I have spent a lot of my life doing, and if we could have slide 2, is there's many more lives, and I'm sorry, this just didn't really show up as well as I would have liked it to, but that's probably my lack of talent at putting slides together. Every year in this country, we have about 3.5 million live births, give or take. In 1923, or 2023, it was 3,590,000, but it goes up and down a bit. And these are the many more lives that will be protected when one considers the number of workers. I couldn't see any statistics on that, but it might be available. Workers who are in various stages of pregnancy. And most women know that you really don't know you're pregnant in the 3rd, 4th, 5th week, maybe. And that's the most vulnerable period of a human being's life, I think. And these workers are not just in the fields, but they're in the hot kitchens, the hot laundries, they're in construction jobs, they're in their hot homes. They're perhaps not educated on these issues. Perhaps they're not seeing a healthcare provider yet for whatever reason, and we could go into that for a long time. But this really, this is the most complex process, and I think marvelous thing that we have probably in life. When you take millions and millions and billions and trillions of cells, neurons, connections, enzymes, genetic material, DNA, and you start over here with this little ball of collection of cells, and then you go through the process of embryo, fetus, infant, baby, newborn, there are all types of things that can affect those cells, enzymes, connections. And the most critical ones are happening here in these solid bars. You have your spinal cord developing, you have your brain developing, you have your heart developing, you have your little eyeballs developing. And any little thing, i.e. heat, mercury, lead, et cetera, can affect those developing embryos and cause perhaps major defects. And you know, the thing about it is this little human, these little humans, they have no voice, absolutely no voice. They have no cell phone connection. They have no way to communicate their distress to somebody. They can't say, Mom, I got an issue. They have absolutely no voice. And that's why it's important that we be their voice. And I feel I'm so passionate about this because I feel I've really tried to do that for 50 years. Now, I'm not an obstetrician. I have friends, many friends that are much smarter than me about this process. But I know a lot about little babies and this process that they go through and the things that we're seeing on the other end when they come out and have issues that follow them for most of their lives. If you all can just imagine being someplace, no communication, no cell phone, no social media, no nothing for 9 months. And we know that these babies, that when they're exposed, there's a fair amount of good science on when they're exposed to extreme heat, causes complications in pregnant women. Pregnant women tend to have a higher core temperature anyway, so they're already at risk, as are certain people that are on medications that I think Dr. Gould and Bob, a friend of mine, hi Bob, talked about. But when the woman is working in these heated conditions, she has a high risk for dehydration. It reduces blood flow to the uterus, and it leads to premature labor, delivery. Premature babies are not as healthy. It can lead to reduced blood flow in the placenta, and that can lead to fetal malnutrition. It can lead to low birth weight infants. Low birth weight infants, those that are under about 5 pounds, 8 ounces, they're not as healthy babies. And then, of course, sadly, it can lead to stillbirths. And so all of these infants then are exposed to more adverse medical outcomes that are going to last them and their families often a lifetime if they live. And that's where OSHA, you play a big part. Infants are especially vulnerable to the effects of heat in the first week of life. There's a recent study that found infant mortality increases by 25% on
Is
Your
it just
Honor,
me this time?
this time it's not just you.
Okay.
It is not you.
Dr. Ringenberger, we lost you there for a minute. We can't hear you anymore. Did you accidentally go on mute or? I don't know if you can hear me, but no, we cannot hear you. It looks to me like you are on mute. I don't know. Mr. Roberts, do you have the ability to
I can
unmute?
unmute Dr. Ringenberg, but I don't believe that is the issue. I think
Okay.
the microphone of Dr. Ringenberg. Oh, there we go. Maybe that is the issue.
Can you hear me now?
We can hear you now, yes.
Okay, thanks. I'm not sure what happened, but so let's see, where was I? That infants and children, they suffer disproportionately, because they have different, they don't have the same heat stressors, reactions to heat as adults do. Infants are not miniature adults. I can't stress that enough. They're not miniature adults. They have their own their physiologic, and their cognitive immaturity and their cognitive development, and physical and physiologic. And so there are so many things that are different about infants that you can't say the same for adults. And there's a lot of really, really good research going on about women in pregnancy and this complex process of embryo to fetus to baby to child. A third of our country now, I guess over 130 million or so people are under heat advisories, and this would be an absolutely perfect time to hopefully do some research on heat and pregnancy and how the developing embryo and fetus does. So we can go to the next slide. I think this was an interesting study. About 1% of births in the United States, about 1%, have congenital heart disease. And this particular study looked at projected changes in maternal heat exposure during early pregnancy. And again, that early pregnancy, when the heart is really developing, is like at week 3, 4, 5. Early in pregnancy is when this damage would take place. And so this is going to place a larger burden on communities, families, the babies, obviously, that will be born with congenital heart defects. And I think as hopefully as time goes on, I'm not a researcher scientist in that sense, but hopefully we'll be able to have more projections like this and be able to educate people, in this particular case, mothers, on various risks to heat and heat exposure and exposure to other things that affects their baby. So slide 4, and I'll just kind of hurry through these. I think, there's already so much good data out there. We've been using these CDC charts. We've been going out to schools, high schools, talking about heat exposure, heat exhaustion, heat stress, heat stroke, things to do all over our county here in Central Florida and Hillsborough County and Pinellas County, and talking to coaches and trainers. And the OSHA has, just some tremendous material already. So, there's a lot of things out there that I think people might not even be aware of. And if I could have the next slide. And then, Florida recently passed the Florida Zach Martin Act, and that was in 2020. Honestly, not many people even know about that I've talked to, at least, and maybe more in the schools that I haven't talked with. But this young man died of heat stroke, and because of his death and his parents' action and leadership, I think that safety for athletes, especially football players or folks that have a lot of gear on, hot weather, is much, much better and safer in Florida now. Of course, there's the Pregnant Workers Fairness Act. I don't know how many people are aware of that, honestly. And then we have My Green Doctor that my colleague, Todd Sack, has been involved with for many years. And My Green Doctor, and if we go to the next slide and the last slide, My Green Doctor it's a comprehensive environmental sustainability practice management program, and it's mainly for health professionals, for hospitals, clinics, could be for dentists, could be for others. I think that this could be widely adapted for a lot of people, a lot of businesses, but it gives mainly information and ways that you can make your practice, your patient safer, green your practice. It's all science-based. It's not political motivated. It's mainly for outpatient clinics, and will save money. And if I can, I'll stop now. And if I could just go back to slide 2 for 1 second, while I say that as a healthcare provider for many, many years, that one there, as physicians and healthcare providers, we know we can't change the weather, but we can hopefully guide and change the behavior of our patients to keep them safe during these challenging times. And I would hope that OSHA and all the people working with you will keep this little row of human beings in your mind as you're going through your thought process on this important proposal. And it's been a privilege to be the voice of these little human beings, and I hope that you will keep it in the front of your mind when you're doing your work. And I want to thank you again today. It's been a real pleasure, and thank you so much for what you're doing. It's very meaningful in life. Meaningful. Thank you.
Thank you. All right. I gather Mr. Sack is not with us, correct, Mr. Roberts?
I do not see him in the list. Okay. I will just say if he is in the attendees list, if he maybe wants to make himself known, he's in an alternative name, but it does sound like from what Dr. Ringenberg said that he might be otherwise engaged.
Right. And I'm not sure what time it is in Tanzania. I think that's where he is. Thanks.
Where am I? Okay. Mr. Levinson, I think there's one more witness from a Physicians for Social Responsibility group. Should we?
Yes, Your Honor, there is.
Okay.
So the final speaker is a Chris Covert Bowles. He also does not appear to be in the list, but again, I will say if Mr. Covert Bowles is with us under an alternative alias, then please, alternative name, please make yourself known. That does not look like he is here.
Okay. Mr. Levinson, do you want to do questions now? Do you want to take a 10-minute break now? We've been going for a while. It's up to you. I'm good either way. You're on mute.
Sorry. Your Honor, we're close to the end of the day. If we could just wrap things up so that we don't go long.
Sure.
That would be fine with us.
Okay.
Andrew Levinson for OSHA. Thank you all from Physicians for Responsibility, both the national organization and the chapters, for your testimony. My first question, and I guess before I get going, we're happy to hear anything that you all have to say right now. We also have a post-hearing written comment period. You may also want to save responses for then or expand upon your thoughts in the post-hearing comment period. The first question that I have for the group relates to a statement that we've had many stakeholders talk about their belief that OSHA's standard is a one-size-fits-all approach, particularly as it relates to the triggers for interventions and our use of the heat index. They've requested that we have more flexibility and allow people in different regions of the country to assess temperature and humidity in their locality rather than relying upon one national trigger for heat index that it accounts for, again, both temperature and humidity. We're curious if you're aware of any medical literature that would support such a contention, or any evidence that the body handles heat differently in different regions. And related to that, we've got a provision requiring acclimatization. Is that enough to account for regional differences in temperature? And we'd love your thoughts on that either now or in post-hearing comments.
Happy to jump in here. We do have some studies that we can provide in post-hearing comments regarding heat triggers. I think our stance is that heat index is being used properly here, since it does account for humidity, even if it is viewed as a one-size-fits-all approach. In our previously written comments alongside the other health organizations that I mentioned earlier, we actually, along with Alliance of Nurses for Healthy Environments that spoke earlier, we recommend a trigger of 80 degrees as well. We do have a couple studies that I can send along. I believe the most recent is from 2018 that showed that workers were impacted and some heat deaths occurred even below 90 degrees because potentially of the humidity. So we think that this is worth reconsidering having it be 80 degrees rather than the 90 degrees that's currently proposed.
Well, if I can just add one thing, I think I'm not sure how to do it, and
sorry,
this is, I'm sorry, this is Dr. Ringenberg. Can you hear me okay?
Yep,
Sorry.
no, I just wanted you to identify yourself for the record.
Sorry. I think somehow we have to figure out a way to marry HIPAA and HIPAA compliance and privacy with you know, a worker's right for rest. And I mean, because there's no doubt about it. I mean, there are so many issues with medications and, well, pregnancy, I just mentioned, that's a limited number of workers. And I don't know how many women, honestly, are in the fields, but imagine there is data on that. And how many are pregnant. And so I think that there has to be some way to marry up HIPAA and the laws to keep everybody safe, because it does make a difference. It definitely makes a difference in health and safety.
You're muted, Mr. Levinson.
Thank you. My next question relates to the issue of signs and symptoms. One of the things that OSHA's proposed regulation requires is a buddy system for workers to identify signs and symptoms of heat illness in coworkers. Some of our stakeholders have said that that's not possible because workers are not medical professionals. In your experience, is it possible as medical professionals for non-medical professionals to be taught the signs and symptoms of heat illness, and how effective is that in terms of training people to identify signs and symptoms?
I don't know if Bob is still on, Dr. Gould. He's probably had more experience than me, but I'm sorry, it's Dr. Ringberg again in Tampa. And I mean, I think it's poor, you know, from my military experience, having a buddy system is very important. Having a buddy system, having the knowledge, and we have so much more knowledge than we did back in the 90s. And I think most people, I think, read their bodies pretty good. Most people know their bodies pretty good. Now, I agree with someone mentioned before, but they're going to plow through because they want to make the money. They want to, you know, et cetera, et cetera. But I think when you have a buddy there kind of hearing what's going on, yes, I'm feeling a little dizzy. I kind of have a headache. You know, I kind of stopped sweating. I mean, these little symptoms that are going to lead to, well, a heat stroke, most likely at some point, especially if you stop sweating. So, I mean, I think having a buddy there knowledgeable, and, you know, some of this doesn't have to be high tech. It can be an app that has the stuff on it. You know, we have so many things now. Our watches tell us when it's too loud or too hot or too whatevers. And so I think technology is there to help guide this. So personally, I don't know, Mia, you may have other thoughts, and we can certainly take it back to all of our many physicians.
Maya Horniak for the record. Yeah, speaking on behalf of our health professionals, I don't think that you need to be a medical professional in order to see that somebody is experiencing heat stress, especially when workers are given the proper training and information, and know the signs and symptoms to look for, which is should be a requirement for we believe all employers, including small businesses. This just makes the most sense because there are some pretty clear signs and symptoms that if you stop sweating, if you become pale, if your breathing and pulse are irregular, these are things that they can recognize in one another, especially if they are buddied up often and know how they would typically be acting. I think this is a cost-effective way for employees to work with one another and be able to recognize it, because of course you're not going to be able to have a health professional, a first responder on every single work site or in every single restaurant or any of the other covered areas in order to diagnose.
Thank you. Your Honor, the next questions for the witnesses come from Zoe Petropoulos.
Hey, this is Zoe Petropoulos with the Directorate of Standards and Guidance. If you were on earlier in the session, you've probably already heard similar questions like the ones I'm about to ask, but I'm interested in the experiences of your members in these topics. So in your experiences as healthcare professionals, are you aware of workers not reporting heat-related injuries and illnesses they experience to their employers?
This is Lynn, yes.
And Maya, I have also heard that from our members, that this is, they won't always say where they experience the heat stress, and then it doesn't get marked properly or reported as it should be, which is why I think the numbers are much lower than what they actually are for people that experience heat stress, heat stroke, or heat-related deaths.
Thanks. And a related question, but you kind of touched on that. If your membership is aware of any data or they have anecdotes among themselves of cases of heat-related injuries and illnesses among workers that are treated in a healthcare setting but never get coded as such in databases, so they don't get coded as work-related or they don't get coded as heat-related, we're interested in your membership's experience on that.
Yeah, I'm happy to follow up in post-hearing comments on that with some anecdotes from our doctors and nurses. This is of course, something that happens relatively often. I believe Alliance of Nurses for Healthy Environments also had some anecdotes earlier, because a lot of health professionals are in a rush when they're treating and are just trying to help a patient, and the booking comes second to that, of course.
And that was it for my questions, Andy.
Thank you. The next question comes from Tiffany Defoe.
Hi, this is Tiffany Defoe with the Director of Standards and Guidance, OSHA. Now, if you've been here throughout the afternoon panel, you may have heard me ask a version of this before about California's provision for as-needed rest breaks, which states that employees shall be allowed and encouraged to take a preventative cool-down rest in the shade when they feel the need to do so to protect themselves from overheating. And the way that OSHA's proposed as-needed rest break requirement was phrased is somewhat similar to that. I wanted to ask, from a medical standpoint, if you have any thoughts to offer on whether it is important to, as California's rule does, require employers to provide as-needed rest breaks to employees who feel they need them to prevent an incidence of overheating, as contrasted, for example, with perhaps a requirement that only kicks in if they are actually experiencing early signs and symptoms of heat illness.
Well, I mean, this is Lynn in Tampa. I'll comment, and Mia, you probably maybe have more information on it, but I think, you know, again, most people understand their bodies, and from my experience here, I've done a lot of work with the farm workers. I had a mobile medical van that we used to go out and care for the underserved and uninsured and underinsured kids mainly in the agricultural areas south of Tampa. And, you know, most of these folks, I mean, they really want to work. They want to make a living. A lot of them are single moms or single, you know, and they're providing for kids and families. And so I don't think they'll neglect it. I mean, I don't know that it's been studied, but I think that if they feel the need, because again, we don't know if they're on, you know, a mental health illness, mental health medication, a medicine for hypertension. They're not thermal regulating right. That happens during pregnancy. It happens during different things. And so, you know, if they feel that need, I mean, to me, there needs to be some flexibility, some common sense, which unfortunately I don't see a lot of today, it seems, but there should be some common sense in life. But anyway, but we can survey our docs and get more information for you.
Thank you. That's my only question.
And Your Honor, the last question from OSHA comes from Rachel Karst.
Hi, I just wanted to follow up a little bit on the buddy system and using that as a cost-effective way to monitor employees for signs and symptoms. If you have any information on how much observation is required by the employees, like what time does this take? Is this something that's already being done somewhat through general interactions as they work? Or is this going to require extra time to stop and say, hey, how are you feeling? And how much time do you think that would be appropriate to estimate for that type of interaction? Any thoughts on that? Just trying to gauge how long the buddies are interacting and not working and what the cost associated with that is.
This is Maya Horniak again for the record. I think that it would be relatively minimal. I'm not positive that this is something that's happening yet, based on the state policies that have already been implemented. I'm happy to look into it or to speak with our doctors and nurses about it, how long they think something like that would take, even if it's just outlined survey questions to ask one another, if that would be 5 minutes or if it could take longer, depending on if they're already experiencing symptoms.
Okay, thanks.
Your Honor, I just wanted to, but before OSHA concludes its questioning, it appeared Ms. Horniak might have wanted to respond to Ms. Defoe's question earlier, and I may have cut her off. I wanted to just see if that was the case.
That's totally fine. I think Dr. Ringenberg got everything that I was going to say.
Okay, then, Your Honor, that concludes OSHA's questions.
Thank you. Ms. Wiles, anything from the solicitor's office?
Yes, Your Honor. This is Linda Wiles from the Solicitor's Office. I just wanted to mark as exhibit number 13, the Florida Chapter Physicians for Social Responsibility PowerPoint that Dr. Ringenberg presented, and enter that into the record.
Thank you.
Thank you.
I assume there are no objections. So that PowerPoint is admitted as exhibit 13. Is that what you said, 13?
Yes, Your Honor.
Thank you.
And I have no questions. And I thank all the folks from Physicians for Social Responsibility for their time and testimony today.
Thank you. Mr. Roberts, are there any questions from the other online participants?
There are no questions from the online attendees, Your Honor.
Okay, Ms. Horniak and Dr. Ringenberg and Dr. Gould, if you're still there, thank you very much for your time and for sharing your testimony with us today. It's helpful.
Thank you. Thank you. Be well. Thanks.
All right, I think we have one more witness.
The last witness today is Laurie Byron from Montana Health Professionals for a Healthy Climate. Ms. Byron, please state your name and affiliation.
Thanks. Can you hear me?
Yes.
Okay, great. I'm Dr. Laurie Byron. I'm a pediatrician and the head of the Montana Health Professionals for a Healthy Climate. I also I also have a master's degree in energy policy. I spent my career in Indian Health Service, so I did a lot of public health, and I also volunteered in migrant clinics. So I have a little larger scope than a lot of people that just did general pediatrics. So thank you for this opportunity to testify and for all of your work to look at the science and the practicality in this rulemaking. I will say that you all on this panel have listened and considered testimony far more thoughtfully than any hearing I have ever attended, and especially after surviving 2 weeks of testimony. I feel like this proposed rule has been super long in coming and is desperately needed in a warming world. So I've knocked out everything from my testimony that was already said, so it's going to be really short. I would like to say that just setting these standards and drawing attention to the issue is going to save lives. So thank you for what you're doing. I can attest to the underreporting on death certificates in the emergency room and in the hospital. As other people have noted, the doctors are super busy, and they rarely note that a death or an illness was caused or worsened by certain problems, like by heat. There are T codes for the effects of heat. I don't think I've ever seen them used by another ER doc. And the modifying codes and the risk factors are also not well documented, both for the diagnosis in the ER and the hospital and on death certificates. The High School Sports Association has really strong standards on the issues with heat in young athletes, and they require acclimatization now. And these standards are required across the United States. And I care for kids, so that really makes me happy because I think it's saving lives. But you know, my kids grow up, and I still care about them even when they become an adult. So I think this rulemaking to look at workers and heat standards is really important. You all have heard that kidney damage and disease really hurts our farm workers, and it just seems like decreased water and increased heat seems to be causative, that our kidneys get damaged by prolonged exposure to heat with poor hydration. There's another group that I don't think has been mentioned today, and that is that people with pre-existing illnesses and they're still able to work. They don't want to be disabled, and they are a lot more vulnerable also. And then we have the issue with medicines. And so we have a number of prescription drugs that make the patient more vulnerable to the negative effects of heat. So a class of drugs called ACE inhibitors, which treat blood pressure. They're very, very common, and a lot of people have high blood pressure. These people become more vulnerable. And then psychotropic drugs, a lot of them affect our ability to tolerate heat and to recognize problems with heat. And at least 1 out of 5 adults suffer from depression or anxiety. And that's just 2 groups of people requiring psychotropic medications, according to the CDC. And then anticholinergics are the 3rd class that really affect our ability to tolerate heat. And people with asthma, people with nausea and vomiting problems use them. So they're pretty common too. Dr. Ringenberg covered the pregnant moms and their babies in the oven, no pun intended, fantastically, so I won't talk about them. So I would just like to recommend today that we, that you all consider changing the rules which are already created, which are great, but looking at the heat signs and symptoms should start at the heat index over 80, which a number of people have noted, and then requiring that all employees, not just large employers, have heat plans regardless of their size, and that they're translated into other languages as appropriate. That's all I have to say. Thank you.
Thank you. Any questions from OSHA?
Yes, Your Honor. Dr. Byron, thank you very much for your testimony. We're happy to have comments either now and or in a post-hearing written comment period if you'd like to expand upon any of your thoughts. I want to repeat a question that I asked some other medical professionals earlier this afternoon. We've had a number of stakeholders assert that OSHA's approach is one size fits all, and that the heat index triggers that OSHA has proposed may not be appropriate in every region, and that there's regional variability. And we're looking for any body of literature that you might be aware of about, does the human body respond differently to heat in different regions, or are the heat triggers appropriate in all parts of the country? And again, the heat indexing accounts for both temperature and humidity. Any thoughts you may have are welcome.
Yeah. Well, you all are probably more expert in this than I am, so I'll defer back to you somewhat, but there are definitely regional differences. I mean, people in Montana are not as used to heat as people in Florida are. So we're actually probably more sensitive. And after being an author on the Climate Change and Human Health Report in Montana, this is one of the things that we looked at. But I still think having a national standard and having something to start out with is needed.
So do you think a period of acclimatization during heat waves or at the beginning of heat season is enough, or should the triggers be different?
I think having a national standard is just far better than any other way of piecemealing this.
Thank you. The next question relates to signs and symptoms. And one of the things that OSHA has talked about is a buddy system where workers would be taught signs and symptoms to watch out for in coworkers, and people have asserted that other workers are not medical professionals and that they couldn't accurately assess the signs and symptoms of heat-related illness. Do you have any thoughts on whether or not people could be trained, non-medical professionals could be trained to recognize the signs and symptoms?
I think they can be trained somewhat. I'm not sure what, I mean, buddies are great. When I hike, I don't want to be attacked by a grizzly bear and be out there alone. So it's nice to have a buddy, but buddies don't always recognize everything. And, especially with these people that are on medicines that affect their own ability to regulate heat and to know that they're getting in trouble. I think, for people like that, or for people with other medical problems, their buddy is not necessarily going to pick up everything. So I'm not sure what they would replace. I think it's a good suggestion, but.
Thank you. Your Honor, the next question comes from Zoe Petropoulos.
Hi, this is Zoe Petropoulos with the Directorate of Standards and Guidance. So I heard you mention underreporting of heat as a cause of death on death certificates in your testimony. And I'm just wondering if you or your membership have any additional data, research, or anecdotes on that topic. We would welcome those in post-hearing comments or now. And we're also interested more generally on your membership's experience on coding of heat-related causes on medical forms and also work-related boxes that are checked or other indications of work-relatedness. We're interested in anything your membership can share on that topic.
Thank you.
And then I'll also just say you mentioned your own personal experience working, I believe, correct me if I'm wrong, in a clinic with migrant workers. If you have any experiences or anecdotes about the reporting of heat-related symptoms and heat-related illnesses among those workers, we would welcome that now or in post-hearing comments.
Yes, and again, like everybody else that I think has been asked that question, you definitely see people's reticence to complain or to say they're having a problem or to ask for rest when it's not something that's standardly given.
Thank you so much, and that's it for me.
Your Honor, that concludes the questions from OSHA.
Thank you. Anything from the solicitor's office?
Yes, Your Honor. This is Linda Wiles from the Solicitor's Office. I did have just one question for Dr. Byron. Thank you for being here today and for your testimony. You mentioned the potential side effects of some prescription drugs, which could aggravate heat stress symptoms for folks that are taking those medicines. And I'm not sure if you heard earlier today from the Alliance of Nurses for Healthy Environments, one of their recommendations was medical screening to aid in providing employees necessary protections where these employees are more vulnerable to heat stress. I wondered if you had thoughts about whether medical screening should be utilized, and if so, do you have suggestions for balancing the need for such information with employee privacy rights?
I don't have opinions on the privacy rights. I do think that that a medical screening is great, but I sort of think it's like the buddy. It's not going to capture everything, and a lot of people aren't going to tell the truth because they don't want to lose their job or not get a job by talking about their medical problems.
Thank you so much. That's all for me, Your Honor.
Thank you. Mr. Roberts, any other online participants with questions?
Your Honor, there are no online participants with questions.
Okay, then Dr. Byron, I just want to say thank you very much for your testimony today. We appreciate your time.
Thank you.
Before I close things down, Mr. Levinson, is there anything else from OSHA?
No, Your Honor. Thank you very much for today. Nothing further from OSHA.
Anything from the solicitor's office?
I just wanted to make sure that the individual from PSR that we missed isn't on the line. If we could just do one last call to see.
Are you referring to Mr.
Mr. Covert Bowles?
Covert Bowles, yes. Mr. Covert Bowles, if you're here, if you could make yourself known. Raise your hand.
Seems like he's not here.
Yeah, I do not see anything.
Okay, that's all for me, Your Honor.
Thank you for checking. All right, we are now at the end of all scheduled witnesses for today. I would like to remind the hearing participants that they may submit additional evidence or statements relevant to the proceeding within 90 days of the end of the hearing, which will be September 30th, 2025. At that point, the record for this rulemaking will close. On behalf of the Department of Labor, I want to publicly thank all those people who gave their time and testimony to contribute to this hearing today. And to all participants, thank you for your interest in this important matter. The hearing is hereby adjourned for today. It will be reconvened at 9:30 a.m. on Monday. Thank you, everyone. Okay, I think we're good.